That's but from 2021 it's been changing, but
bench to be made, আমি বলেছিলাম mentioning কিন্তু online mentioning তো আমি নিচ্ছি না। Yes, not right now. Yes.
Issued a letter of intent in favor of the petition by the end of 31st of
You please wait behind the others. Just wait for the other matters. Just see the urgencies I am refusing. Then come and mention. You remain. I'll take up your mentioning again after all the other mentionings are over. Please stay back. I'm very honest. Stay back if you are convinced. Yes, then I'll take it. Yeah. It's appearing in the list. Not under the upgraded heading. It upgraded. Give please paper. Give them up. Yes.
I have a lordship sleep.
তোমার বাড়ি কানেকশন বারণ করছো কেন করছো? অটোমেটিক হয়ে যাচ্ছে, তুমি বন্ধ করতে পারছো না। এরপর তো আরো অনেক কিছু তুমি পারবে না, অটোমেটিক হয়ে যাবে। Yes, please use the mic.
Yes, my lord, this is my lord in respect of the registration of fraud, my lord, the stamp paper. Your lordship knows it. That
you want to pay the money, take back the
yes.
Hand over. Yes.
And another, my lord, the contempt matter.
Contempt, wait for this. Yes. Yes, Mr. Haldar.
Item number 4. Please lordship. Petitioner has properties, one in the front side and one in the back side, lordship. The back side property has been
Purchase the property in the middle also, Mr. Haldar, don't mention.
Lordship, 2 assessment has been made. Back side is 3 crore, lordship, 3 crore rupees, and front side has been 1 crore. Challenging the said, petitioner has moved before Justice Bhattacharya. Order passed for reconsideration, did not reconsider, and passed the same order, lordship. We have challenged the same order.
Yes.
My lord, new electricity connection, my lord. They came to install, left without installing.
Hand over. Upgraded. Yes.
This is under the heading upgraded matter, new electricity connection. But the petitioner has undergone a bypass surgery of art. CSC wants to give connection, but my lord, the landlord is opposing.
What is the item number?
My lord, 61 today.
When did he undergo the bypass surgery?
My lord, in the month of December, she again has to be hospitalized at present.
Hand over. এটা টপে দিয়ে দেবেন, আপগ্রেডের মধ্যে টপে দিয়ে দেবেন। Yes.
Not death certificate from the corporation. Since
please hand over. Yes.
in spite of paying the quotation fees, I'm not getting the connection.
And you want an upgradation? It is in the upgraded list.
35 of today's.
Is it in the upgraded list?
No.
Then yes, hand over. It upgraded দিয়ে দেবেন। Yes.
I permitted to mention item number 691, your lordship. Petitioner is a senior citizen, your lordship, aged about 67 years old, your lordship. Despite refusing the credit card, your lordship, bank has issued credit card in my name, your lordship. Your lordship,
Not urgent at all.
Adjusting amount from my pension account, your lordship.
Not right now. Not right now. Yes. What is urgency?
I want to pay the gold loan entire. There, after filing of this petition, they issued a letter stating that on 15th of September, they will auction all the gold. I want to take the debt saying that.
15th of September.
15th of
এটা টপে দিয়ে দেবে। Yes,
Is that okay for the?
please hand over. No. No. Hand over.
Copied the application, but during the pendency of the application, ruling political party taking action of this matter. The application was-
Section 14 Surface Act application is pending. What do you want now? What do you want? What relief do you want in the writ petition? Hand over.
Petitioner has been debarred from participating in any tender matter
Hand over.
and gentlemen.
Yes.
Against the application, my lord, against the willful defaulter case, now they are pretending, my lord, to make the publication.
Application. This is an application. Please hand over. Yes.
Another is a restoration,
Another is a
restoration application.
applications hand over. Yes. Not contempts. Other applications. Please hand over.
May I lordship kindly to mention item number 73, the petitioner before lordship is a 80-year-old patient, is an unmarried cancer survivor. Now his savings bank account has been debit freeze without any intimation whatsoever. Now the problem is he has run out of cash reserve and does not have even money to buy medicines, your lordship.
73 টা টপে দিয়ে দেবেন তো 73 give a slip. Yes. Yes, Mr. Shah.
Item number 64 of the upgraded list, upgraded on the 9th of August, because your lordship was, my lord, convinced that, my lord, there was a freezing of the bank partnership account. My lord, as instance of one party when the civil court had refused that order. Well, it is, my lord, since 9th August, my lord,
Sure,
the
no,
business is, my lord, closed.
I fully appreciate, but no further.
My lord, last occasion, my lord, allowed my mentioning, my lord, for upgraded, my lord, it has not come in the upgraded, but as a item number 663, my lord. This is, my lord, ESI authority, my lord, they have.
Allowed the upgrading.
Yes, yes.
Please hand over again. এটা একটু দিয়ে দেবেন তো
All right.
upgraded liste চলে যাবে. Yes.
My lord, may I have your leave to mention item number 282 of the monthly list, lordship?
Yes.
I've been debarred and blacklisted from participating in any tender from 14 July. I've annexed a list of upcoming tenders.
Hand
which
over.
is on
Hand over.
8 September.
Upgraded data
10th
দিয়ে দেবেন।
September.
Upgrade. Yes.
Lordship, may I be
My
permitted to
lordship.
mention, your lordship, this matter is appearing as item 280 in the monthly list, your lordship. This I filed on the 28th of July 2023, your lordship. And I've mentioned 4 occasions, your lordship. The urgency was only that I had applied for the environment clearance in July 2019 and the respondent 11 has applied in August 2020. Now his environment clearance has been given and he is now setting up the plant, your lordship. It's extremely urgent a matter, your lordship.
Plant for what?
Plant for the processing of biomedical waste.
No, wait for some time.
Lordship, he is
Wait for
all,
some time. No.
My lord,
No.
my lord, by placing forged documents, my lord, the petitioner secured an order from this honorable court, from your lordship, my lord.
From me?
Yes.
It's an application for recall or modification. Hand over. Application heading এ যাবে. Yes.
For execution of the interim order.
Please hand over. No, you stand there and mention so that you can understand the reason for my not including further matters. This is the reason for my not including other matters. Do you understand that? After that mention. Yes, please come this side and mention.
The fact is that after considering your lordship directed the Bidhannagar Municipal Corporation to submit a report indicating the reason why the amount has not been released, my lord. They are the tenderer since 2021. He is not getting any money, my lord. Huge money has been blocked. He successfully executed the order.
You'll have to wait for some time. I'm
No,
sorry.
I have already, your lordship directed, my lord. Now the family will be ruined, my lord. They have nothing. Every
no,
month
no.
he has to pay them, my lord.
Not now. Yes.
No, next week, my lord. Next
No,
week, my
the
lord.
first time you said correctly. Next month. Yes.
Next month.
New? No, not right now. Yes.
I have agreed by non-disposal of my 614 applications. There are 3 similar matters.
Hand over. Yes.
273, my lord.
What was allowed? What was allowed? It wasn't allowed. Your face says it all. What was allowed? What is the mentioning? What is the urgency? Even if it was not allowed previously, please hand it over. Yes. Yes, Mr. Huda. Be a bit louder, Mr. Uday.
By IOCL, did not check for this, did not give a lesser number of procuring tank truck. Now that they've issued a notification, my lord, to give backdoor entry to the favored ballot applicants, my lord.
Tender have to wait for some time, sir. No.
Because any time the letter of acceptance.
I appreciate, but no. Yes. What is the matter? Tell me the urgency. You have mentioned that's totally immaterial. You want a consideration of your representation? Hand over. Yes. What is the urgency? Wait for some time, ma'am. Wait for some time. Yes. Louder, louder, louder. Can't hear you. Really can't hear you. Please be a bit louder. What do you want in the writ petition? Hand over. Yes.
Number 693 of your lordship's monthly dispatch. Earlier, when it was against the
One second. Again, take it to be mentioned. The previous matter you have mentioned has to be mentioned. It has become infructuous. Give the caption to be mentioned. Within brackets, infructuous. Take to be mentioned heading as well. Yes, please. Sorry. You must have not been there when it was called on. It cannot go down the updated list. No, all the upgraded matters are there. Something must have happened. No. No. Wait for some time. No further upgradation right now. Yes. Some of the debarred matters I have already taken. Please wait for some time. Not right now. Sorry, no. Yes.
May I be permission to mention one matter, old matter, it was new motion.
Old matter or new motion? Old new motion. Wait for some time. Yes.
Only one petitioner is a senior citizen suffering from.
I appreciate, but can't add now. Yes.
New motion, since the date of filing.
Urgency.
Since the date of filing, matter never listed.
Next. No.
Your lordship, item number 209 of today's list, your lordship, the petitioner has been debarred, your lordship, and the respondent authorities, they are.
Debarred quota is over for today.
Your
Next week
lordship,
come
they have
back.
already issued a e-tender notice, your lordship. I have the tender.
Notice to do what?
To publish a new on the same tender project, your lordship. With the petitioner has been debarred already, your lordship.
Oh, wait for some time.
Kindly, your lordship.
To file this writ petition, my lord, the DM order passed in respect of the other property, my lord, but the bank is.
Why are you asking for leave? File in due course.
My lord,
File in due course.
My lord, the DM order has been passed. My lord, they will attach my.
When was the order passed?
My lord, the order is passed at 29th
August.
August, my lord.
Very leave দিয়ে দিতেন কালকে থাকবে list. Very it will appear tomorrow.
You kindly to mention, my lord, duly registered apartment association consists
কাল
of
থাকবে
125 villas, my lord.
হ্যাঁ টপের দিকে yes.
Duly registered apartment association consisting of 125 villas. Out of 125 members, only 8 members are paying the fees on a regular basis for the past 3 years. Now they have come up with an application, come up with a meeting saying that we don't want the other body to be conducted any further, the association role. Now the meeting is scheduled to be held on 10th of September, my lord.
No.
They are all defaulters, my lord.
No,
All
sorry.
the members.
No. Yes.
My lord, may I be permitted to mention one matter? In this matter, my lord, Mr. Petitioner is the partnership firm under the MSME Act 2006. In order to ascertain the certain company, certain firm as a MSME under the MSME, Honorable Division Bench already passed an order on 24th August 2020 in order to ascertain how the certain company will be ascertained under the MSME Act. In spite of that order, my lord, respondent authority passed the improved order by terminating contract, which was
You have challenged the termination.
termination.
Wait for some time.
My lord, in this regard, my lord, urgency that unless it is not recalled, petitioner farm will suffer huge loss.
No.
Already all compliant, my lord, there's a, it is similar issue already
No.
adjudicated
Please
by.
go, yes.
Lordship, this matter was heard by your lordship. Your lordship, it was a Jalpaiguri bench matter. Lordship, thereafter the interim order was vacated. Your lordship, lordship, thereafter an recalling application has been filed and the file has been brought from the Jalpaiguri bench before this bench. Your lordship, I've been mentioning before the Jalpaiguri bench, but the matter could not be listed because they have sent the file here because of a recalling application when the interim order has already expired on 31st August.
No, I can hear it in the Jalpaiguri bench, not right now. I won't have time to file it.
Only praying, let the file be sent before the Jalpaiguri bench. Your
It
lordship.
will appear as to be mentioned tomorrow then for that
Lordship.
purpose. Just remind me why it is appearing as.
Lordship, lordship.
এটা to be mentioned কালকে দিয়ে দেবেন জলপাইগুড়িতে পাঠানো হবে
Grateful, dear lordship.
My lords, need to mention a
Yes.
new motion which filed in 2021. This is a writ for a direction upon the collector to hear my appeal under Stamp Act.
hand over please. এটা আপগ্রেড দিয়ে দিন yes
It's a new motion, my lord. It's not appearing.
even then it will appear under that.
Operation of item number 273, my lord, petitioner applied for new electricity connection in 2022, my lord, but till date connection has
hand
not
over এটা আপগ্রেড
Item number 255, my lord, it is the first new motion. It appeared on the top of the list.
What is the urgency, please?
Urgency is, my lord, petition due to the non-jurisdictional order passed by the respondent authority concerned. Petitioner's farm is almost on the closure. 200 laborers are on the verge of starvation, my lord. Only I want my lord to be hard, my lord, because
you have challenged what
I have challenged the notice, my lord, on the without jurisdiction which has been passed.
notice of
Notice of debarring the petitioner for.
regarding please you have to wait for some
But this is what.
are you representing the labor the 200 labor or the owner of the concern so why are you taking the plea of the laborers no
Because they are the manufacturing.
no
physical item.
they will more you will suffer more than them you are representing not the laborers but the owner so please mention like that no not right now yes
He's manufacturing the
My lord,
principal
objection-
item, my lord. That is why everything.
No.
My lord, petitioning for extension of interim.
extension handover
He has applied for arms license so that he can act as an armed guardman.
handover
Your lordship, I am looking for upgradation. My lord, the
what is the urgency
urgency is that,
take your time don't be very fast yes
urgency is that in front of my house, there is a electrical transformer being installed just in front of the entrance.
handover
But I have your lordship, I need to mention, my lord, the item number 1163, my lord, this is the assigned matter, my lord. I have previously. made-
civil division
My lord, this, my lord, on the last occasion, we have taken adjournment. My lord, it is fixed on 11th September, my lord, as last time. My lord,
এটা টপে দিয়ে দেবেন তো হ্যান্ড ওভার দ্য স্লিপ এটা টপে থাকবে কাল yes please hand over yes hand over yes you are for the vendors sellers
Yes, sir.
hand over please.
On the personal option, the petitioner is having a tailoring shop in the premises for option, even in spite of the installation of the municipal office.
hand over এটা আপগ্রেডেড থাকবে
Some 100% constructed structure in the PWD road in front of their house.
not right now
Mention item number.
There is no.
yes you
May I permit to mention item number 126 of the monthly list, my lord. This is the petitioner is praying for consideration of his representation.
hand over
My lord, may I be permitted?
আপগ্রেডেড থাকবে
My lord,
Yes.
may I be permitted to mention? My lord, the petitioner is a volleyball professional who representing India since 2000.
urgency
So, urgency is that during selection process in 2023, the Asian game, she was not being selected by the authorities. Now, my lord, subsequently she represented the representation to the authority. It was not considered.
hand over
And my lord, the
এটা আপগ্রেড
urgency
টপের দিকে দিয়ে দেবে টপে দিয়ে দেবে
is leaving for China.
yes
Lordship, may I permitted to mention one matter, item 168 of your lordship's list. The petitioner, during the COVID pandemic time, the SDO Kolani floated a tender for supplying some computer materials or software services, and petitioner appeared in this tender, awarded the work order, but till date sum of 15 lakh rupees the petitioner has invested, but no one single rupee has been disbursed by this SDO Kalani. Several representation has been given.
Money claim, please wait for some time. No, not right.
Your Lordship, may I have your leave to mention the item number 140? Your
Please take the microphone. Yes. Item?
Item number 140, your
What is the
Lordship.
urgency?
Urgency, the petitioner is a association carrying out welfare activities. Now, your Lordship, the respondent authorities being the NKD, your Lordship, they have obstructed its carrying out its activities. Now, your Lordship, Durga Puja is on its eve, so they have put a lock in the said.
What part of welfare?
Your Lordship, it carries out all type of welfare, like from the Independence Day and all type of Saraswati Puja, your Lordship, Durga
These
Puja.
are welfare. Wait for some time. There are more welfares to look to.
Your Lordship, because of the Durga Puja, your
No,
Lordship.
not right now. Not right.
Your Lordship.
May I have your Lordship's
Yes.
leave to mention item 623 of the monthly list, my lord? My lord, here the complaint certificate has been issued, defect liability period over from 2019. My security deposit and retention money is not being released. Directions were given in 2020. No affidavit in opposition filed till date, my lord.
Wait for some time, ma'am. No.
Huge amounts of money are getting.
I
stuck,
appreciate,
my
but not right now.
2019, my lord, the whole.
Not
COVID
right
period,
now.
my lord.
No.
My lord,
Yes.
I have another.
No. What is that?
I am entitled to hill allowance under the notification, which is not being given. My lord, my representation may be considered. They may give a hearing.
Hand over. Yes.
Let-
Permitted to mention item.
Urgency.
The petitioner's bank account has been frozen for a long.
What are you? Individual person or a institution?
Person.
Hand over. Yes. Please take the microphone. Take the mic. Yes.
May I be permitted to mention item number 486? My lord, the petitioner's bank account has been freezed by the bank authorities.
What are you?
I am the petitioner, I am individual person.
Yes.
Your Lordship, may I please be permitted to mention item number 688 of.
Are you sisters? Two of you?
No, my lord.
That's very yes.
Uh,
If you are sisters, I would have refused you because the family quota is over. Yes. What is your urgency?
Item number 688 of your monthly list.
Take the
Your
mic.
Lordship.
Take the mic. Take the mic.
Item number 688 of your monthly list, your Lordship. The only urgency is that the respondent authorities are endorsing the illegal unauthorized encroachments by providing trade licenses and all those electricities and even constructing roads on the Waqf property. Your
Wait
Lordship,
for
this
some
is-
time. No.
Your Lordship, this is.
Sorry,
very
ma'am.
urgent.
No, not so urgent. No, not right now. Yes.
Lordship mentioning for upgradation in the list.
Urgency.
Yeah, your Lordship, I've been removed as the supplier of this same
Oh, wait for some time. No, not right now.
contempt application.
Sorry, no.
Your Lordship, this is the matter is regarding the issuance of RC2 certificate in favor of the petitioner.
Please be a bit louder. What certificate?
RC2 certificate in favor of the.
Or
petitioner.
incentive? No, not right now. Not right now. Yes.
Item number 767 of the monthly list. I am a petitioner as a farmer and a senior citizen. My land has been encroached by the respondent number 4 by setting up high intensity electrical wires. I have made my representation before this honorable.
Hand over.
Item number 1047 for upgradation. Urgency is this, my lord, the petitioner is.
You're reviving the localized habits. No.
Yes, matter.
Yes, Mr. Koth, what is it?
My
What
lord,
is it?
the urgency is this, my lord, the senior citizen mother. He's not being maintained by his son. Although he's earning from the, my lord, this is father's stamp vending business.
Please hand over.
My lord, item number 1047.
1047. Please write on a slip of paper so that it can be upgraded. Yes.
This is a new statement. It's a tender matter. No.
Tender, wait for some time. No.
I have a lot of time to mention item number 676. What has happened? Lord, petitioner's father used to maintain a savings bank account. Lord, in spite of obtaining a success certificate from the bank office are not disbursing the amount.
Hand over.
It matters by lot. The petitioner is basically has a drag license. You are the drag license of BDC.
What license?
Drag license.
Drug, yes.
But, yes, person yes, give some person for renewal. But my signature
This will take some time, not right now.
anytime by anything may happen by not but
No, nothing will happen. Not right now. Yes. So to be mentioned, like to be mentioned, it has been given or disconnected. So what do you want now? What is the urgency in the matter? Hand over. Yes, Mr. Manna. Mortgage property has not been released. Mr. Manna, please wait for some time, not right now. No. Next. Urgency, please. You'll have to wait for some time. No. You'll have to wait till probably 1 or 2 more years. I'll complete this side and not come back. You are? Hand over. Yes. If that is the only urgency, sorry, no. If I may refuse last month, there must not be urgency in there. They don't mention. No affidavit direction. No, there are so many urgency. No. Next man. No.
I am 90 years old. The electricity company is issuing commercial meter in my name, but I am issuing the meter for domestic purpose.
Hand over.
The amount is very high.
May I be permitted to mention item number 735 of the monthly list, my lord. IOCL has illegally encroached into my property. Now, when I protested, they said, okay, I will pay you certain compensation. Yet today, no compensation has been paid.
Please wait for some.
My lord, I'm a senior citizen and I'm in a hand-to-mouth condition. My lord, have on earlier occasion allowed my mentioning. It is appearing in the monthly list. My lord, kindly it be upgraded at once.
No, there are so many matters I cannot now. Yes.
Lord, may I be permitted to mention item number 690 of the today list, my lord, for upgradation, my lord. Your petitioner is a farmer, my lord. During the pendency of this writ petition, my lord, the private respondent had damaged the crops of the petitioner, my lord. And
What relief do you want in the writ petition?
my lord, they have also damaged the residential house of the writ petitioner.
What relief do you want?
Police help, my lord.
For?
For
Police in action, Justice Sengupta.
but this has been filed in before your order.
Give the heading to be mentioned, I'll release it. To be mentioned, bracket police help. Within bracket police help. It to be mentioned, bracket police help for release.
My lord, item number 549, my lord. I am praying for upgradation because my lord, petitioners minor data kidnapped, my lord, and rescued by the police and take to the home. And 7 months, my lord, sees in home. Say they are
Hand over.
releasing.
It upgraded the other.
Leave to file, my lord. This is against.
What is the urgency?
My lord, the urgency is, my lord, the DRT is not in session, my lord. Section 14 order has been passed, my lord. My essay has been filed. My lord, this week, my lord, any moment they will take possession, my lord.
Tomorrow top. Leave. Yes. Please take the microphone. Yes.
My lord, the private respondent acquired and built a construction on a road owned by PWD and Union of India, my lord. For this reason, my lord, the petitioners.
Wait for some time.
My lord, one more, my lord.
Application.
Restoration application, my lord.
Registration application. Yes. Yes. I'll not come back this side. Please don't wait. These people. No, I'm taking mentioning for sufficient time. Yes. You. Complete.
May I have my mention, I don't know, 246, my lord, discuss with electricity, my lord, I am without electricity, my lord. Just
No. Please be a bit faster. I'll just take a break.
An application for renewal of the passport. The passport authorities has cancelled the passport and they have asked for making a fresh application, my lord.
No urgency right now. Yes.
Lordship, item number 160 of the monthly list. My urgency is there's just a scarcity of the water in the locality. People in the locality, they do not get.
What is the relief you have sought?
For installing of the second land deep.
Please hand over. It is upgraded list.
I have been declared as a willful defaulter. Willful
defaulter not so urgent. No, Mr. Arfin, no. Yes.
Dispute with respect to constitution of an apartment ownership association.
Not this year.
The problem is not because of the pendency of this writ petition. Everybody has stopped paying the maintenance.
No, Mr. Conway, not right now. No. Yes.
This is my section 14 application.
You want a disposal?
Yes, my lord.
Hand over. Yes.
Chance
Petitioner is appealing for loss and for this.
Petitioner is a
sufferer and employee also suffering for this. My lot upgradation.
Sorry, no, not right now. Yes.
Item number 740 for upgradation. The petitioner is a senior citizen. The dispute is regarding a bank account. The bank has frozen the account.
Not right now. Let me finish off these upgraded matters first. No. Call on the list.
My lord,
Further mention.
My lord, for
Please call.
upgradation. My lord, upgradation. My lord,
No further mention. Call on the list.
Port Blair matter item number 1.
এটা কি কোন লিস্টে আইটেম?
My lord, your lordship told me to mention
ভালো
this
করে বলে
matter.
দিন ওখানে, Port
My
Blair
lord,
item.
one matter for release.
My lord,
Release
your
from my
lordship
lord's
asked
list.
Port Blair matter item number 1.
Port Blair item 1 who is appearing?
My lord, I am appearing on
My
behalf of
lord,
the
the
respondent. my
appeal
lord.
is still pending. The appeal is still pending, my lords, and on the last occasion, it was adjourned at the request of the contempt petitioner, my lords. It is coming up in September.
When should
And it will be taken up in the.
My senior is appearing for the petitioner. Mr. Kumar is appearing for the.
I'll pick it up on October 10th. Within that, we hope
My lord.
that is taken up.
My lord.
My lord.
Learned counsel for the alleged contemner submits that an appeal against the parent order is now pending and was adjourned on the last occasion on the prayer of the present contempt petitioner. Full stop, next para. On the prayer of learned counsel for the alleged contemner, the matter is adjourned and shall next be listed on October 10, 2023.
Most
Thank you.
grateful.
Item 2 টা দেখুন।
Item 2.
My lord, I am appealing for the contender in this case. We have complied the order by passing an order dated 10 July 2023, my lord. This representation has been disposed of.
Who is the
I'm for the petitioner, my lord. Kindly come to the compliance report. The order passed by the settlement officer. Second last paragraph, my lord. It's still pending, my lord. Just to escape from the contempt application, this order has been passed. Kindly come to their order, my lord.
Where is that order?
It's they have annexed, my lord, the order in the compliance report.
That's a very well, yes.
My lord, second page, my lord. Second page, second last paragraph. Tahsildar settlement is directed to review the recognition of the boundaries as per the physical position of the recorded tenants and put up the proposal as per rules and available revenue records. When there is a direction to review that means it has not been completely disposed of. It is a case of subdivision, my lord, and all the parties are consented for the proposal map. They have given the proposal map on consented basis.
Let me first see the direction which was passed by the court.
My lord, there was a direction to dispose of my representation in accordance with law.
Yes, my lord, it has been disposed of.
Direction to dispose. Yes.
In accordance with law. Now they have.
Yes.
We have disposed of the representation.
Kindly see last two paragraphs, my lord.
Right.
I have not encroached any excess area. I am not encroached any excess area. I want my land to be subdivided. That is the recorded. I am the recorded tenant. The petitioners are the recorded tenant. We don't have any excess area to that. We want the land to be subdivided, which has been recorded in our name.
The proposal given by the applicant is not matching with the record, my lord. As such, the order has been passed with the direction.
No, the direction was to consider your representation that has been considered and your prayer has been refused.
Yes, madam.
But the Tahsildar again to review.
It is a fresh cause of action.
Because the Tahsildar settlement is directed to review the recognition of boundaries. That means it is still pending, my lord.
And if you are aggrieved, this is a new cause of action. We cannot decide this contempt application.
My lord.
Learned counsel for the petitioner submits that there has not been sufficient compliance, although an eyewash has been given by the alleged contemners by its order dated July 10, 2023. Full stop, such contention is disputed by the alleged contemner who argues that the petitioner's representation has been duly considered and disposed of. Full stop, next para. The order dated July 10, 2023, annexed to the compliance report of the alleged contemner indicates that the authority concerned considered the aspects of the matter involved and ultimately came to the conclusion that as per established practice, excess area, if any, cannot be allowed to be in possession of the applicants for subdivision to occur. Full stop. It was also observed that possession of applicant, schedule of property acquired by applicant as per gift deed, proposal map and map as per revenue records have to tally for subdivision to occur. Full stop. In view of the above observations, it was recorded by the settlement officer, South Andaman, that he is of the considered opinion that the present application of the recorded tenants dated 22/12/16 for subdivision of the concerned land cannot be approved. Full stop. The Tehsildar settlement was directed to review the reorganization of boundaries as per physical possession of the recorded tenants and put up proposal as per rules and available revenue records. Full stop. Next para. The applicants were directed to vacate excess area by applying to the area Tehsildar and may reapply for subdivision after fulfilling the conditions required for subdivision. For sub next para, irrespective of the merits of the said adjudication, the order of this court was complied with by considering and deciding the representation of the petitioners. Full stop. In the event the present petitioner is aggrieved with the said order dated July 10, 2023, the same furnishes a new cause of action for the petitioner, enabling the petitioner to file a fresh writ petition. Full stop. However, there is nothing on record to indicate that there was any deliberate violation of the order of this court to justify issuance of a rule of contempt. Full stop. Hence, CPAN 34 of 2023 is dismissed with liberty to the petitioner to challenge by way of a properly constituted challenge to the order dated July 10, 2023, if aggrieved with the said order. Full stop. No orders to cause urgency. Thank you.
Oblige, my lord.
Oblige, lordship.
Next. Regular list.
I beg your pardon, my lord, but your lordship asked me to mention this matter after the completion of hearing, completion of mention.
Yes, what is that? This?
My lord, the West Bengal Industrial Corporation Limited issued a letter of intent in my favor. Now, I was required to complete the commissioning, my lord, by end of 31st of August. Now,
what has happened now?
Now, my letter of intent may be withdrawn at any point of time. I have invested more than
Not
4
right
crores,
now.
my lord.
Sorry, no. Yes.
My lord,
praying
for
for
item number 1.
We mentioned item 1, yes.
My lord.
Why release?
I am for the petition.
Why release?
This is a police in action matter.
Since the matter pertains to a police in action, as pointed out by learned counsel for the petitioner, this court does not have determination. Full stop. Accordingly, the matter is released from my list with liberty to the parties to mention for inclusion before the appropriate bench having determination. Next.
My lord, my lord, my lord.
2.
Item
Two.
2.
Yes.
Item 2, I appear for the petitioner. We are seeking an order against the enforcement directorate. I'm said your lordship.
Since this court does not have determination, let the matter stand released from my list with liberty to the parties to mention for inclusion before the appropriate bench having
And
determination.
one more request. Well, this lady was standing from the beginning. She was in person. But
Yes.
she hasn't
Oh, in
understood
person.
that in the mention.
Thank you, Mr. Ghosh.
She was raising her hand, but I don't think your lordship.
Thank you. This is the
can see her.
proper duty of an officer of the court, actually. Thank you for pointing out. Yes. What do you say?
My lord, I was
Let me hear. Oh, yes, yes.
That has been
No, your name should be recorded.
Please.
In every matter which I release, your name has to be recorded, Mr.
my lord.
Yes.
একটু দেয়া যাক এটা
না এটা কি ব্যাপারটা কি আগে বলুন।
অ্যাকচুয়ালি আমি পিটিশনার, হ্যাঁ 6032 সব এই
আপনার লয়ার কেউ আছেন?
আমি একটু বলছি, আমার এই মামলাটা আমার যেহেতু উকিল মশাই সহযোগিতা করেননি 11ই জুনের পরে এই মানে 11
আমি
তারিখ
মিস্টার ধ্রুব ঘোষকে আমি অ্যামিকাস কিউরি অ্যাপয়েন্ট করছি আপনার।
এইটা মানে মিডিয়েশনে মৌসুম না না
নাও ডু ইওর ফাদার ডিউটি।
স্যার এটা না মিডিয়েশনে মানে এর আগে যে মৌসুমী ভট্টাচার্য যে ছিলেন উনি বলে গেছিলেন লাস্ট দিন আমি অ্যাপিয়ার হতে পারিনি শুধু যদি এটা মিডিয়েশনে একটু আপনি দিয়ে দেন, এটা লেখা এই অর্ডার কপিটা লেখা আছে।
এই ম্যাটারটা কি আরবিট্রেশনের কানেকশনে? এটা কিসের কানেকশন? মেন রিট পিটিশনটা আপনার কিসের ব্যাপারে?
হ্যাঁ রিট পিটিশনটা আপনার আমার কাছে রিট পিটিশনটা আছে, এটা হচ্ছে
ওটা দাও। এটা টু বি মেনশনডে কালকে দিয়ে দাও। কালকে টু বি মেনশনডে থাকবে এটা লিস্টে কালকে লিস্টের উপর দিকে টু বি মেনশন হেডিং এ থাকবে, আপনি থাকবেন বা কাউকে রাখবেন, অর্ডার পাস করবেন।
My lord, I beg your pardon.
You are
This
also
mat-
appearing in person?
No, no,
Then no.
no. This matter was heard by you.
I've started calling the list, please. Yes. Item 2, Dako.
Item 3.
Yes.
My lord, I appear for.
Yes, Mr. Dar.
Lord, I appear for the respondent school in this matter.
My lord,
Yes.
respondents have been served. Have been served.
Yes,
My lord,
Mr. Dar.
Yes. My lord, before your lordship looks at any of the document, if I can just say. My lord, there is one concept before making my submissions on the merit. My lord, the Christian missionary schools, which are, my lord, the minority institutions. My lord, there is a concept called, they call it.
What is this? রাখুন এখানে।
My lord, there is a concept called we know that the name of the school has a word called diocesan of something. My lord, it's common. Now, diocese is
Yes.
the territorial jurisdiction of the bishop.
Right.
Bishop is the head, and under that, my lord, there are several institutions. Now, that may be required. After Vishaka's case, my lord, there has been a legislations, 2013 Act. It's a long name. I'm for preventing, my lord, sexual harassment at workplace.
Right.
I am challenging an order passed under this act by the local complaints committee, LCC, instead of ICC. I am questioning the very jurisdiction.
What is I?
My lord, internal complaints
Internal,
committee.
Very good, yes.
My lord, the legislation, if I can briefly say, directed that to prevent sexual harassment in any workplace, every establishment, institutions, they must have an internal complaints committee. My lord, that's a must.
Yes.
It's a post Vishaka. Until that time, this legislation was there. It was guided by the Vishaka with the similar kind of directions under Article 141. Now, the legislation also prescribed if there is absence of ICC, in every district, there is an LCC. So, in absence of ICC, the jurisdiction of the LCC is also there under the 2013 Act.
So operates in the same field if ICC or not?
Yes, 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 yes.
If ICC is there, is it the appellate authority? No.
No, it is not.
Very well. If it is not there, then
It
LCC.
is not an appellate
Right.
Fundamentally, I do not know, there are several points I have, but I want to confine myself with the jurisdictional point, because if I succeed on the jurisdiction point, I may not be requiring to go to any merit of it. On merit, if I can only use the two sentences, on merit, the LCC has found, I have said to X, a person, that Y is I have to use a Bengali word, Y is quote and unquote phaltu mein. And that has been used to translate as phaltu is cheap, though the dictionary it says useless, and that is a sexual harassment. But that is on merit. I'm not into that. Lordship, my lord, challenge is, I have specifically taken the point before the LCC that there is an ICC in this St. Stephen's. This is it concerns with the primary education in the Barakpur. Under the
These people are all staff of that.
The
teaching or non-teaching, whatever.
If I can use, it's a staff, but I want to use the term as used in the legislation. The 2013 legislation, it uses the term as an employee, and it covers, it's not like a service jurisprudence employee. It covers even a person who comes up there, even if he doesn't take any money, whoever is working in the workplace, he is an employee. Now, my capacity is that
not strangers.
Not strangers.
Right.
Because what happens, my lord, that the women who are working there,
it's not their workplace, the strangers. Whoever is working there.
Whoever is working there. Now, whoever is working, it's a very very wide kind of definitions, as I have found it there.
Yes.
Now, I am the secretary of the governing body of St. Stephen's School, of the managing committee of that school.
Right.
My lord, above me, there is the managing committee, there is a vice president, there is a president, and the head of these entire institutions is under the bishop. All these minority institutions.
You are under the diocese.
Yes,
Right.
I'm under the diocese.
Yes.
Now, my challenge, first challenge is the order is entirely without jurisdiction by the LCC.
Because ICC.
Because of the two reasons. LCC has accepted by its own order that there is an existence of ICC. I could have understood that he says that there is an absence, so therefore I take up the jurisdiction. He accepts that, but thereafter he uses one sentence, it is not properly constituted. That's the sentence. And he passes the order. The effective order is that remove me, and throughout the future, I can never be secretary in the school. That's the order itself. My lord, may I place the relevance?
What is the second ground of charge? One is LCC, ICC. The
Yes.
other ground of
My lord, the other ground of challenges are this. The crux of the matter that I said to why.
No, on jurisdiction,
Yes.
only LCC, ICC. This.
Well, on jurisdiction, this is.
So you want to address jurisdiction?
But I have another, but according to me, that's not the best. That I was trying to see what's the meaning, because I have annexed the dictionary from the Etidev dictionary, because that's the Bengali to. But it says useless, and I was trying to also.
Context has to be seen.
Correct. The context.
Yes,
Well,
definitely.
otherwise, we often say in Bengali, like if I can use
Often
this.
say many things which need not be uttered, but
True.
But
True.
the connotation, the context is very essential.
True. Context is, according to me, it's the entirety.
Entirety. Yes.
Now here the context,
Yes.
though I should not go to the merit prior to my submissions and jurisdiction point. It was not even in presence of the private respondent. I said about someone else, but lots of
Proximity has to be considered. That the
has
other
to be,
things are-
but if that is on merit on fit.
Yes.
True. My lord, the other point of jurisdiction would be that the act does not even prescribe that the alleged person can be removed, because there is a prescriptions in the act itself what can be done. That is also, there is a complete absence of that. Now, may I, my lord, first
Mr. Kormakar, take your seat. You are the victim.
No.
Or the institution.
I am representing the school.
Great. Take it.
I think
It
so.
has a
School, as
ICC.
we are, I don't think there is much. School is not against.
Sir, my endeavor will be to substantiate that I have a validly constituted ICC.
Obviously.
My endeavor.
Lordship, may kindly first see the jurisdictions of the ICC.
Who is actually the main opponent here? Are
The
they
private
present?
respondent number 15 served.
You are for which authority? The entity which passed the order.
No, victim is
Victim. He is for the victim, and
I am for Milord the LCC.
Great.
That's
So both of them are
yes,
there.
all.
You are the main opponents basically
Yes.
in this matter. No, because your order has been challenged,
Yes,
and she's the.
it is
suffering
yes.
one. Right.
Lordship, may first kindly see section 4(2), the ICC formation.
Protection of children from section of.
Well, this is a wrong printing. Everyone faces this problem.
So can you rely on the main section?
Yes. But the inside, it should not be judged by the cover. In this case, I mean, that's a common thing I have faced. I don't know why they keep on making mistakes.
No, the name of the. No, this is the protection of children from sexual offense.
No, this
POXO.
is
This is POXO.
Lordship. I don't know.
There is another.
Or take the slim version. This, because
The adult version of that POXO.
Yes.
Yes. Of that act. Yes. Right, I've got it now. So section 4 you say?
yes, 4 is by law the Constitution of Internal Complaints Committee.
Right.
Lordship, may kindly see that section 4(2), the Internal Complaints Committee shall consist of the following members to be nominated by the employer. May I request your Lordship to keep page 222 side by side.
Yes. You are arguing on the non-existence, their argument that there is no existence of a properly constituted.
May I show
You're
that?
arguing on that.
Yes, I'm arguing on that existence, and not only existence, properly existence. And I would also show that if there is improperty,
then also
he's nobody. LCC is not an appellate authority. And there is true.
Yes.
My lord, I will show, but Lordship might take it as my statement that in the impugned order also there is a clear-cut recording, there is an existence, but for the sentence not properly constituted. True. Now, Lordship may kindly see section 4.2 that internal complaints committee shall consist of the following members to be nominated by the employer, namely A, the presiding officer who shall be a woman. B, not less than 2 members from amongst employees, preferably committed
A
to
woman employed as at a senior level at workplace.
Yes, but in this case, the acting principal.
Very well. Next.
Next is B, not less than 2 members from amongst employees, preferably committed to the cause of women or who have had experience in social work or have legal knowledge. My lord, there are 2 women who have that experience and they are there. I think there C, 1 member from amongst non-government organizations or associations committed to the cause of women of a person familiar with the issues relating to sexual harassment, provided that's not necessary. The last at 222, Reverend Dr. Surojit Sarkar, my lord, in this diocese, they have also charitable societies and institutions where many, my lord, the facilities are done, activities are done, which are relating to women development, helping women. So he says
Cause of women in a sense.
Yes. So, my lord,
although broadly,
it's a broadly.
it's not woman based, but even then, very well.
So I say that what
palpably, at least there is nothing palpable to show that they are not properly
Yes, I could have understood that challenge is thrown that there is an
this person is not committed
Yes,
to the cause.
yes.
Those are more nitty-gritties.
Not there.
Yes.
My lord, that is the formation. Now, Lordship may kindly see the jurisdiction of the ICC. At kindly see section 9.1.
Yes, 9.1.
Any aggrieved woman may make in writing a complaint of sexual harassment at workplace to the internal committee, if so constituted, or the local committee, in case it is not so constituted, within a period of 3 months from the date of incident, and in the case of not necessary. Now, Lordship may see, providing that not necessary first proviso. But thereafter, none of the provisos or 9.2, none of the things are necessary.
Mr. Thor, what is your take on this? No, this has a peculiarity in its language.
Yes.
Any agreement may make in writing complaint
Yes.
to internal committee if so constituted, or LC
Yes.
in case it is not so constituted within a period of 3 months. Oh, I'm sorry.
Yes.
The complaint has to be within.
So that's a limitation.
The constitution is
Yes.
nothing.
Mala, if I can say this,
Yes.
presence has one particular committee under the statute. Absence makes it the committee being different.
Right.
It cannot be presence even then a different committee. Now, Lordship may also
proper is immaterial.
That is immaterial,
right?
According to me. For that, Lordship may kindly see section 26, because it will give a reference if there is a proper, improper, who has the authority. It's the government. Lordship may see that penalty for non-compliance with the provisions of the Act, where the employer fails to constitute the internal committee under subsection 1 of section 4, then or B, C are not relevant here, shall be punishable with fine, and in case of defaulting case, cancellation, approval, that may go. For an example, I'm running in school. So if there is an approval by the state, having noticed that I have not constituted, it's a state, they can intervene and say, we are cancelling the licensing, etc. That is under after post first default. Now, Lordship may kindly see the jurisdiction of the LCC. That's at 6. Well, I'm told by my learned friend that he has marked, so I should convey it to before your Lordship.
Yes.
Whether there is other books.
In
are
any
also-
event, you will be showing the same things. So let us
Yes,
not be
yes,
on this. Yes.
And in sometimes I feel that we have gone ahead of that. Marking is, I don't think that.
Rather, I think marking should be there.
Yes, yes.
To guide people. I mean, what I am arguing on.
Well, I thought I should not make that bold statement.
No, I mean,
But
I don't
to
know.
me, it shortens the time.
Apart from the judge's order, that would be a bit gross. Otherwise, you can, why can't you mark it?
Well,
They will come and that will also be marked. Anyway, yes.
Well, six. Constitution and jurisdiction of the local complaints committee.
Right.
Well, may I read it? Because every district officer shall constitute in the district concerned a committee to be known as the local complaints committee to receive complaints of sexual harassment. Now, Lordship may kindly mark thereafter. From establishments, the contrast with an aggrieved domain in other case of ICC. From establishments where the internal complaints committee has not been constituted due to having less than 10 workers, or this is also the another, if the complaint is against the employer himself. Now, Lordship has to see the definition of employer. Lordship may kindly see 2G. Well, 2G.
If there is an ICC, then the ICC itself will hear also against the principal employer.
Well, I would say that the word is head, because in the may I place the definition and then Malad respond to this.
Yes.
The definition of an employer means in relation to any department, organization, undertaking, establishment, enterprise, Lordship may mark institution in this case. Institution, office, branch or unit of the appropriate government or a local authority. Thereafter, the head of that, leave that everything institution.
Yes.
Now, page 102, what I have exactly said, my lord, this all minority institutions, the bishop is the head of the institution. But if I can give a parallel, which we often say, like many decisions are taken by this honorable court by the full court. Now the registrar signs, sends it to wherever it is to be sent. But that does not make the registrar as the decision-making authority. Because that point may come, because I was the secretary, I have signatures of several documents. But Lordship may kindly have a look at 102 page. The word head, Lordship has seen in the very definition itself.
Yes.
Now, the part of the regulations, if the context otherwise requires, society shall mean the Barakpur Diocesan Education Society. That's a society under the school. Bishop of Barakpur shall mean the person holding the office and who functions according to the constitution of the Church of North India as the religious and administrative head of the Diocese of Barakpur. Now, coming back to the definition of employee, because I was saying that the definition of employee, unlike the service jurisprudence, it is something much wider, so that everyone, whoever is working, can be taken into account. That is in 2F. Employee means a person employed at a workplace for any work on regular, temporary, ad hoc, daily wages basis, either directly through an agent, including a contractor, with or without the knowledge of the principal employer, whether for remuneration or not, or working on a voluntary basis.
There is a dispute regarding that.
Yes.
Here. Why is that being placed here?
Because I am the secretary.
Yes.
Now, this is a voluntary work I do there. I I was only thinking that in case they take a point, in case that, look, you are not like another teacher. So my endeavor before your lordship is that the definition of the employee here, fundamentally, if someone is employed at a workplace for any work, now whether he is getting any remuneration or not getting any remuneration, that is completely immaterial. Completely immaterial.
No, if they have filed a complaint against this act, then they have to admit that
Well,
they are
they
an
filed initially, the lady filed before the ICC.
But under this act,
Under this act.
if it is under this act, she has to admit that she is an employee.
Yes. Yes.
So there cannot be any argument on that.
yes,
If they say I'm not an
yes.
employee, everything goes.
Yes.
So
True,
then
true.
that's under general law then.
True.
Right.
Now, my lord, may I take to my other point of jurisdiction? Lordship may kindly take 13.3. Though I have not shown before your lordship, but I have said what was the punishment. Remove and future. 13.3. Where the internal committee or the local committee, as the case may be, arrives at the conclusion that the allegation against the respondent has been proved, it shall recommend to the employer or the district officer, as the case may be, 1, to take action for sexual harassment as a misconduct in accordance with the provisions of the service rules applicable to the respondent, or where no such service rules have been made in such manner as may be prescribed. 2, to deduct notwithstanding, well, this is for deduction of some amount, etc. I couldn't find anywhere in the act that remove, and not only remove, if lordship kindly have a look at that also.
Such manner as has been prescribed, where is the prescription?
Now, this the rule ta dekhacho, rule to central government.
There's a rule.
Yes, Mala, there is a rule, but I would express before your lordships. I have my understanding of the rule is that's a central rule. Now there is a definition of the appropriate government. Now the appropriate government, may I show the definition and my lord complete my sentence. If lordship kindly have a look at the definition of the appropriate government at 2B. No, that's it. Let's see.
Yes.
Kindly have a look at this. The appropriate government means in relation to a workplace which is established, owned, controlled, wholly or substantially financed
This
by
is state government.
It is basically it's a private institutions.
Yes.
But geographically, lordship may kindly see that Roman 2, in relation to any workplace not covered under subclause because it is not funded by either state, falling within its territory, the state government. Now, under the act, state government has the power to frame the rule, and under the act, also the central government has the power to frame rule. Though none of the rules really it goes against me, because the parent act itself has said what could be the recommendation.
Prescribed means prescribed by rules made
The
under this
prescribed,
act.
there is always common definition prescribed by rule.
And prescribed by this act, that is there. See, so anything there in the rule?
My lord, yes, there is something in the rule, my lord. There is, if lordship kindly see.
Because since we are on removal.
Yes. In the rule itself, first rule 7.4.
Nine probably, because that is
yes, and 9.
Any action.
9, lordship will see, in my understanding, 9 allows termination.
Allows?
Termination, because the word 9 allows, the word termination is there. Yes.
Yes, it is there.
It is there. I've seen them. It is there.
Because it's termination, it's with curly lines.
Yes.
The others are straight lines.
So it
So
does.
broadly that is there.
Yes.
So this is the worst point, that's why.
It is
of jurisdiction.
Yes, it could be yes.
Worse, I mean,
yes.
among the two.
Yes. That's right. Now, lordship may also see that I have shown before your lordship the definition of the appropriate government. That is
yes.
There under 2B, 2B Roman 2. In relation to any workplace not covered under subclause 1 falling within its territory, the state government. Rule 9 not being framed by the state government. I am not aware, my learned friend may be aware, because because I have seen the book only. I have tried to search from the internet. I have not been able to find any rule being framed by the state. But I don't want to, my lord, take confidence on that, because sometimes it happens, there could be. But neither it is in the book nor in the, at least on the web, any of the websites.
Is there any other section conferring rule-making power on the
29, Lordship may see that it refers to appropriate government. It doesn't say
No,
the power of the appropriate government to make rules. 29.
No, you're right actually, because if the state has not made the rules, 29 comes in.
Yes. Because I was, my lord, because I had some understanding of the Electricity Act. There also, there is a central commission and the state commissions.
Absolutely.
None of the rules, there also the definition legislatures, they tried to have a very neutral definition of appropriate government. But whenever jurisdiction goes into, if it is in the territory of the state, it is the state government they are to make, and for the central, it could be. Now, sorry. Yes. The central government may, by notification in the official gazette, make rules for carrying out the provisions of the act. But thereafter, these all are there, but Lordship will not find. Lordship may kindly see F. The powers for making an inquiry under clause C of subsection 2 of section 11. And
H is important.
Yes. The manner of action to be taken under clause 1, yes, 13.3. Yes, manner. Now, that's, may I, before proceeding further, may I show before your lordship page 304.
Yes.
That's the impugned order. The relevant portion.
Yes. Yes.
Well, it's serial number 3. LC not 24 Parganas asked opposite party that whether there is an ICC constituted as per the act in the school or not. Opposite party informed that there is an ICC, but at the time of hearing it was revealed the ICC of St. Stephen's School was not a valid committee as per such and such act, because, kindly see the addition, no external member in the said committee. The word external I have checked up is completely absent in section 4.1. There is no word, this is his understanding. Lordship will not find the word external. And thereafter, Lordship may...
So probably C could be advised the external.
But the I
it
said
is not there.
It is absence.
As a mandate, it is
yes,
not
it's a rewriting. It's a rewriting.
Yes.
Now, Lordship may kindly take page 306.
No, Mr. Dhar,
Yes.
this person, the C person
Yes.
of Port C.
Yes.
I mean, is he a member of independent non-governmental organizations?
I should not say independent, because this
Under the
minority,
diocese.
yes, because it is under the Church of North India.
No, that may be, but church is not the employer here. Here, acha, very well. You are going by church bishop.
Yes, because he is the head.
And regarding the school, who is the head?
Well, regarding the school, there is a managing committee, vice president, and the president. But ultimately, head is the bishop only, nobody else.
Of the school also.
Of the school also.
Decisions of the school are taken by the bishop.
Well, bishop is the ex officio president of the managing committee of this.
Good. Yes.
So that's page 102. It's all minority institutions. It is the territorial jurisdictions. Head is the bishop. Now,
so no external member, yes. That
yes.
is come. Yes.
Lordship may kindly see page 306.
Yes.
Observation of LC not 24 Parganas. In the instant case, local committee not 24 Parganas observed that Both complainant and the opposite party have appeared and submitted their complaint and written statement. Both were examined by the local committee. Their witnesses were examined based on the written complaint, submission of witness or hearing both the parties. Committee members are of the opinion as follows. The opposite party, Mr. Shukollan Halda, that is myself, harassed the complainant sexually by passing the lewd comment, quote, cheap woman, within bracket, Phaltu Mein, about the complainant to her colleague, namely Anupam Mitra, which was further corroborated by witness, namely Mr. Anupam Mitra. In fact, I was not even allowed to cross-examine Mr. Mitra also, but these are on merit. The lewd remark is a serious assassination of the complainant's character, which borders sexual overtones. Further, it was evident from the deposition of Anupam Mitra that the earlier letter written by him, which was marked as annexure such in such and such opposite party, was false and fabricated. It clearly proves that the opposite party tried to mislead the LCC and suppressed facts. We, the local committee, not 20 Prognos, had unanimously recommended the following steps. The opposite party, Mr. Shukollan Halda, should be removed from the post of secretary, St. Stephen's School, Damdam, with immediate effect, and should not be a member in executive committee of the school in future. Internal complaint committee should be made. Now kindly see this. Next. Internal complaint committee should be made functional in the school with immediate effect and awareness of the staff, both. These are some just. This 19A and 19J
seems to be a tussle between the administration and the.
I never wanted to make
appears to be diocese and the administration.
There was a criminal case there. Ultimately, learned court found nothing against
very
me.
apparent assumption of jurisdiction.
And,
Anyway,
and there is
within law, then even.
in fact, there is a lot of bitter. I don't want to say anything on that because there is also at least 2-3 criminal cases are there. And those where learned court has found.
A giveaway is the lack of external member. That is the giveaway on their end.
Yes.
I mean, that's their.
Lordship may kindly consider this. In every district, there would be one district officer. And there are thousands of institutions in every district.
Yes.
The whole purpose of the Vishaka and then 2003 is basically to sensitize.
Yes.
It's sensitized, according to me, is the first criteria. And that's why there is a conciliation, some kind of whether, and thereafter, there are some other recommendations so that if I assume that for every institutions or for a primary institution, secondary, it goes to a district. Possibly that was never conceived of. And I could have understood that an LCC is no an appellate body. I could have understood there is a challenge thrown. It is not properly constituted. I fail. But these are my respective submissions.
Yes, Mr. Kormakar. In a nutshell, Mr. Kormakar.
Yes. Lord, more or less everything has been
You
indicated.
are for the.
I'm for the school.
School, right?
Lord, I was never heard to disclose or substantiate whether I have validly.
There is one I just forgot.
Yeah.
Lordship may kindly see 11, section 11, second proviso. In fact, provided further that where both the parties are employees, the parties shall during the course of inquiry be given an opportunity of being heard, and a copy of the findings shall be made available to both the parties, enabling them to make representation against the findings before the committee. So it is not findings and punishment. Findings given to person, representation post that. That is a common practice in all service jurisprudence. That findings given to the delinquent officer or whoever is the employee, he gives a representation thereafter. So this is a mandate of but that is.
Here you are given a hearing.
I said that once there is a findings, Lordship will see that the.
It is recorded that both complainant and opposite party have appeared.
But that is, I received the complaint and I made my whatever response to that. Thereafter, the LCC gave its findings and punishment. I say that after findings, there has to be my representations, which is a requirement under second proviso of 11. In fact, my lord, there are very landmark judgments, but dealing with the service matters. That once the inquiry officer holds, there is his findings, thereafter he has to give, because I may have something to say on that finding.
Yes, although sexual harassment is on gender, but the repercussion is on the service side.
Yes. Yes.
So has to be good.
And I can make it clear that as far as the complaint is concerned, there is an ICC. If that goes to the ICC, I have absolutely no difficulty.
Obviously, yes.
And in fact, I have not shown the document. ICC, my lord, they started, but she did not thereafter go there.
But I shall indicate those documents. Now, my lord, that I had a validly constituted ICC, that is not disputed, because the my lord, the victim, my lord, alleged victim, my lord, she personally, my lord, approached the ICC first. My lord, kindly come straight away to my lord, page number 106. Before that, my lord, kindly comes to page 55, just to indicate it fell from your lordship, my lord, why, my lord, the reason of this tussle. My lord, kindly comes to page 55 once. This is kindly notes the date, my lord, 5th of May, 2022. This to inform the complaint have been received against such and such, my lord, private respondent, primary teacher such and such. She have been dereliction of her duty during invigilation duty such and such. Look, this was the basis for a proceeding, my lord, which was initiated against her. As a counterblast, this came. Now, my lord, how? Kindly comes, my lord, to page 106, as I indicated, my lord. First of August, my lord, the complaint was lodged. And before that, my lord, there is an email on July, my lord, 4th of July, and subsequent to that on 7th of July. Your lordship will find that, my lord, at page 194 and 202 also.
Which was first? 106?
Lord, 194. That's 106 is basically indicating, Lord, the reasons why the committee was not functioning.
The 106 says what?
Lord, I'll take your lordship to 194. Kindly come.
First 194?
19.
Very good.
21st of June, 2022.
Yes.
To the President Managing Committee, such and such, my lord, asking for clarification regarding this. My lord, these are the indications, my lord, kindly turns over. The secretary pointed out that my character, commitment, work ethics, workplace behavioral norms, such and such. My lord, these were also.
This is the victim rights regarding
yes.
allegation against her.
This is the first complaint. This is the first complaint of the incident. The incident.
Complaint against the victim.
This is the victim's complaint.
That's very.
This is the victim's complaint.
Right.
Kindly comes, my lord, to 196. These are the, my lord, conversations based on which the victim thought that, my lord, this is, my lord, something which has a sexual, my lord,
overtone.
Yes.
Yes.
Lord, I'm not reading and disturbing your lordship on this at this stage at least. Kindly turns over. It goes on, my lord, to 197 as well.
Yes.
So, my lord, this is the basis of the complaint. My lord, now after this, what did I do? Immediately, my lord, my learned senior friend had placed that, my lord, the constitution of the committee. I my lord, constituted it and, my lord, referred the matter to, my lord, the ICC. My lord, she lodged a formal complaint with the ICC also. Now kindly comes to 106. Once the complaint was, my lord, being considered by the ICC.
106 is the complaint of the lady.
Of the victim.
To the ICC.
To against the ICC.
No, not again. This is the first complaint to the ICC pursuant to your reference.
194 is the first complaint of the victim.
To the president.
To the president.
Not to the ICC.
Not to the ICC is also there, 202. Yes, 202, my lord, I indicated. 194 was with the president, 200 your lordship sees, 25th June. The chairperson, internal complaints committee.
Right.
So, my lord, she was aware that ICC was functioning and existing. She makes a complaint there. Thereafter, my lord, this 106 comes up with this complaint, straight away goes to, my lord, to the LCC. Number
106 is also ICC.
106, my lord, kindly sees 106 once.
To the presiding officer, internal complaint committee.
Yes. Lord, and it writes Lord about the bias and those allegations are there that you are not Lord the right Lord committee which can function kindly comes to paragraph 3. This is a basic allegation that the applicant as being constrained had further approached the LCC. So Lord ICC was in session of the matter. How Lord may I indicate to that your lordship Lord kindly comes to 103 once. This is my lord on 2nd of August 2022. At the bottom, you will also find the date. Lord, the names of the internal committee, Lord, already placed. Name of the complainants, Bithi Dotto. Second, Lord, is Orpita Vishwas. She is being informed for hearing of grievances, bide such and such, to meet the members of ICC at 11 a.m., but she did not attend the hearing. Thereafter, Lord, also she was Lord, reminded a lot of time. She did not attend the hearing. The matter is still kept pending. I did not dismiss the matter deliberately so as to give her Lord, an opportunity of being heard. Pending this situation.
Mr. Kormakar, I was thinking there is a provision of penalty against the institution if ICC is not formed.
Yes.
Suppose actually her grievance is correct. Member number 4, Dr. Sarkar, is not a proper member, if I may. What is her remedy?
Lord,
I mean, if I say that your committee is absolutely biased, is there any remedy against that in law?
The remedy is to approach the government and initiate proceeding, or if
that
not,
is for
then
penalty.
go to
That is for penalty. But the committee remains.
Yes. No, Lord, the committee will go because of the penalty. Kindly sees Lord.
So if like such a situation, when my complaint is going to the committee, it's in season of the matter, I take a jurisdiction point. Now there is no scope
there are
of
two-phase remedies in my respectful submission. One is Lord, to lodge a complaint against the penal where the penal consequences are there, and the second is to come to court for reconstitution of the committee.
They can file a 226 also.
Yes, for reconstitution of the committee. They cannot say that because you don't have or you have a defective committee, I will go to LCC. LCC, my lord, is a substitute.
No, that does not confer jurisdiction automatically to LCC.
LCC
Maybe
is a substitute.
Very.
There is a purpose for existence of LCC. LCC is a substitute, not an appellate authority or a supervisory authority.
That purpose has been, in this present case, it has been satisfied.
Assert.
Anyway, so this is all.
And Lord, the last submission is Lord, without hearing. I was never a party, Lord, before the LCC, never. Lord, the school has been given a stricture how to form ICC, how to maintain Lord, records. Lord, this is my respectful submission is not what Lord, LCC is supposed to function. These are Lord, my respectful submissions.
Thank you. Yes. First, I'll hear the victim, then. Yes.
Lord, may I?
Yes. In a nutshell, don't take so much time. Yes, we are hard pressed for time.
My learned senior has already, my lord, placed the appropriate sections, my lord. I am only on two aspects of the matter. My lord, I say that even if ICC is there, the dispute is whether, my lord, if there is an existing ICC, whether the complaint can approach the local complaints committee or not. My lord, I say that irrespective of the fact that there exists an internal complaints committee, the victim shall approach the local complaints committee, and the local complaints committee only has jurisdiction since under section, my lord, it provides that if the complaint is against an employer, my lord, the inquiry has to be done by the local complaints committee and not the internal complaints committee. So I say that even, my lord, the IC exists, and even if, my lord, I do not go into the dispute with whether it was, my lord, rightly constituted or not, my lord, I say even if there is an existing ICC, my lord, if the complaint, which is in my case against an employer, my lord, it will go before.
How do you deal with that point? The employer has been defined.
The definition of employer, my lord, employer's definition, my lord, my learned senior has placed, my lord, probably.
Yes. So that says head.
I'm just reiterating, my lord, the definition.
Please come there. Yes, no difference.
My lord, kindly sees, my lord, 2G. My lord, employer means in relation to any department, organization, undertaking, establishment, enterprise, institution, office, branch, or unit of the appropriate
head of the department, organization, etc. is the important thing.
head of the department.
Right.
The
Or
a local authority, the head of the department, organization, undertaking, etc., etc., or unit or such other office as the appropriate government or the local authority, as the case may be by an order specified in this behalf. My lord, next, my lord, in any workplace.
no,
not
let
covered
us
under
let us
subclause
let
one.
us
My
dwell,
lord,
dwell on this a bit. So this is an alternative of enterprise institution. It's an enterprise institution, office, branch, or unit, or such other officer as may be appropriate. So it may be some other officer also if the state government stipulates.
My lord, my humble submission, my lord, G subclause 1 does not apply in my case because this is only, my lord, governmental organization, governmental institution.
Acha, very well.
My lord, 2 kindly sees, my lord, in any workplace not covered under subclause 1, any personnel responsible for the management, supervision and control of the workplace. This is my case, my lord. I am not covered by 1. I am covered by 2, which is any workplace, my lord, other than covered under subclause 1. Any person responsible for the management. My lord, kindly sees who is the secretary. My lord, the secretary is the appointing officer. Secretary is my appointing officer. The secretary is my confirming officer. My lord, kindly sees. My lord, kindly sees the annexures from, my lord, page 163 onwards, or my lord, even prior to that. I'm sorry. My lord, kindly sees the letter of appointment at page number 148. My lord, this is being issued by the secretary as well as the principal. My lord, then, my lord, kindly sees my transfer as a receptionist to a primary teacher. My lord, kindly sees page 163. This is issued by the secretary. My lord,
transfer can be misused also.
My lord,
transfer can be misused also. You may have that apprehension.
My lord, I am on the part of, my lord, the management, whether the secretary is
I
part of the
understand.
management.
I understand. Because if somebody has the power to transfer you, that may be used as a tool. That's why may be said to be to come within this.
I'm great. My lord, kindly sees page 164. The powers the secretary enjoys. My lord, who is going to work in what capacity? My lord, the secretary is deciding. Page 164.
Right.
My lord, appointment of contract at page 168. This is their documents. Principal and secretary. So, my lord, the secretary, my lord, they cannot deny is a part of the management. My lord, the secretary is, my lord, not only part of the management, my lord, secretary is my appointing authority. My lord, this is, my lord, one aspect of my submission.
So just stop আমি দেখছি এখন, দেখে না তাড়াতাড়ি। সেক্সুয়াল হ্যারাসমেন্ট অ্যাক্ট বললেই হবে। লাইব্রেরিতে সেক্সুয়াল হ্যারাসমেন্ট অ্যাক্ট। Yes, let us continue.
May I hand up?
Thank you. Yes. Because now I will be seeing the ununderlined portions. So এটা ওনাকে ফেরত দিতে আমি এটা নিয়ে দিচ্ছি। এই বইটা আনি না, হ্যাঁ এখন। Yes. So you say the LCC in any event has jurisdiction. This is one aspect of the matter. Regarding the allegation saying to somebody else, does it fall within the definition of sexual harassment? Let us also deal with that.
Kindly comes to the complaint that I have submitted before the local complaints committee. That is a detailed complaint.
Anything to show that you were present at that point of time?
My lord, it was.
It's hearsay basically.
Heard. No, my lord, I heard.
Acha, let us see that. Page?
My lord, kindly gives me. My lord, 124, my lord.
Yes.
Lord, this is my detailed complaint, my lord. May I read?
Let us come to the relevant portion where it deals with this in your presence or you heard or something like that.
My lord, it is a, my lord, a lengthy document, but.
Acha, let me go through it.
My lord,
Please take your seat. I'll just go through it
kindly,
quickly and then need not expose, I mean, the. What was the date of this offense allegation? The last one? The one which?
My lord, 21st of
June.
June.
It's a very, this is the series of events actually. Very well. What about removal?
My lord, I have been terminated. I have been terminated from the school.
When?
My lord, the termination letter, my lord, will find at page 310. No, not 310.
Paragraph 20. 22nd February 2020.
Page 287. 287. I'm sorry, my lord.
Paragraph 24.
Page 287. Both me and my husband, my lord, by the same letter.
And this impugned order was passed on?
My lord, the local.
I mean,
local
yes,
committee's
LC.
order, my lord, it was communicated on 23rd of May, 2023, my lord. Annexure P 21, page 301 is the forwarding letter. The inquiry and recommendation is at page number 302, my lord. The recommendation is at page number 307.
Have you challenged the termination anywhere?
My lord, for
Lord, there is
challenging
a-
the termination, my lord, I'll have to file a suit, my lord.
A fake
I do not
certificate,
have a
complaint was made, police is
that is a
investigating,
different aspect
challenged.
altogether.
Now,
No, that itself cannot be a.
washing was refused.
Anyway, very good.
So, my lord, first, my lord, even if, my lord, the ICC was constituted properly, my lord, my complaint would shall go to the local complaints committee, because, my lord, this is the secretary and he is coming within the purview of the employer. So the second aspect is, my lord, section 18. My lord, it is not a case that, my lord, from the very beginning, my lord, he has challenged the jurisdiction of the local complaints committee. In fact, my lord, when the local complaints committee shows the petitioner, my lord, he submitted a reply. He submitted not only a reply, my lord, he submitted a written statement. And, my lord, section 18, there is a provision for statutory appeal. If a person is, my lord, aggrieved by the recommendation, my lord, the remedy lies in a statutory appeal. And all these points of, my lord, including jurisdiction, my lord, may be agitated before the appellate authority. And, my lord, the question of bias cannot be made by the petitioner against the local complaints committee, because, my lord, there were two other complaints made by two other individuals against the same person and others before the local complaints committee. In those two complaints, my lord, those two have been annexed. In those two complaints, the local complaints committee did not find or exonerated the petitioner. So the petitioner cannot say that local complaints committee is totally biased against me.
The local committee exonerated the.
Yes, my lord. Two previous, my lord, recommendation at page 76 and 85, my lord, kindly see. '76 inquiry, recommendation at page 83. Exonerating the petitioners and others. Second, my lord, starts from 85. My lord, at page 92. The petitioner and another, my lord, exonerated. So, my lord, the question of bias cannot be raised against the local complaints committee, because he has been exonerated in previous two cases.
What about the power of removal? Whether one can be removed as a penal measure?
My lord, the recommendation of the local complaint.
They have been removed, yes.
My lord, they have removed me, terminated me.
Yes.
My lord, kindly consider.
No, not that. The removal of Mr. Dhor's client, whether that can be one of the measures taken under 13(2).
From the management, from the post of secretary.
Yes.
From the post of secretary.
Right.
My lord, kindly comes to section 13.
3I.
13.
13(3)(I).
My lord, I am grateful. My lord, 3I.
Yes.
To take action for sexual harassment as a misconduct in accordance with the provisions of the service rules applicable to the respondent, or where no such service rules have been made in such manner as may be prescribed. My lord, prescribed under the rules.
Yes. Prescribed under the rules made under this act.
Under this act.
So, as Mr. Dhor was arguing, I mean, that whether this should be not covered by any of the appropriate governments.
not
Because
covered.
it's not, that is also your case on the other point. Because this is, because the other part should apply.
2GII.
2GI, yes. So if that be so, then it has to be the state government.
My lord, in this case, my lord, if the question is, my lord, whether there is a, my lord, a service rule or not.
If there is no
service rule, then, my lord, in accordance with the, my lord, rules, the prescribed rules.
Prescribed rules are not there because state government has not yet framed any rule.
My lord, this is the central rules, my lord.
That is not, in your particular case, the state government rules have to apply. Because the rule making power, if you see, appropriate government, Section 29, central government may make rules in particular period generality, such and such.
My lord, it is only the central government, my lord.
Yes.
And my lord, to my understanding, my lord, these rules will be applicable in all cases. My lord, Rule 9, if your lordship may kindly peruses.
Rule 9 is there, yes.
My lord, except in cases where service rules exist, where the complaints committee arrives at a conclusion that the allegation against the respondent has been proved, it shall recommend to the employer or the district officer, as the case may be, to take action, including a written apology, warning, reprimand, censure, withholding of promotion, withholding of pay rise or increments, terminating the respondent from service.
Yes, that is there.
And he has, my lord, admitted that this is an honorary post he is holding, my lord. He is actually a primary school teacher.
No, the language of Section 29 is appropriate government.
My lord. Lord, the central government may, by notification in the official gazette, make
yes.
rules for carrying out the provisions of this act. In particular, without prejudice to the generality of the foregoing powers. My lord, the following, my lord, the rules.
Now let us come to Section 8 once that has been referred to.
Lord,
here.
Section 8.
Yes.
Lord, grants an audit.
Wait. Because some rule making power is also there under Section 8(4). Right, that's a different aspect.
My lord, that is grants and audit, if your lordship may kindly go.
Yes, yes. And subsection 4 of Section 29 says any rule made under 8(4) by the state government shall be laid and other things. So that is relating to setting up and audit and all this.
My lord.
Good.
So, my lord, under Rule 9, my lord, the recommendation, my lord, the LC is not powerless to pass the recommendation that he has passed. And in any event, my lord, if he is aggrieved by the recommendation of the local complaints committee, my lord, the remedy lies in a statutory appeal under Section 8, read with Rule 11 of the rules, my lord.
18.
Section 18, Rule 11.
Right. Good.
And I also, my lord, have a right, if the recommendation is not implemented, I also have a right to prefer an appeal.
Under 18 itself.
Under 18 itself, my
yes. Good.
My lord, this is my humble.
Thank you. Yes. Yes, Mr. Galib. Mr. Galib, anything you have to add to the victims?
Lordship,
I think just
Lordship, principal issues are two.
Right.
whether, my lord, the LCC had the jurisdiction to deal with the matter. And secondly, the phrase "Faltu mein," my lord, is sexually implicit or sexually explicit phrase. So let me first traverse the first point, lordship. My lord, this LCC, lordship kindly sees, my lord, may I just, my lord, take your lordship to the act. Before that, kindly see who is the petitioner. Paragraph 3, he says, who is he? Primary teacher of some other school and also the secretary of the managing committee of St. Stephen's School. Para 3. In para 5, my lord, the petitioner says that your petitioner secretary of the managing committee of St. Stephen's School, as well as he is the secretary of the governing body of the founder body diocese of Barakpur Church of North India, and the petitioner is elected as the secretary of the Barakpur Diocesan Education Society under Church of North India, and is also the secretary of executive committee of diocese of Barakpur. It is stated that St. Stephen's group of schools is situated in different parts of West Bengal, and the head office branch address is Damdam Sohans. So, my lord, he is also, my lord, some office bearer with the diocesan also. So, my lord, this was a point which was taken before the LCC, that the internal complaint committee which was constituted was in contravention of section 4 clause C of the act. In their, my lord's, usage of word, this outsider or something they said, outside member. It's a question of semantics, lordship. So, my lord, my learned senior friend was pleased to submit with your lordship that one person from diocesan represented that particular category of member in the ICC. And subsequently, my lord, it was reconstituted, replacing that gentleman by some other person, what this is. But the question is, my lord, despite the existence of an ICC, whether LCC has the jurisdiction to deal with the matter. If so, when? My lord, kindly sees section 9. My lord, any aggrieved woman may make in writing a complaint of sexual harassment at workplace to the internal committee, if so constituted, or the local committee, in case it is not so constituted, within a period of 3 months from the date of incident, and in case of a series of incidents, within the period of 3 months from the date of last incident. So, my lord, my learned senior friend, Mr. Kormokar, my learned friend, if he comes up with a resolution that when was it constituted, was it within 3 months? Because my learned friend, Mr. Kormokar,
no, allegation has to be, I made the same mistake first. Allegation has to be within 3 months. Anyway.
Incident.
Anything else, Mr. Khalif?
Within a period of 3 months from the date of incident.
What incident?
That incident of that sexual harassment as alleged in the complaint.
So what is the nexus with their constitution?
Lordship?
It will take much time. So please continue. Let us continue. Yes.
Or series of incidents within a period of 3 months. My lord, lordship kindly
we have to add anything to Mr. Noshko's point.
Lordship, page 302 kindly sees, page 302. Kindly sees, my lord, the part she stated accordingly. That portion.
Yes.
Heard a lewd comment about her character passed by opposite party when she was coming out from the office of the prince on 26 November 2022. If this is to be considered as the last date of incident, my lord, 3 months.
Yes.
My lord, the complaint to the managing committee, which my learned friend Mr. Kormoka has referred to at page 194, if it shows that she lodged the complaint with the managing committee, that still shows that there was no ICC, as because My lord, if your lordship sees section 19, if your lordship sees section 19 of the act, my lord, clause B, kindly sees every employer shall, kindly sees B, display at any conspicuous place in the workplace the penal consequence of sexual harassment and the order constituting the internal committee under subsection 1 of section 4. So that display should have been there in the conspicuous place of the workplace. This shows.
Yes,
Lordship.
definitely it should have been.
And second, my lord, when does the LCC can take up?
When, Mr. Gali?
Kindly sees, my lord, section 6.
Yes.
Every district officer shall constitute in the district concerned a committee to be known as the local complaints committee to receive complaints of sexual harassment from establishments where the internal complaint committee has not been constituted due to having less than 10, or if the complaint is against the employer himself. My lord, kindly sees, my lord.
Mr. Galib, let us do some value addition here.
Para 30.
Because we have a time crunch. I'm being very candid. I requested you to add to Mr. Supreme Noskor's arguments, whatever is there to add. And what do you have to add?
No, the
I'm
petitioner.
sorry, yes.
The petitioner himself is claiming to be an employer in paragraph 34.
Yes.
This is.
Yes.
So employer definition.
If this applies, then employer, he comes in.
And my lord, clause G of section 2.
Right, right.
This is where I mean, lordship. So even if there is an ICC, see the petitioner himself is claiming in paragraph 34 to be an employer.
So then it comes in.
So
LCC comes.
if the very mean of complaint is against the employer, LCC can take it up directly.
Right.
And my lord, regarding this comment, lordship will get the definition of my lord sexual harassment, section 2, clause N.
Seen it, yes.
And Miller section 3.
Right. True.
And Miller, the recommendations, Miller. My respectful submission is, it is Miller app 11 and section 18. Read with section, rule Miller. Rule Miller 11.
Right.
So Miller, these are my respectful submissions.
Thank you. Yes.
Just one.
Please, my lord, judgment passed by a coordinate bench on this issue.
Yes, before Mr. Dhar starts.
It is an unreported judgment, my lord, I'm giving a copy, sir.
On what point?
My lord, on this point, my lord, whether it will go before the LCC with the definition of employer, but the coordinate bench says that this requires a fact finding, and the report will not go into the fact finding, and the appellate authority, my lord, was.
Yes.
Paragraph
22?
24, my lord.
24. Twenty-four. 24 is something else.
Twenty-eight, my lord, subparagraph 14, 15, 16, 17.
Which act was this?
The same act of 2020.
Right. Very.
And Miller kindly takes note of section 16 provides whether the identity of the agreed person is to be Miller.
Identity of the agreed person is
undisclosed. Lordship, akin to section 74 of JJ Act, Juvenile Justice. Kindly see section 16 provides
juvenile justice.
As the identity under the is not to be disclosed
Similar.
under section, it's akin, I find Miller, section 16 provides you kindly see. Section 16. without disclosing the name, address, identity.
Thank you for this. Thank you.
Not sure.
I have only one sentence to say.
Yes.
There was a good point taken by my learned friend on the definition of the employer. When Lordship looks at the Roman 2, three things: management, comma, supervision, and control. It's not or.
Employer definition.
Employer definition, he took a point because I referred the head in G
Yes.
Roman 1.
Right.
He referred Roman 2. In Roman 2, Lordship may see there are three components. One is the management. It's not or.
No.
Second is the supervision, and third is the control. So therefore, put together these three, it is always head. That's why it is similar to head.
But Mr. Dhar, one covers only appropriate government. Why not? I mean, in relation to one, G1.
Yes.
In relation to any department.
There is a possibility. I don't deny that. There is a
this unit may qualify unit only or
there is a possibility because I missed that point. So I said there is a possibility.
So we thought that it was referring to only the unit or branch.
True.
Maybe.
True.
Maybe regarding the whole thing before that.
I was trying to draw inspiration from one while interpreting two. Even if it is for someone else, one equals to head. Now two equals to what? I said two equals to three components. Now these three components, it doesn't stand separately. It's not that someone who has a part in the management minus supervision and control. He has to have three things. But this is my response to this. Now there was on findings was never given to me. There was no response to that. All I say, my lord, today we are before your lordships, my lord. It is possible because it's a matter of interpretations. But if your lordship look at the balance of convenience and inconvenience, one is that I stand removed from today itself. Another is that lordship finds that I have a somewhat arguable good case. So in that way, there is a probability that, my lord, I have an arguable good case seeking a stay of this order. Lordship may decide on the legal issues on the 2013 Act. I'm not saying that any of the points is absolutely invalid, but equally there is a validity of my submissions also.
This deposition and all have you annexed here? Deposition of Anupam.
My lord, in fact, my lord, may I seek? In fact, none of the copy was given to me. After filing the writ petitions, I made a letter. Just couple of days before, I have been able to get the copies. I have an excellent point, but I am not disclosing it because I have a fear that that would be changed. So my instruction is to seek an order if the records can be produced. But I am not saying my point because that will show everything.
What about appeal? Availability of
Section 18
apart from jurisdiction. If jurisdiction fails, then appeal.
So far as section 18 is concerned, I feel that the reference of the rule and there is a standing order. If lordship kindly have a look at 18, I don't think there is really a appellate forum being formed. I don't think so, but I have to. So I know that because I have had the, my lord, because what has happened, my lord, there is an appellate authority, what they are referring to.
That is not
no, that is, they are referring to an appellate authority formed under the rule. But anybody from a state establishment, they do not receive that petitions. That was my argument. In fact, my lord, if the matter at all comes in the hearing, my lord, we may be able to apprise your lordships that it requires an interpretations on that. Firstly, there is actually no appellate authority. Secondly, my lord, there are hundreds of judgments on this point because I am questioning the very jurisdiction of it, and I took that point in my letter.
Joint Secretary, Labor Department is the appellate.
There is a
Joint Secretary, Labor Department.
under which rules?
211. It says, my lord, that under section 2 of Industrial Employment Standing Order,
And I have some genuine doubts because of having appeared in some matter and this question having cropped up.
No, but appeal, it's there.
I know it is there, but I don't think there is any single example of any of the state establishments or geographically establishments situated in the state of West Bengal has been taken up by them at all. Leaving.
We have filed subject to
Hmm? You can say that. You say that.
In fact, my lord, in a public interest litigation, which Mr. Orogar-
But that created problem in one public interest litigations without seeing anything. Probably the honorable division bench simply made a comment that there is an appellate authority and nothing further. But possibly it was not after seeing the document, but that I may address after seeing any
Mr.
notification.
Dhar, if I admit the matter for hearing,
Yes.
then I don't intend to pass any interim order. Or I can decide it, outright.
Lordship may decide it outright.
I think that will be easier for because
Lordship may
if
decide
there's no
it.
interim order,
Yes,
it
yes, yes,
becomes
yes.
meaningless
Yes,
for
yes,
you.
yes.
Do you have to
True.
do you have to disclose anything else apart from this? I mean, any relevant document? I cannot go into new facts, obviously, or facts. Mostly here. So I'll close arguments. I'll try to be very fast, Mr. Dhar, but
But
I'll-
only one document that page 311,
Yes.
that dictionary. I have that page of the dictionary I have used because they have translated as cheap. It is basically useless.
I am rather surprised because in any event, I think for them also it should have been heard at length. The only allegation to which it was restricted, the committee was restricted, was this lewd comment. But there is a backdrop to this entire thing, which she has made an elaborate.
But all were found by the LCC in the other proceedings, all not substantiated. Page 83. Because there are other comments which are apparently very against me. I have sent, starting with the word hot. Those are all found page 83.
Regarding the other
Yes,
complaints.
Yes.
Lord, page
Because
103.
all persons who are facing the terminations, they made also page 83, Lordship will see.
That's it.
It is there.
And Lord, the three.
So that's the reason I have
complaints-
not gone to the entirety because otherwise, yes, it could have.
Anyway, we have to restrict ourselves to this.
That's the reason.
This comment.
That's the
only.
reason why I
Because
restricted.
that is the LCC has
Yes,
decided on that. one.
Yes, yes. And
Lord, page 103.
83, I actually have
83.
that's marked.
Lord-
But the only consideration of the LCC was, in your case, was
Yes.
this lewd comment. I mean,
Lord, taking into consideration the other aspects.
you have no challenge.
And the very person who said I said so,
Yes.
paragraph 29, I said that I was not even allowed to cross-examine that person.
Lord, the name of
But
the
in the
three
report
complaints,
below-
your lordship would find at page 103.
I won't go into that much. I will. So I'll have to restrict myself to the LCC consideration.
Yes.
So that
Lordship,
was.
may I file the report, my lord, given to me by the District Social Welfare Officer, respondent number.
What does it say, Mr. Gali?
Regarding the point of cross-examination, it says that he declined to cross-examine the complaint witness in every occasion, and it was recorded by the presiding officer as well.
But that is the record I wanted to actually say. This is
declined to
concocted
cross-examine.
and it was not even there. And page down.
So, my lord, may I?
I won't
file-
take that on record, record, Mr. Gali, because I did not direct it. I won't take that. That would be taking a particular view. Then I'll have to direct them to
Take
give a reply,
exception.
rejoinder and all
Take
this.
exception to
So that will be a factual inquiry also. I'll decide mostly on jurisdiction and also apart from jurisdiction, in a sense jurisdiction, I mean, whether it's palpably, I mean, unreasoned or arbitrary, the other aspects of it. Very well.
Deeply obliged.
Hearing is concluded, judgment is reserved.
Great.
ওই বইটা শুধু পড়া বইটা শুধু পনেরোটা তাহলে 15 বাদ দিয়ে করি তো তখন বললে তো ধরতে পারতাম ওকে এখন বলে আর লাভ কি চলে গেছে আচ্ছা 15 বাদ দিয়ে ওটা করে দিলাম 15 যে বলেছি তারটা শুধু 15 হবে বাকিটা yes call on the next
4 I am for the petition, my lord.
yes
My lord, I mentioned the matter.
you are for the
State Bank of India
Right.
and
My lord.
other officers.
My lord, I mentioned the matter before, Lordship, order please to allow my prayer, my lord.
What is the matter, please?
My lord, the matter is urgent because, my lord, tomorrow is the date of auction of the vehicle. My lord,
What is your ground?
ground, my lord? The vehicle was purchased by me after taking loan, my lord, in 2016. My lord, two loan, my lords. My lord, I have paid already, my lord. Out of 14 lakhs, my lord, I took 14 lakhs. I have paid 19.54 lakhs till date. My lord, 27th July, they forcibly seized without recovery proceeding. No proceeding have initiated. Forcibly seized, and now immediately after, my lord, on 1st or 2nd August, my lord, I made a prayer before the bank, 1st of August. I offered 5.20 lakhs again. You accept this money and settle the matter. Mala, you will also kindly come to page 22. Forcible seizure is at page 21, 27th of July, 26th of July 2023, without the recovery proceeding, without any proceeding. And 22 is my representation for OTS, one-time settlement. My lord, I pray, my lord, mode of payment, you will also kindly come to, my lord, page 23. I think what is a better, it's a better offer. I think it can be.
When is the sale scheduled?
My lord,
Auction is scheduled tomorrow.
Tomorrow.
520, if they agree, I cannot compel them to agree.
But they can, and your most surprising, my lord, when I approached the respondent of 4, my lord, the assistant general manager, he accepted, yes, he take 4 lakhs and release the vehicle. And respondent of 5 and 6 says, no. We have already settled to sell the vehicle by auction. But kindly see, I offered 5.20. AGM says 4 lakhs. You take and release the vehicle of the
chief manager prevails over the assistant manager. What can be done?
What can be done, my lord? This is the way.
That is the hierarchy.
No. 4 is the higher one.
4 is the assistant general manager.
Assistant manager. And chief manager, my lord, you also can see the same building.
Very well. Yes,
4 is the higher
let us
officer.
hear them what they have to say.
Yes.
5,20,000 what to say.
Has come, they say everything. When when account is NPA, then there is no other option but go to for auction.
This is already an NPA account. Obviously, it's
Or
an
NPA, already NPA, my lord.
What is the notice? NPA notice has not served.
NPA.
No. I have
So
not
5,20,000 is not acceptable to you.
Now it is due and payable more than 9 lakhs.
More than 9.
9 lakhs.
If they don't accept
Total
sir,
public money.
My lord.
No.
I have offered.
compel them to accept.
I have offered 5.20.
No offer is accepted as
No, Mr.
because
Samantu, I
no
cannot.
officer has come. My
Who
lord,
has come?
And
officer, bank officer.
What will the officer do? You were there.
And the auction price is fixed, my lord, 6.28 lakhs. 6,20,28,000. Your logic can I shall make payment 6.28
Can meet the bid, highest bid. I'll give that liberty to you. If you meet the highest bid, they'll sell to you. Sell back. to you. They'll take that amount, not sell back. They'll take that
I have
amount and
come
give
before lost on 2 grounds. Number 1, my lord.
match the highest bid. Match the highest bid tomorrow. They'll be giving you an offer to match the highest bid.
I have already, my OTS PR has not been decided. That is one of the reasons.
They are deciding. Their officer is there. For that reason only, your learned friend is saying his officer. But he is conveying the communication that he does not agree.
4 says accept it. 5 and 6 says.
At order.
Your lordship kindly.
Petitioner's vehicle.
Kindly allow me to participate in the auction, my lord.
The petitioner took a loan from the respondent bank but failed to repay the same after paying some amount of the dues. Full stop next para. Learned counsel for the petitioner submits that the petitioner's vehicle was unlawfully seized without any appropriate order. Full stop upon the petitioner offering an amount of rupees 5,20,000, the same was not considered by the bank. Full stop, it is argued that the petitioner is ready to pay to repay the amount due by easy installments. For some next para, learned counsel for the bank submits that the account of the petitioner was already rendered non-performing assets asset within bracket NPA, bracket close, full stop. Hence, comma, only upon taking an inventory, comma, the bank sees the vehicle and has put up the same for auction tomorrow. Full stop. Next para, it is submitted that on instruction, comma, the bank does not agree to the amount of rupees 5,20,000 offered by the petitioner. Full stop. Next para, at this juncture, comma, learned counsel for the petitioner contends that the petitioner is agreeable to participate in the auction as well. Full stop. Next para, heard learned counsel for the parties, full stop. The court cannot compel the respondent bank to accept the offer of partial repayment, full stop. Next para, however, comma, it would only be fair if the petitioner is permitted to match the highest bid in the auction sale, full stop. Better still, comma, since the petitioner seeks to participate in the auction sale as one of the bidders, comma, there is nothing to prevent such participation on the part of the petitioner. Full stop. Next para, is there anything in law to prevent him if he participates in the auction? Next para, accordingly, WPA 21476 of 2023 is disposed of by granting liberty to the petitioner to participate in the auction sale of the vehicle of the petitioner, which is going to be held tomorrow, comma. Alternatively, the bank shall give an opportunity to the petitioner to match the highest bid which is received by the bank in the auction sale prior to transferring the vehicle in favor of third party. Full stop. No less to cause certain.
Five.
Five, who is for the petitioner? Yes. Mr. Haldar, what is the matter?
I appear on behalf of the CSC.
Right.
The tenant applied for new electric connection.
Landlord served?
The landlord has no problem. And
Please file the affidavit of service. Yes.
Mala
Mr. Mukherjee.
CSC, only CSC is the party.
Affidavit of service, you have to file in every matter. Something has to be on record. Yes.
Landlord is not a party.
Have you served the CSC?
Yes.
File the affidavit of service.
Affidavit is not.
Yes, what is the matter?
My instruction on 17th of October 2022.
Is it a collusive matter, Mr. Haldar? You are not
No.
ready with the affidavit of service.
Usually CST matter, they appear. Usually all matters, they appear.
Yes, Mr. Mukherjee, you agree?
I issued a notice for splitting of load, my lord. This is in respect of a property which is there in Terity Bazaar, my lord. That unfortunately, that notice is not annexed.
That has not been received by my
The
client.
petitioner submits that the petitioner, being a tenant, applied for an electricity connection. Full stop. However, comma, the CSC Limited has not yet given such connection. Full stop. Next para, learned counsel for the CSC Limited submits that the CSC Limited has already written to the petitioner disclosing that there is an apprehension of splitting of load. Full stop. Next para, learned counsel for the petitioner disputes the contention that such a communication has been given to the petitioner. Full stop. Be that as it may, comma, since the CSC Limited specifically opposes the electricity connection of the petitioner, comma, on the ground of splitting of load, comma, the matter falls for consideration before the appropriate authority, that is the concerned grievance redressal officer, bracketed GRO. Full stop. Next para. Hence, WPA 15771 of 2023 is disposed of by granting the petitioner liberty to approach the concerned GRO for resolution of the dispute. Full stop. If so approached, comma, the GRO shall decide the issue in accordance with law, preferably within 6 weeks from the date of approach of the petitioner. No rest to cause.
I'm grateful.
Thank you.
6.
May please lordship, I am for the petitioner.
Yes.
I have served. Last occasion they appeared. And my lord,
Come back tomorrow. Proper service. Same heading kal thakbe. Not today. Same heading kal thakbe. Porte rakho.
7.
Educator. They have this is the application for shifting of transform from the premises of your petitioner to today they have given the copy of the report. Let it be tomorrow.
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 A report is filed by learned counsel for the CAC Limited, handing over a copy of the same to the learned advocate for the petitioner, on the prayer of learned counsel for the petitioner to prepare
Can it be on Wednesday?
to take instructions on the report, let the matter stand adjourned till September 6, 2023, when it will be listed under the same heading.
এটা কি আছে?
এরকম জায়গাতেই থাকবে বুধবার।
এটা তো বিট সার্ভিস আছে।
Yes.
8,
আগের দিন টাইম নিয়েছো।
Yes.
Petitioner is a consumer of electricity paying bill. They have disconnected the electric line of the petitioner.
Does the private respondent have any notice that you have mentioned out of turn?
No,
Because
no, only WBACP.
No, Sanjeev Shet appeared for the private respondent. Give a notice, come back tomorrow.
Last occasion I have said.
So give a notice, because you mentioned these electricity matters to be taken on a day. I said
But
this.
it is in the lease. It
Even
is
then,
in
what
the
is your
lease.
dispute? You are the tenant.
I am the tenant and my electric line has been disconnected by the CAC authority. But no dues is.
Yes, what is the matter, Mr. Nayak?
He has totally suppressed the fact. His paragraph 3 says he is residing, he was a tenant, his father was a tenant in respect of 3/3 Ramakrishna Mandir Path Road, Howrah. Then he has been subsequently evicted from the premises. Then in respect to a particular room, and that was 3/3, and meter is installed there. Bailiff came and bailiff ousted them, handed over the room to the landlady, who is landlord, who is number 4. Now they are residing in 3/3/1, and they were deriving electricity from 3/3 to 3/3/1 unauthorized abstraction electricity. Now they have been totally ousted. They are non-existent in respect of 3/3. That belongs to the landlord, because after the decree, bailiff came, bailiff ousted them, handed over the position. Now they say it has been disconnected on the request of the landlord, who has taken over the position, who has been delivered the position. We had to act on that. This is disconnected in September. They have been ousted. They are totally false statement. Their meter is at 3/3/1, paragraph 3. Kindly see the bill they have annexed. Meter is at 3/3. Where the room is, they have been ousted from the room in September. Bailiff delivered the position to landlord, and they want to stay in 3/3/1, and they want
So
to.
they are wanting a shifting of the meter.
They have not been a prayer for that after September. In September, they have been ousted by the bailiff. Position is handed over. Landlord requested that he remove it. We have decided.
What about this? You have suppressed this?
No, there is no submission. The building was, the premises was one, and after that.
You suffer an eviction decree?
My lord, that I have to instruction.
What instruction? Bailiff is here, decree is here.
Have you got a copy of the decree? I'll impose costs on your client.
No, my lord, I have to take instruction. Let it be tomorrow, my lord.
No instruction. If it
My lord,
hands over a copy of the decree,
my lord, I am the
Bailiff order and all these execution.
please just hand over. I'll keep that on.
Kindly. Center. তোমার মক্কেল তোমাকে না দিলে
না বললে
দিতে আনতে পারে। You knows all this.
Your client does not know.
They have been ousted from the room. Bailiff came, thrown them out.
Mr. Haldar, I'll send an officer today itself.
Well,
if it is found that he is not there, he'll be directly behind the bars. He won't get an opportunity.
My lord,
he won't get an opportunity to bring his toothbrush. I'm telling you.
My instruction is, my lord, no, that incident has not been happened. So my lord will free to do.
Look at this. Look at this.
I know that. I have asked the client in front of my lord.
Call him here towards me.
আসুন।
উচ্ছেদের ডিগ্রি হয়েছে আপনার বিরুদ্ধে?
আমার বিরুদ্ধে উচ্ছেদের ডিগ্রি হয় না।
কার বিরুদ্ধে হয়েছে?
ওটা আমার ভাইয়ের বিরুদ্ধে হয়েছে।
আপনি সেখানেই থাকতেন?
আমি সেখানেই আছি।
3/3 তে কোনোদিন থাকতেন?
3/3 তেই থাকতাম।
এখন কোথায় থাকেন?
আমি এখন ওখানেই আছি।
পেছন থেকে কে আপনাকে প্রম্পট করছেন?
ওটা আমার স্ত্রী।
ওনাকে ডাকুন, যদি আপনি কথা বলেন তো আপনার সঙ্গে বলি, নয়তো উনি যদি বলেন তো ওনার সঙ্গেই কথা বলি। 3/1 এ কে থাকেন?
আমরা 3/3-তেই থাকি।
3/1 এ কেন আপনার মিটার রয়েছে?
আমাদের মাটির বাড়ি ছিল, মিটার দেয়নি এখানে। 80 বছরের বাড়ি তো।
File an affidavit, Mr. Naik. Learned counsel for the petitioner submits that the petitioner is a tenant in respect of the property. Full stop. Next para, however, comma, the CAC Limited disconnected the supply of the petitioner without any reason. Full stop. The petitioner seeks restoration of the same. So next para, learned counsel appearing for the CAC Limited submits that the petitioner has suffered an eviction decree and was ousted from the concerned property, that is premises number 3/3, Ramkrishna Mandir Path, Howrah, PS Batra, Howrah 711101. Full stop. Next para, as such, the electricity supply was disconnected in due course. Full stop.
On the request of
Next.
landlady, my lord.
Next para, it is submitted that such disconnection was effected at the behest of the landlord. That is private respondent number 4. Full stop. Next para. Learned counsel for the CAC Limited also files photocopies of documents, inter alia, including the order dated September 15, 2022, passed in title execution case number 64 of 2022, which indicates that the bailiff was directed to execute the writ of possession against the petitioner. Full stop. September 26, 2022 was fixed for filing of report by the court bailiff. Full stop. Next para. An order dated September 26, 2022 discloses that the bailiff submitted his report and it appeared from the same that the writ had been executed. Full stop. Next para. The execution case was accordingly disposed of in full satisfaction of the decree. Full stop. Next para. Since the petitioner is personally present in court along with his wife and submits on query of court that no, they were never ousted in pursuance of any eviction decree. আপনার বিরুদ্ধে কোনো eviction decree হয়েছিল কি? And no eviction decree was ever passed against the petitioner, the matter requires immediate inquiry on the part of the court, and if it ultimately transpires that either of the parties are making incorrect statements before the court, serious implications are to follow. Full stop. Hence, learned counsel for the CAC Limited is directed to file a short affidavit, annexing the documents handed over in court today and vouchsafing their veracity. Full stop. Such affidavit shall be filed on the next returnable date with an advance copy to the petitioner's advocate. Full stop. The petitioner will be entitled to file a rejoinder to the same and also file it on the next returnable date. Full stop. Such report shall be prepared and a copy thereof be served on the petitioner within September 15, 2023. Full stop. Rejoinder thereto, if any, shall be filed on the next returnable date as indicated above. Full stop. The matter shall next be listed on September 25, 2023 at the top of the list.
My lord, deeply.
Mr. Halda, please indicate to your client the implications if he is wrong. Do you have other copies of this?
Lord, no, one copy. No, Lord, let it be there, my lord.
Please take other copies and annex those. I'll keep this on record because I've relied on this.
Grateful.
Mr. Halda, please try to give a notice to the landlord also in the meantime, so that he's present on the next occasion. Yes.
9.
I am for the petitioner.
Yes.
It's for rerouting of the electricity line, high tension electricity line given to my residence. It's been, if your lordship come to the page number 24. I'm filing the affidavit of service.
Thank you. All have been served?
Yes.
I am for the state respondents.
Oh, right.
There's a page number 24 is a plan. The dotted lines in the arrow lines in the middle shows that the currents have been given from the backside of the road. And there is a front road in front of my house. The consequence of giving the connection from the backside, Lordship will turn the next pages. You'll find the high tension electric line is lying down on the ground courtyards.
This is your courtyard, obviously.
Yes, my lord. Against, and we're crossing the fence, the next page, number 27.
When was it installed? Recently?
It was done in the 2008. We are repeating, making a request. It had not been done yet.
When it was being done, did you oppose?
Yes, my lord.
Or subsequently you were asking?
If there was an order also, my lord. My father was a late father, was a writ petitioner. He filed this. 2008 was disconnected. They were not restoring for the reason known to them. Even we requested to give the connection from the front side. They refused.
Oh, this supplies electricity to your premises itself?
Yes, my lord. Your lordship, come to the page number 22. And
so you are wanting a shifting of that line
from the backside to the front side, giving relief to the also to the backside neighbors.
You are agreeable to pay for that shifting?
My lord, there's all connections are given from the front side, each and every houses. There are poles also.
But at the relevant juncture, if it was done in 2008, now then you have to, you are ready and willing to accommodate a space for that. I mean, the front side means is beyond your premises. You now want
front of the premises. The connections have been given from the back side.
Now you want it from the front side.
From the front side.
From the front side means not in your premises.
From the road.
On the road.
From the road.
Yes. What do you say, Mr. Naik?
My lordship, come to the page number 22 and 23. There was an order earlier also.
Right.
Page number 23. However, for the second paragraph. However, I make it clear that for purpose of the supplying electricity to the petitioner in terms of the order, respondent number 7 will not draw any electrical line through or over the exclusive owned property of the private respondent, and such electric line should be drawn through or over any public road, street, or common passage apart from exclusive owned property of the petitioner.
So this is your exclusively owned.
Yes.
You are the petitioner there.
Yeah, I'm the petitioner over here at present. And the front side connections have been given, can be shown.
This was passed long back. The connection was given the same year.
2008, and we are
Why do you wait
running
for so
a
long?
pillar and post managed for the petitioner. They come to me and said it's a very simple thing. We have to move the application. That's all.
But your delay is very, I mean, telltale.
No, there was a objection given by somebody saying that the front portion of the road in front of my house belongs to them particularly. They are still, but it has been used by the public for 50 years. And there is a report to that extent, my lord, if your lordship
But
comes
Mr. Mukherjee, 15 years waiting for
50.
Waiting for 15 years. This order was passed in 2008.
And there was a litigation going on saying that you cannot give connection, electricity cannot give connection because this portion is a private road.
Litigation between whom?
Between the objector and the...
You were there, a party there?
They had made me a party. There was a RTI even made by me.
Litigation means civil suit.
In a civil suit.
What happened to that?
Injunction was vacated. Because if your lordship come to the RTI I have made, that's page number 32.
Yes.
The relevant portion is the below portion, the following information about width and length in respect of the road and pond under the present ward number 89-131, post Arangata, village Para, Master Para, district Nodia, leading from the Ashok Kumar Bhaumik's shop to the house of Rabindranath Mohori. In respect of the tender given to the Bidhan Ghosh, Akash, and assign a sketch map is a road. It's stated that the road is even being maintained by the government fund. It's not a private road.
Can it be done over the road, Mr. Naik?
My lord, firstly, my lord, so far instruction is concerned, lord, the supply was taken 20 years back by his father, my lord, Amonindranatھ Bhaumik.
There was a direction of a court of a coordinate bench.
My lord, it was disconnected in a storm, my lord. It was disconnected in 2008 or 2007.
No, 2008, he has annexed an order. Mr. Mukherjee has annexed an order.
That was for restoration.
Restoration, but it was stated there,
this
will
order
not
was-
draw any electric line through or over the exclusively owned property of the private respondents or common passage apart
Since my
from...
lord, nobody appeared for the respondents, this was not a protective order, not to disturb anybody's land, but land to be restored.
Should be drawn through or over any public roads or
It is
street or
something,
common
my lord,
passage apart from...
it is something, my lord,
So this is exclusively owned by him, so you have to remove it to, in compliance with that order, you have to put
it
it
is
over...
done. It is line is restored and he is enjoying electricity. But
it was to be restored over a public passage or a road or street,
My lord, that
not
is
over his exclusive property.
in 2008. Now, my lord, I have instruction, he is enjoying electricity. Now he wants shifting. So for shifting is concerned, my lord, twice, my lord, inspection was made and all the, my lord, persons belonging, my lord, having the land throughout, my lord, over his or around his, my lord, this building, they are having strong objection. And, my lord, all these objectors.
So what about public road? If it is from the public road?
My lord, it is not possible so far as report is concerned. I can bring specific report also because Ashok Kumar Bhomik and some Tripathi and others and Mohadev Bhomik, Nileshwar Bhomik, Indrajit Dubey, they all are opposing. They say all the lands that belongs to them. They will not permit WBSCTCL, my lord, to do. If you can arrange, my lord, the space or spot and pay the fees, we have no objection. But that is not done. On spot inspection, it failed.
Well, the front road is a public road. Can it be a private portion, be a private road?
That
An
cannot be
objection has been
decided
given
here.
by the backside objection that is in page number 45 and 46. Page number 45 and 46.
No, Mr. Mukherjee, what happened to the suit exactly? What is the stage of that? What was vacated? Who obtained the interim order?
The other side objector obtained the interim order that this is a private road. Our connections cannot be given from the private road. Actually, this is that portion of the road.
The subject matter of that suit is which property? Not your property
It's
objection.
not property, it's a road. Leads to the road.
So the suit
Somebody
is
is claiming, objectors are claiming the front portion of the public road is a private one. Nobody can give the connection from this.
Then, Mr. Mukherjee, if that is pending, unless that is decided.
No, that is disposed of, my lord. If your lordship want, you can keep it. My lord, that is disposed of. If your lordship can keep it the next week, I can bring the records.
Learned counsel for the petitioner submits that there was an order of a coordinate bench passed as long back as on April 23, 2008, at the behest of the petitioner, that for the purpose of supplying electricity to the petitioner in terms of the said order, the distribution licensee would not draw any electric line through or over the exclusively owned property of the private respondents therein, and such electric line should be drawn through or over any public road, street, or common passage apart from exclusively owned property of the petitioner. It is submitted that despite such order, the electricity connection was drawn through the backyard of the petitioner. Thus, facing electricity hazards, the petitioner sought for shifting of the said line to the front road, over which allegedly other electricity lines also pass. Next para, it is submitted that a civil suit is pending regarding the said alternative passage at the behest of the private respondents, who claim the property to be theirs. Next para. Learned counsel appearing for the distribution licensee submits that upon an endeavor by the distribution licensee, it was found that all other persons having adjacent properties have strong objection to the shifting of the petitioner's electricity line over some alternative passage. Next para. Upon query of court regarding the current stage of the suit and the details thereof, learned counsel for the petitioner seeks a week's adjournment for producing relevant document. Accordingly, let the matter stand adjourned till December 13, 2023, when December 12, 2023, when the relevant documents shall be furnished by the petitioner, including the plaint of the suit, any relevant order passed therein and or other connected documents. Mr. Mukherjee, please produce a copy of the plaint, relevant orders,
Lordship,
whatever.
shall I just draw attention of page number 30?
December 12, Lordship.
December 12.
Sorry, September 12.
Page number 30. Page number 30.
One more objection I have taken, Lordship. His father expired and he has not made any application, my lord, for change of name.
That does not require for the causing the hazards to the behind neighbor is high tension electric line lying on the floor.
While we are on a spree of directing restoration and revival, we shall also consider the case of his father.
Page number 30, my lord.
It is 30.
My lord, one indulgence, lordship, kindly not take amiss of me. Lordship, kindly not use the word adjournment in your lordship's order, my lord.
No,
Lordship can post it in the top of the list on 12.
Otherwise, my lord, we will be facing difficulty.
Top of the list, actually, I will not be there for 2 weeks, so it doesn't matter. I'll go to Jalpaiguri.
No,
So
my lord, I am only just trying to impress upon your
it
lordship.
doesn't matter. That's what I'm saying.
Lordship
The
kindly.
effect will be all
my
the
lord,
same.
it's my humble request. Lordship may kindly not use the word adjournment in your lordship's order. Otherwise, we will be facing difficulty otherwise. Lordship may kindly consider.
What did I say? Adjourned till
Yes, my lord.
My lord, kindly, the matter is adjourned, lordship kindly.
Shall we,
delete this.
acha, the matter stand adjourned na kore, the matter is posted for passing further orders on such and such.
My lord, great.
Thank
I'm grateful.
My lord, I am. My lord, the next matter, item number 11, 10, my lord, the Mr. Udipan Banerjee is appearing for the petitioner. My lord, his son has detected with dengue and typhoid.
When should I
Both-
keep it?
He is admitted to the hospital, my lord.
When should I keep it?
After 1 week, my lord.
I appear for the licensing. I
আচ্ছা
obviously cannot.
পরে ম্যাটারটা একবার বোর্ডে শো করে দিন, একবার কল করে দিন 10
10,
বোর্ড একবার on the prayer of learned counsel for the petitioner, comma, the matter is adjourned till, I'll give you 2 weeks, adjourned till
Grateful, my lord. Grateful.
September 18, 2023. Please come
Grateful,
down.
my lord. Grateful.
নামগুলো একটু রেকর্ড করুন।
Item number 11.
May please lordship.
Yes.
My lord, what happened, my lord, the CSC authority disconnected line on the ground of pilferage.
Right.
In order to get anticipative bail, we have paid already 50%. To my lord, matter be referred to the local. Before that, what I am paying, I am offering to pay 10% more in order to get restoration without electricity, my lord, and the remaining matter will be before the local. The problem will be solved.
Have you preferred any appeal?
My lord, no appeal has been prepared.
What is the scope of this?
My lord, the amount will be reduced before the Lok Adalat.
It is pending before the Lok Adalat?
No, it will be referred to the Lok Adalat. On 9th, it will be heard.
Whenever it is referred, then the Lok Adalat can decide on this. Before this, how can I die?
Before that, my lord, I am offering to pay 10% in order to restore the line.
Yes.
Item number 10, 11 and 13 are to be heard together, Milord. Milord, they are absolutely interlinked. Because Milord,
These are two different.
same address, same course of action, same date, and same type of pilferage. And Milord, the interesting part is that after the connection of this petitioner was disconnected, the petitioner number 13 was caught supplying electricity to this particular petitioner. And Milord, as on date, the total dues in connection with 13 and 11, Milord, having a close nexus is around 1,88,592 after paying 50%.
My lord,
And Milord,
13, the petitioner is someone else.
someone else residing in the same address, and Milord caught while supplying connection to the
This petitioner was taking from the other petitioner.
My lord, let the 13 be called on, I'll satisfy.
13B?
Call on
item number 30.
item number 13.
11 আর 13 দুটো দেখি তো 11 13 দুটো একসঙ্গে 13 কল করে মুখে
13.
My lord, in this matter, I am for the petitioner. My lord, two line has been disconnected. They have finally assessed amount is page 11. My lord, the assessed amount is page 11. That is, amount is 4,640. I am ready to pay that amount. Line be restored.
No, Milord.
That's this is the amount of the pilferage. And next one is, my lord, both the amount I will pay, let the line.
Mr. Haldar, if you are agreeable to pay the amount, why did you prefer the writ petition? 13.
My lord, writ petition 1 in the
I'm hearing 13 now for the time being. In 13, you say you are agreeable to pay the dues.
Yes.
So why did you prefer the writ petition in the first place? Could have done that.
That order be, otherwise they will not accept.
Milord,
Otherwise, they will not accept. I want to pay entire amount of these two petitioners.
Milord, our apprehension is that once the current is being
And that matter.
You are willing to pay the entire amount of 13.
Yes.
Since they have got close nexus having the same address.
So, Mr. Ghosh, on that premise, you cannot withhold electricity restoration. If they pay, you have to pay.
Apprehension
If they do it again, then you will again take.
as soon as the current is restored, Milord,
For that, you cannot deprive them of electricity. That apprehension cannot be a legitimate. So 13 I'll allow. 13 I'll say they'll deposit the entire. Yes.
the entire assessed amount.
And regarding this, what is your stand? If they pay in the other, yes.
Milord, if they are inclined to go before the local Adalat, Milord, we have got no objection.
And before
Otherwise,
that,
they will
so
have to
before-
pay the entire amount, Milord.
Before that restoration, you are not agreeable.
No, Milord,
10%.
because Milord, they have not preferred any appeal. And in council section 127, Milord, 1 month have expired in both the cases. So, Milord, unless the full
So
amount is
this
paid, Milord,
10 you don't get any, 11 you don't get any relief, Mr. Haldar.
Yes.
11 you don't get any relief, Mr. Haldar. 13 you are
to the local.
Learned Council, 11 or 13 action now. The present writ petitions, comma, having arisen from disconnections of electricity supply regarding the same premises, comma, are being taken up together due to such identity of causes of action, full next para. In WPA 18984 of 2023, comma, the petitioners are agreeable to deposit the entire amount assessed by the CSC Limited along with restoration charge.
There are two
petitioners.
Yes, petitioners. Along with restoration charges. Full stop. Next para. Accordingly, WPA 18984 of 2023 is disposed of by granting liberty to the petitioners to pay the entire assessed amounts raised by the CSC Limited in respect of their connections, comma, along with restoration charges and any other legitimate dues which the CSC Limited is entitled to claim in law.
There is no
Full
such-
stop. Upon such payment being made, comma, the CSC Limited shall restore the electricity supplies to the said petitioners within 24 hours thereafter. Full stop. Next para. Insofar as WPA 18979 of 2023 is concerned, comma, the petitioner submits that the petitioner is agreeable to pay 10% of the balance amount, comma, which remains after deducting the 50% of the assessed dues paid by the petitioner for obtaining anticipated bail on the allegation of pilferage of electricity. Full stop. It is submitted that in any event, comma, the matter is required to be placed before the oncoming Lok Adalat, and the petitioner seeks an immediate restoration of electricity connection upon payment of such additional 10% for the time being. So next para, Learned Counsel for the CSC Limited places reliance on sections 126 and 127 of the Electricity Act 2003 and submits that in contemplation of law, comma, the entire amount has to be deposited for getting back electricity connection. In any event, comma, the statutory period of 30 days have also elapsed, comma, thereby preventing the CSC Limited from restoring the electricity line to the petitioner. Next para, since the law contemplates deposit of the entire assessed amount for restoration of electricity, comma, it is beyond the domain of the writ court to compel the CSC Limited to restore electricity supply. However, comma, since the petitioner seeks a reference to the Lok Adalat, comma, for the ends of justice, comma, the matter be placed before the Lok Adalat for resolution, for amicable resolution between the parties. First.
And Milord, in the place of 24 hours, Milord, kindly makes it 48 hours.
48 করে দাও আগেরটা, 24 না করে 48. Thank you. 12টা 12 তারপর 14.
12.
Appear for CS.
Right. Yes, Ms. Halda.
This is, for the petitioner. This is my affidavit, sir. I have heard, my lord, here the petitioner is the owner of the.
Respondent, sir, private respondent.
I heard,
appearing for private.
All right. Yes.
my lord, what I am praying, this is a shifting of meter of their meter from that premises to other portion of the premises. That is.
The meter is in their name,
Their name.
standing in your premises.
Yes, that is our grievance. That be shifted at the cost of the respondent. That is my prayer.
What do you say, Mr.
My lord, so far as this property was originally property of mother, we were occupying, he was given by virtue of a gift, a portion of the property in question.
Demarcated portion?
Demarcated portion, my lord, but that has not been mutated. My lord, so far as common, same holding still exists. Therefore, my lord, the shifting, the meter originally that was standing in the portion that has been gifted.
So let it be transferred to your portion. If there is an alternative, they'll have an inspection. You, both of you will be there. Let us see if it is feasible, subject to hearing, Ms. Rao.
My lord, so far as this is concerned, so far as our meter is concerned, my lord, the one line has been given.
So
by the CSC.
No, the meter is standing in their property, now their portion.
In their portion.
They are wanting a shifting to your portion or somewhere else.
My lord, so far as my meter is concerned, I am ready.
Oh, there are other meters also there.
No, there is 2 meters, two brothers.
One is your meter,
And at
both
the
going from the same meter room.
same return room
Meter.
and the same portion. It will be shifted, their meter.
Shifting 1 meter in isolation, is it possible? Let us hear this.
1 meter now. Meter, there are 2 meters.
2 meters housed in 1 meter room located in your premises.
That is the question.
One is your meter, another is their meter.
Yeah.
You are wanting their meter to be shifted to their portion. So in isolation, that is called isolation. In isolation, whether that can be done, let us hear from the CS.
First item, number 5 is, I think, Shankar Pachar. He is
Anand
no
Pachal.
more. His
Anand
wife-
Pachal is the petitioner.
Number 5 respondent. I think.
How did you serve him?
No,
That's an
no,
interesting proposition.
1 second. Number 3 is his wife. She has applied for shifting. My lord, but my lord, it was not in the right format. Now she said,
Three has applied for shifting.
yes, she had.
So who is petitioner? Who is the petitioner?
Must Anandu.
No, Anand, how is he related to them?
I don't know how they are related, my lord, but
Hmm.
now my instructions are we will shift. If Krishna Pachal makes an application, my lord, that should be for a new service connection, then we'll shift. But they have to make an application, no proper application now before us.
They have to apply.
Sure, Krishna has to apply. She has applied for name change.
No, if they agree, can it not be recorded here? I mean, is it so insurmountable that if I pass an order of court, that let it be shifted without their application? On his application, he'll have to pay. That is not possible under your rules.
His application, my lord, actually he wants Krishna to go out.
Yes.
So if Krishna has to
Now,
go out,
I am hearing both sides. Suppose if I resolve the issue by passing an order in this court, in this matter, that you will shift. He will pay the expenses. Is it possible or insurmountable? He'll pay the expenses. Is it possible at all? I mean, that is what I'm asking. If it's possible, sir.
I do not think so. That is not the instruction. The instruction is she has to apply. Krishna
Miss, Mr. Aldar, you cannot apply. You cannot seek for. Mr. Mitra, can you apply if I give you that liberty? We give you that direction, but they will pay for the entire shifting charges. I'll direct you to apply.
Well, my client will apply.
Your client will apply. They'll pay the expenses.
My lord,
Is it possible? No. They'll have to apply.
new service.
For new service.
New service. Yes.
Prices.
New
Yeah,
service.
But
new
the
service.
premises is.
No, the meter has to be shifted only.
Single meter per
It would be as a new service.
Till date, my lord, the holding is of one premises.
No, they have not this problem. What is your issue? Learned counsel for the petitioner argues that the mother of the petitioner was the original owner of the property, which subsequently a deed of gift was made by which the concerned portion of the property, comma, which houses the electricity meters at the premises, comma, was allocated to the petitioner. First up, now the petitioner seeks a shifting of the electricity meter of the private respondents to the latter apostrophe S portion, comma, from the said meter room. First up, next para, learned counsel for the CSC Limited submits that the CSC Limited has no issues with such a proposition, but the concerned consumer whose meter is to be shifted, that is the respondent number 3, comma, has to apply. First up, next para, learned counsel for the respondent submits that although a portion of the property was gifted to the petitioner, comma, the petitioner did not obtain a separate mutation and the property stands as it is. First up, next para, since the CSC Limited is otherwise agreeable to shift the electricity meter as a new service connection in the name of the private respondents, comma, it is immaterial whether mutation has been obtained by the petitioner or not. Full stop. Next para. It is only fair and proper that, comma, since the portion where the meter room now stands falls within the property allocated, gifted to the petitioner, comma, the electricity meter of the private respondent number 3 is transferred to the latter apostrophe S portion of the premises. First up, the said arrangement would be proper from all aspects, comma, including to obviate any future dispute between the parties regarding the electricity supply. First up, next para. Hence, WPA 18983 of 2023 is disposed of by directing respondent number 3. Only 3 is the consumer. Respondent number 3 to apply for shifting of her electricity connection from its present location within the premises gifted to the petitioner to the portion exclusively occupied by the respondent number 3, full stop, upon such an application being made, comma, the CSC Limited shall effect such transfer, comma, by way of giving a new service connection to the respondent number 3 at the latter apostrophe S portion of the premises. Full stop. The initial shifting charges shall be borne by the present petitioner. Full stop. Initially, the respondent number 3 shall make such application within a week from date, and upon estimate being duly raised by the CSC Limited, stroke quotation being issued, comma, the respondent number 3 shall serve a copy of the same of the petitioner for the petitioner to make the necessary payments. Full stop. Upon all formalities being thus complied with, comma, the CSC Limited shall effect the shifting of electricity connection to the portion of the respondent number 3, comma, preferably within a fortnight from the date of completion of compliance of formalities. Full stop. No orders to cause urgency. Thank you. Mr. Mitra, you will apply within a week. Within a week, hand over to him the quotation. When they raise it, you will pay. Thank you.
14.
Yes.
My application.
May we please your lordship.
I pay for the licensing company, CSC. My affidavit of service, my lord.
What is the matter, please?
My lord, I have
Well,
applied.
I am for the respondent number 4 and 5. Well, I prefer 1 week adjournment.
No, no. Why? Electricity? No, no.
This is an alternative accommodation. Here's the principal accommodation. This is the electricity. This is the alternative accommodation.
No, no adjournment. Yes.
My lord, my application, I have made an application for installation of a new electric meter for domestic purpose. I have been, lordship, they have made the payment. We went for inspection, but the applicant was not available on 2 occasions. They have to identify the meter board. Otherwise, we cannot give them the supply. If they identify the meter board, then we are in a position.
Why have you implicated
My
the
lord.
private respondents?
My
What is
lord,
their role?
my lord, on in the month of March, the CSC had visited the premises, but there was an obstruction from respondent number 4 and 5.
Who are they? Who are they?
They are the uncles of the petitioner.
Reside in the same premises?
They reside in the same premises.
No.
Premise of their objection?
Nothing.
Achha, let us hear them then. I'll hear them and come back. Yes.
Lordship,
Well, what happened? Actually,
One minute. 1 minute. Yes.
it's not the meter board, the main switch. We are going to give them the meter, but they have to identify the main switch.
Very good. Yes.
well, kindly see the page number 13 of the writ petition.
Right.
It is in the name of one Nur Muhammad. Nur Muhammad.
Yes.
Nur Muhammad is the father of the respondent number 4 and 5.
Right.
Nur Muhammad died in the year 2017. And prior to the death of the Nur Muhammad, the mother of the present writ petitioner died. That is the page number 16 onward.
How are they related with you?
Well, I am the maternal uncle of the petitioner.
Very well then.
Mama.
Then?
And since the mother of the petitioner died prior to the death of the Nur Muhammad, that's why he has not inherited the property. Just to get the property, he has filed this writ petition.
How can they get a property by way of an electricity connection? Unheard of proposition.
My lord.
He is not residing there. He is
My
not
lord.
residing. My lord, kindly see where her mother died. Kindly see the address from the page number 16. 5 Tatibagan Road, page number 16, my lord.
Yes.
This is the permanent address, 5 Tatibagan Road, PS Beniapukur, Kolkata 14. This is the address of the mother. This is the address of the son.
Mother's address is immaterial. Please come to page 17.
My lord, I have seen that we have changed in such a backdoor process
No.
to file this writ petition.
They'll
Kindly
get
call for the report.
They'll get an electricity
Yeah.
connection. That would create no special right or equity in their favor. That will be without prejudice.
But they are not. He is not residing there.
This is sufficient prima facie proof.
My lord.
Other card. Other card and other documents are probably there. I'll just check up.
My lord, he is not, as per the heirship, he is not the owner. Co-sharer in the property.
That is your objection?
That is my objection.
Let us set the petition on this. Yes. What is page 19? How do you give an electricity bill if you are not, if you don't have any connection?
My lord, she had been residing there itself.
This is in your name, page 19.
Page 19.
This is
19.
an application.
My lord.
Yes.
Yes, I had made an application. This is my
What is that application?
application.
Acha.
And my into that they have
Apart
made
from the
payments.
other card, is there anything else?
I have also annexed, I think, my lord, it is not the I have also annexed my voter ID card, which is on the subsequent page itself. And my lord, apologies, it is not legible. I think it's not very clearly legible, but the address is the same.
Yes, voter
But
ID
my
card.
lord, I only say,
Right.
my only prayer is that they will come to the premises, but they are creating obstruction.
No, that is there. That I have.
That, and I'm only praying that it may be done in the
Police.
presence of the police.
Right.
At the cost of the
Learned
petitioner.
counsel for
My
the
lord.
petitioner contends that the petitioner sought a new electricity connection at the premises in question at 7/H/5, Jannagar Road, Kolkata 17, 7,17,000. Push up. However, due to obstruction of the private respondents, the said connection could not be given by the CSC Limited. Push up. Learned counsel appearing for the CSC Limited submits that at the time of inspection, the petitioner was not present and
To identify the main switch.
as such, the main switch of the electricity supply at the premises could not be identified or located. Full stop. Next para. Learned counsel for the private respondent submits that the petitioner was never in possession of the property. Full stop. By placing reliance on the death certificate of the mother of the petitioner, which has been father of the petitioner,
Mother.
the mother of the petitioner, which has been annexed at page 16 of the writ petition, it is argued that she resided at 5, Tati Bagan Road, PS Beniapukur, Kolkata 7,14,000, which is not the premises at which the electricity connection has been sought. First up, it is argued that the petitioner is neither the owner nor an occupant of the property where he seeks electricity connection and, by way of taking electricity, is seeking to establish possession and title thereto. First up, next para. Upon hearing learned counsel for the petitioner, it transpires from the documents annexed to the writ petition that the petitioner has annexed photocopies of his voter's identity card as well as Aadhaar card, which are sufficient prima facie proof of possession of a person in respect of a property, at least for the purpose of giving new electricity connection. Full stop. In any event, section 43 of the Electricity Act 2003 confers a right on an occupant to get electricity connection. Full stop. Next para. In order to allay the apprehension of the CSC Limited, it would be required that the petitioner remains present when the CSC holds an inspection for identifying the main switch and to ascertain the feasibility of giving an electricity connection to the petitioner. Full stop. Next para. Accordingly, WPA 19.
I'm told that the meter only has to be installed. Everything else has been done. They have made the payments, only the meter.
Whatever. Accordingly, WPA 19158 of 2023 is disposed of by directing the. You don't need another inspection then.
No, we don't need an inspection.
But you said you have to identify this meter.
Yes.
Main switch and
The petitioner has to be present for identification of the main switch. That is the only
Very good.
requirement.
WPA 19158 of 2023 is disposed of by directing the CSC Limited to give a new electricity connection to the petitioner at the premises in question from the existing meter board room, and for such purpose, they have paid.
They have made the payment.
And for such purpose, the CSC Limited shall give a prior notice to the petitioner when the CSC intends to give such connection, comma, to enable the petitioner to be present and identify the main switch for the purpose of giving such connection to the petitioner. Full stop. As the CSC Limited submits that all other formalities have been complied with by the petitioner, comma, nothing remains to be done by the petitioner apart from identifying the main switch. Full stop. Next para. In the event any obstruction is raised by the private respondents, comma, the CSC Limited personnel will be at liberty to approach respondent number 3, comma, the officer in charge of the Beniapukur police station, who will give adequate assistance by acting on a server copy of this order at the cost of the petitioner, comma, in the process, comma, if necessary, comma, breaking open any padlock or other hindrance if set up by the private respondents for the purpose of giving access to the CSC personnel to give electricity connection to the petitioner. Full stop. It is, comma, however, comma, made clear that the electricity connection as and when given, comma, shall not, comma, per se, comma, operate to create any special right or equity in favor of the petitioner, and shall be without prejudice to the rights and contentions of the petitioner and the private respondents before any other legal forum where the parties may contest out their respective rights regarding the property. Full stop. No orders to cause urgent settlement.
Deeply
Thanks.
I'm grateful.
grateful to your lordship.
15.
15. Yeah.
Lordship, this is my application. Lord.
Yes, please.
This is my affidavit of service. Lord. I appear on behalf of the WBSCDC. Lordship, the petitioner is the owner of a cold storage, Lordship, and
Cold storage.
cold storage.
Yes.
That is regularly paying its bill, Lordship. In the month of June, Lordship, the respondent authority raised a bill of rupees 1,47,000 and more, which the petitioner paid. And subsequently, in the same month, in the mid of June, the respondent authority raised another bill amounting rupees 30 lakhs, stating that some PT fuse in the meter is disputed for malfunctioning for the period of December to May 2023, December 2022 to May 2023, some faulty reading has come, and calculating the adjusted the residual amount with exactly for the last year, Lordship, they have calculated the bill amounting to 30 lakh without any basis, without ignoring the fact that my meter was shut down due to maintenance, which I have annexed here, Lordship, and I have stored lesser amount of potatoes rather than last year, Lordship, and I have made representation that has not been considered. And subsequently, the petitioner went to Consumer Forum, Lordship, but Consumer Forum, without going into the merit, has only made arranged an installment for payment of that same, Lordship. The dispute is that, Lordship, the 30 lakh amount.
Have we challenged here?
Lordship, the 30 lakh amount.
You approach the consumer forum, you have approached the forum, you submitted to that
Lordship, the petitioner has approached the forum.
So after that, you cannot reopen that issue before any forum.
Lordship, the forum has not gone into the merit of Lordship. That is, they have applied.
You submitted to that jurisdiction despite having the GRO, they have decided. Now you are bound by that.
Lordship, that is their, Lordship, but
cannot be allowed to forum shop like this.
Lordship,
you have got the installment, pay the installment or get it. It has been disconnected.
Lordship, the basis of calculation and basis of the disputed meter, Lordship, meter is under lock and key is under their control, Lordship. That is these aspects has not been considered. Whether my
you have a forum, appellate forum before the consumer forum, against the consumer forum. Go there.
Lordship,
I'll give you that alternative, either to go before the appellate forum or to go before the GRO. Your choice, you cannot choose both.
Lordship, as well, Lordship.
Yes, Mr.
But my Lord, kindly see his prayers, my Lord. He has not challenged the consumer forum order, my Lord.
Then I'll not give that relief.
Kindly see page number.
In any event, they cannot challenge that. I mean, yes, they can actually.
Kindly see page 14, it starts. Page 15, they have challenged the bill, they have to go before the GRO.
The present dispute pertains to a billing dispute between the petitioner stroke consumer and the WBSCDCL, push-up. Although the petitioner had approached the consumer forum, comma, it is argued that the consumer forum, comma, without entering into the issues of the particular allegations, comma, merely granted installments to the petitioner. Push-up. Next para. Learned counsel for the WBSCDCL points out that the petitioner has not challenged the order of the consumer forum, but has raised a billing dispute, comma, which is to be adjudicated by the concerned grievance redressal officer. Full stop. Next para. There is substance in the contention of the WBSC DCL. Full stop. In any event, comma, the consumer forum is not the appropriate authority to decide billing disputes, comma, for which a specific forum has been allocated by the regulations framed by the WBERC under the Electricity Act 2003. Full stop. Accordingly, WPA 19159 of 2023 is disposed of by granting liberty to the petitioner to approach the concerned grievance redressal officer within a week from date with the billing dispute as raised in the present writ petition. Full stop. If so approached, comma, the said GRO shall decide the issues without being influenced in any manner by any of the observations made herein and or those of the Consumer Disputes Redressal Forum and decide the same within preferably within 8 weeks from the date of such approach being made by the petitioner. No address to cause urgency.
Lordship, only one prayer, Lordship, within that period, no coercive action may be taken, Lordship, because they have, after filing this writ application, they have
Forum shopping, your forum shopping.
In terms of the order of the.
You approach the consumer forum, you have got an order of installments. After that, you cannot say.
And they have not paid also.
Lordship, at least no disconnection, no disconnection, their Lordship, Milord.
No. Next.
16.
I am for the petition, Lordship.
Yes, Saldar.
Lordship, this is my affidavit of sale. Landlords are sub, Lordship. Petitioner is a tenant, complied with all.
Private respondent?
Yes, yes.
Yes.
No, I am for the CSC, my lord.
CSC. Yes. Service?
We are
Service
ready
good
private
service.
respondent?
Both the private respondents are sub.
we are ready to connect, but
Petitioner has complied with all the
Who are
formalities.
they? The respondents? Private?
landlords.
Landlords.
Land counsel for the petitioner submits that the
We
petitioner
can
is a
get from
tenant
police
in
and,
respect of the
by
property
getting the padlock.
but cannot get new electricity connection due to obstruction created by the private respondents stroke landlords. Full stop. Next para. Despite service, none appears for the private respondents, although the CSC Limited is represented along with the petitioner. Full stop. Affidavit of service filed today be kept on record. Full stop. Next para. Since, comma, in law, comma, the petitioner is entitled as a tenant to get electricity supply. Full stop. Even without going into the question on merits as to the status of the petitioner with regard to the property, comma, the petitioner as an occupant is entitled under section 43 of the Electricity Act 2003 to get electricity supply, irrespective of the objection raised by the landlord stroke true owner. Full stop. Accordingly, WPA 19179 of 2023 is allowed, directing the CSC Limited to give new electricity connection to the petitioner at the premises in question, subject to compliance of all formalities by the petitioner, comma, within a fortnight from such compliance by the petitioner. Full stop. If obstructed by the private respondents, comma, the CSC personnel will be at liberty to approach respondent number 3, the officer in charge of the Wadganj police station, who will give adequate police assistance to the CSC personnel at the cost of the petitioner by acting on a server copy of this order. Full stop. Next para. If any padlock or other hindrance is put up to resist the CSC personnel in that regard, comma, the police personnel will be at liberty to remove such padlock or hindrance to give access to the CSC personnel. No address to cause urgency. Thank you.
Okay.
17.
Milord, may please, Lordship, I am for the petition.
I am for the CSC Limited.
The private respondent, this is my affidavit of service.
I am for the CSC Limited.
Right. Who are they? Private respondents, Mr. Haldar?
As the objector, my lord, part owner of the premises, my lord, annexure.
You are a co-owner or no?
I mean,
Yes, sir.
owner. And my lord,
Co-trespasser.
no trespass. My lord, kindly see the only annexure P1, page 9. Owner. We are the owner. Last line.
After seeing the annexure, you discovered that you are the owner.
No, objection letter to the applicant. That is the objection they made. For that, CSC could not give the effect the supply. We are ready to comply all the formalities, and I have served private response.
Yes, what is the difficulty?
My lord, CSC authority applied for the connection and thereafter.
Without looking into that.
Sorry?
Submit without looking into that. Yes.
CSC authority applied for the electricity connection and we already deputed our representative for the inspection of the said local, but unfortunately the private, we get a strong hindrance from the private respondent, and that's why we are not able to access to the meter room. And that's why at first we are ready to give supply everything, but at first we have to do the inspection, and for the sake of inspection, we need the police help. And if there is any padlock, we also need the police help to break open the padlock. And after if the petitioner comply all the necessary formalities, we are ready to give
So
the
you see
install.
how much more fluent you are without looking into that instruction.
Sorry, my lord.
You are much more fluent without looking into the written instruction. You are stuttering when you look into it.
No, my lord.
Very well, I'll pass.
And if after inspection, if the petitioner prefers all the formalities.
Mr. Haldar, you have managed all the post offices. None of the respondents are appearing. Private respondents are not appearing. CSC is appearing. Very difficult, actually. Your network is increasing.
No, sir. Never. And after inspection, if the petitioner complies all the formalities, we're ready to install the meter. But if there's
Just come
padlock,
for
we
that.
need the police help.
The petitioner has applied for a new electricity connection, but is not being given the same due to obstruction by the private respondent. Full stop. None appears for the private respondent despite service. Affidavit of service filed today be kept on record. Full stop. The CSC Limited submits to council that the CSC Limited is agreeable in principle to give such connection to the petitioner, comma, subject to holding an inspection to ascertain the feasibility of the same. Full stop. It is also submitted that there is obstruction on the part of the private respondent.
And they also given us a letter of objection, that letter of objection, the private respondent given an objection letter to us.
No, there is an objection regarding the possession also.
But Mala Narayan Sao,
You have not disclosed about this suit in the petition.
that I have no instruction. Well, kindly see the is a
Konkanda Challan, Senate Council for the CSC. CSC Limited submits to council. Yes. Private respondents, full stop. At this juncture, comma, Learned Counsel for the CSC Limited hands over a written objection given by the private respondent, where the private respondent has apparently stated that a civil suit is pending for cancellation of sale deed executed allegedly in violation of Section 44 of the Transfer of Property Act in favor of the present petitioner. Also, it has also been alleged that the petitioner, that strangers are trying to take illegal possession of the premise as trespasser, and apparently that the petitioner does not have any possession of the suit property. Full stop. Next para. Since nothing regarding the said suit has been disclosed in the present petition, comma, in order to enable the petitioner to come prepared on the said objection taken by the private respondent, comma, a copy of the written objection be served by Learned Counsel for the CSC Limited to the petitioner by tomorrow. Full stop. The matter shall be taken up under the listed under the same heading day after tomorrow for passing orders.
Right.
Please give a copy. So
Yes,
that
yes,
take
yes.
instruction, Mr. Haldar, if necessary. I'll direct it to be referred to the district magistrate. And please disclose if you are aware or you become aware. Please disclose everything regarding that suit. All injunction order, everything. Thank you. Thank you.
18.
Give a copy to them, please.
My lord, I am on behalf of the state lordship.
Wait for the petitioner, my lord.
Yes, what is the matter?
Of course.
One petitioner, my
Lord,
lord,
I mean for this
is a
CS.
You are also for the
homeopathy
state.
doctor, my lord.
For the CS.
CSC has been taken over by the state.
It was there, my lord, once upon a time.
Yes.
Petitioner is a homeopathy doctor, my lord. And homeopathy clinic is
Homeopathy doctor is relevant here. Mr. Mukherjee told you to say this. I don't have any particular obsession for homeopathy.
no, ma'am.
I mean, or allopathy, either of the two. So why homeopathy doctor you are saying repeatedly?
But she's tenant, my lord. Yes, she's a tenant, my lord. She is initially, she is enjoying electricity given by the respondent landlord, my lord. But after the worsen of relationship between the landlord and tenant, my
The
lord,
eviction suit has been filed.
no, my lord.
Disconnection?
Notice has been given, my lord. Disconnection has been given. Disconnection.
Disconnection has been made.
Yes, my lord.
Notice of eviction has been given.
Has been given.
What is this? How the license department, how the municipal code, page 9?
It is a enlistment license, my lord. Trade license, my
Acha,
lord.
very well.
Well, we have applied, my lord, but the due
This
to
to show your possession, this and the receipts.
yes, my lord. And
What
we
about
have-
service on the private respondent?
Yes, my lord. I have, my lord. And
Good service?
yes, my lord. Yes, my lord.
Yes, what do you say, Mr.?
My lord, they have complied with the formalities, my lord, but the
Eta ki chalo?
meter could not be installed because of the physical objection raised by the private respondents.
Very well. I'll pass on. The grievance of the petitioner, comma, who claims to be a homeopathy doctor practicing in the premises at the premises in question, comma, is that she is not getting electricity connection due to obstruction raised by the private respondents. First of, despite service, comma, none appears for the private respondents. First of, it transpires that the petitioner is claims to be a tenant in respect of the premises and has annexed her license to practice as well as copies of certain rent receipts to show her possession in respect of the property. First of, for the limited purpose of section 43 of the Electricity Act 2003, comma, such proof is deemed to be sufficient to indicate that the petitioner is in settled possession of the property and, comma, as such, comma, entitled to electricity connection. First of, as the landlord stroke private respondent chooses not to appear despite service, comma, the writ petition is taken up for expert hearing and is disposed of. Full stop. WPA 19452 of 2023 is accordingly allowed, comma, thereby directing the CSC Limited to give electricity connection to the petitioner within a fortnight from date and or within a fortnight from compliance of formalities of the by the petitioner, whichever is later, comma, full stop. If any obstruction is raised by the private respondents in doing so, the CSC Limited personnel will be at liberty to approach respondent number 3, the officer in charge of the Chatterjee Hut police station, for getting adequate police assistance. Full stop. If so approached, comma, respondent number 3 shall give such assistance at the cost of the petitioner by acting on a server copy of this order and, comma, if need be, comma, shall break open any padlock or other hindrance to give access to the CSC personnel for such limited purpose. No address to cause administration.
Grateful, my lord.
19.
Yes.
My
Yes.
lord, there is a billing dispute. We made a grievance before the grievance redressal
Page 11 of the writ application.
writ application, and they have
Pending disposal.
pending disposal.
Learned counsel for the petitioner submits that the petitioner raised a billing dispute against the CSC Limited, which was referred by way of a representation before the concerned grievance redressal officer. That is respondent number 3. Full stop. However, comma, since the same is pending, comma, the petitioner seeks an early disposal of the same. Full stop. Next para. In view of the innocuous nature of the prayer, comma, no affidavits are directed. Full stop. WPA 19755 of 2023 is disposed of by directing respondent number 3, comma, the grievance redressal officer, comma, CSC Limited, comma, Howrah Regional Office to decide the petitioner's representation regarding billing dispute in accordance with law as expeditiously as possible, comma, positively within 6 weeks from the date of communication of this order to the respondent number 3. No address to cause.
Till disposal, there will be no disconnection. Well, this is a huge amount of bill, man. Till that.
My lord, they have
it was
neither
a-
filed any written objection nor filed any appeal.
My lord, 6 weeks, heaven will not fall. That disconnection will stay.
If all the petitioners come with the same prayer,
No,
heaven
no,
may fall.
No.
Heaven may fall because the
No,
others will
no,
not get electricity.
No, this is the only, Mala, can you see the amount?
No written objection has been filed, my lord. No appeal has been preferred.
What? The grievance redressal paper, I'm not accuracy. And next page is they have received it.
No ground of any dispute has been disclosed here. You have just said I raised a dispute regarding the billing. Nothing.
The billing amount I have disclosed.
Just you have said I have disputed the amount.
Yes.
No ground has been disclosed.
abnormal amount.
No, no. This cannot, save you from.
5 weeks, 4 weeks.
Generally, they do not disconnect, but you have to depend on that. Not a court's order.
Passes from.
The parted.
20.
Not happening for this CSC, my lord.
Same.
50%.
No, this is the case of theft.
50%.
On 13th of July, the final assessment was served. No appeal, no written objection. And
Anticipated bill obtained, appeal not filed.
no.
No file
No
and
written
match.
objection.
You want to pay 10% more or 20% here?
No, not percent. Let it be to the local.
Let it be. Look at
Dispute will be solved.
the petitioner has. What have you challenged?
50% we have paid as per anticipated bill, and remaining amount.
If the writ petition is not maintainable, can I refer it to the Lok Adalat? This is a more basic question, Mr. Halda. If I don't have determination to hear this,
Amount is so.
very well. Learned counsel for the petitioner submits that the petitioner has challenged final order of assessment by the CSC Limited, full stop. Although the same is otherwise amenable to challenge in an appeal under section 127 of the Electricity Act 2003, since the petitioner seeks an amicable resolution of the issue and placement of the matter before the oncoming Lok Adalat, let the file be placed before the concerned bench of the appropriate bench of the oncoming Lok Adalat, full stop. In the event mutual resolution fails before the Lok Adalat, the file be placed before the regular bench of this court having determination.
Appeal has not been filed within the scheduled date.
Nothing. If it is resolved amicably, Mr. Ghosh, then you will also be saved costs and all this. Litigation costs included.
Deeply obliged for the day.
Thank you.
Grateful, my
Oh, for the day. Yes.
21.
21, my lord, I beg to appear
State.
for the state respondent lordship.
Move the petitioner's writ petition.
My lord, I have a point of maintainability, my lord,
Why?
because there is an arbitration clause. It's a
Affidavits have been exchanged in the matter. And
affidavits
Mr.
have been-
Banerjee is also just entering. So,
Lordship.
so I'll reject it on the ground of maintainability. He's taking a maintainability question
After exchange of affidavit.
after exchange.
No, there was a lordship kindly sees the order dated in the 15th December. That question is
So let me hear the matter. After exchange of affidavits, I'll hear you also on the maintainability issue.
lordship.
This question was kept open.
Lordship kindly sees, my lord, 15 December 2022 order, lordship. Seeks to argue on the point of
Yes, point of
maintainability.
maintainability shall be kept. Argue on all points. Yes.
Petitioner.
Yes, petitioner will argue.
Only thing is, is coming for final hearing.
When?
No, but I may not be able to finish it in 10 minutes. That's the
Yes.
only thing. I know your lordship takes up original site from 3.
True.
So,
So let us see whether any short matters are there. Very well, possible. Not today.
Only thing is tomorrow I'll be in some difficulty, could be come on Wednesday.
On the prayer of the petitioner, let the matter stand adjourned till Wednesday. Wednesday hoche September 6, 2020.
Grateful.
Thank you.
Lordship 22, Lordship, I am happy and we are the petitioner, Lordship.
Yes, what is the matter?
Lordship, fact is that petitioner is the married wife of respondent number 7.
Is there any scope of an unmarried wife?
No. Lordship, only thing,
You're a wife, yes.
respondent number 7.
Right.
Petitioner with her 2 minor child driven out from his matrimonial house on 8/10/2022.
Right.
Thereafter, petitioner filed a criminal case against the husband. That was charge sheeted. That was also annexed process. That was not subject matter. Thereafter, petitioner purchased the one immovable property and also invest some money before the postal department.
What is the movable property?
Immovable property.
Achha.
And also deposit some money before the postal authority under NSC.
These were after you were driven out.
No. During.
You purchased immovable property and invested money in?
Before the postal department under NSC.
Right.
And also invest some money in the LIC department. from her Stridhan article.
Yes.
Thereafter, lordship, respondent number 7, on behalf of his minor child, file a civil suit praying for declaration and permanent injunction regarding that immovable property, also the money lying before the postal department.
That it is his property.
They claiming this is his property.
No divorce suit pending between you.
No divorce suit.
No suit, matrimonial suit at
No
all.
matrimonial suit.
Achha, then
Suit was filed on behalf of the minor child. So, plaintiff is the minor child. I annex the plaintiff.
but the minor children are with you.
Mine with
But
me.
but their father
Father
filed
filed the suit. Minor child.
very well.
Thereafter, father, respondent 7 filed 2 injunction applications. Regarding immovable property, one injunction application, another money lying before the postal department, LIC. That injunction application was rejected. Both.
Right.
In the meantime, one NSC amount was matured.
That was part of that subject matter.
My client made an application before the postal department to release this amount. But postal department was not released. Last occasion, lordship, only one letter was issued by lordship. Last page, lordship, page 48, to the Ramnagar postmaster Ramnagar PS postal department was issued a notice to the superintendent of contact post office. Subject is that this is intimate you that the undersigned received an
Actually, the postmaster, the master did the right thing.
loss.
So you want a direction on that?
There is that the money was deposited by my client, that was mature, that should be disbursed to my client.
It is standing in your name.
Yes, I showing this.
That have you annexed?
Yes, loss. I showing this. That. Loss, page 23. Name and father name of the investor, Sukarna Das Mondal. This is my client. Amount invest on 2018, that was matured on 13 March 2023.
You want a disbursal of this?
That amount.
Yes, what do you say?
My lord, in this matter, Mr. Amol Kumar Sen is appearing for the state, your lordship.
State is not required.
He's
Postmaster.
Lordship, central government.
Central government. Mr. Sen, it's against the central
Against the
government.
center, yes.
So actually you are not.
State has nothing, my lord.
Served on all. Have you checked?
Yes.
Checked the proper.
Yes.
Despite service, none appears for the Union of India and the other respondents apart from the state. First of next para, learned counsel for the petitioner contends that the petitioner is the wife of respondent number 7, but was driven out on October 8, 2022 from her matrimonial home, along with 2 minor children. Full stop. Prior to being so driven out, the petitioner had purchased immovable properties and had made certain investments in movable assets, particularly in the postal department and with the LIC from her Stridhan money. Full stop, next para. Thereafter, the respondent number 7 / husband filed a suit for declaration and injunction in the name of the minor child of the petitioner, seeking a declaration in respect of the movable and the immovable property in question. Full stop. 2 injunction applications were moved separately by the plaintiff / respondent number 7 therein, one each for the movable and the immovable properties, but both the said injunction applications were rejected by the court. Full stop. In the meantime, an NSC certificate of the petitioner has matured and the petitioner sought a release of the same. Full stop. However, an internal communication was made by the sub postmaster, Ramnagar to the superintendent of POs, comma, quantity division annexed at page 48 in that regard. First up, it is argued that the petitioner is entitled to the amount in question and the same should be disbursed immediately in favor of the petitioner. Full stop, next para. As heard learned counsel for the petitioner and the state, full stop, the petitioner has annexed sufficient documents to the writ petition to prima facie to establish that the petitioner that the NSC certificate in question stands in the name of the petitioner. Full stop, that apart, comma, as per submission made by the petitioner wife, comma, there is no matrimonial suit pending between her and the respondent number 7. Full stop, in the declaratory suit filed by the respondent number 7 husband in the name of the minor child of the petitioner, comma, both the injunction applications filed by the plaintiff stroke respondent number 7 were rejected. Full stop, hence, comma, even if the NSC certificate in question is the subject matter of the suit, comma, there is no impediment or any restraint order passed by a competent court at present to debar the petitioner from getting the amount under the said NSC certificate, comma, particularly since the same stands in the name of the petitioner. Full stop, accordingly, WPA 9433 of 2023 is allowed, comma, thereby directing who should disburse Ramnagar. Directing respondent number 4, comma, the postmaster, comma, Ramnagar sub post office, comma, to disburse the amount, to disburse the maturity amount of rupees 4,32,696 against the NSC account number 39689779988 standing in the name of the petitioner with the said sub post office, comma, in terms of relief A, small a, of the present writ petition within a fortnight from the date of communication of this order to the said respondent. Full stop. The parties shall act on a server copy of this order coupled with the written communication of the learned advocate on record for the petitioner instead of insisting upon prior production of a certified copy, comma, to comply with the same. No less to cause urgency. Thank you.
The only thing, I think my learned friend should bring it to my lord's notice that if the my lord, the date of maturity is over, suppose, and my lord, so far my knowledge goes, my lord, if the amount still lying, then my lord, additional amount I think should be, if anything, I think.
Couldn't be fairer. Couldn't be fairer. যেখানটা বলেছি না WPA such and such is disposed of, allowed, directing respondent number such and such to disburse the amount of such and such, যেখানে অ্যাকাউন্ট নাম্বারটা দিয়ে শেষ করলাম, অ্যাকাউন্ট নাম্বারটা দিলাম, অ্যাকাউন্ট নাম্বার along with any other interest or other amount, comma, if accrued on such account till the date of disbursal of the said amount in the name of the petitioner. Thank you so much, Mr. I should have recorded this, but that would make it cumbersome. Should have recorded that you have submitted, but I did not because it will make it cumbersome.
Get
23.
Next.
May I please, Your Lordship?
Please, yes. May it please me. May whatever is before you, please. You cannot please.
May affidavit of service may kindly get
I'm
consideration.
appearing for the Union of India, my lord. I'm led by Ms. Sushmita Shah.
You are the main contesting party?
My lord, my lord.
Yes.
My
What is
lord,
the
as per the instruction from the department, my lord, to my learned senior, my lord, the issue has already been resolved, my lord. May I
For
read,
that,
my
I
lord?
need to take instructions from my client.
It is submitted by the Union of India that the issue has been resolved in the meantime. Full stop. Learned counsel for the petitioner seeks some time to take appropriate instruction on such issue. What is this? Who filed this? Synopsis? Anyway, it is already on.
My lord,
এটা কে দিল?
my lord, wrong. Apologies, my lord. I have given my petition.
Accordingly, let the matter stand. How long would you like to take for this?
My lord, 2 or 3 days, my lord.
Days. Accordingly, let the matter stand adjourned till September 8, 2023, when it will be listed under the same heading. Affidavit of service filed today be kept under.
Grateful, my lord.
Deeply obliged.
Thank you. If you can, please also take written instructions so that I can keep something on record,
My lord.
if possible,
My lord.
to save your back also.
My lord.
Right.
Deeply obliged.
Thank you. Next. আরেকটা দেখেন, এক মিনিট তো আছে।
24.
We are the respondents in this matter.
Won't be hard today. Well, not today. I'll take up the original. Origin side, yes.
Lordship, next item is disposal of section 14 application, very short matter. Item number 15, if your lordship can.
Taken. This is passed over. Your matter, Mr. Panja, is passed over for them.
Lordship,
25,
petition, lordship.
Pending above 60 days.
Yes, it was submitted on 26th of December
In view of
2019.
the innocuous nature of the writ petition, in view of the innocuous nature of the order proposed, further service is not directed, although the respondents are not represented despite service, affidavit service filed today be kept on record, full stop. The petitioner bank is justified in arguing that its application under section 14 of the SABYASACHI Act against the private respondents
Lordship,
have been
since 26th of December 2019.
Have been kept since December 26, 2019, which is much beyond the statutory outer limit of 60 days. Full stop. Accordingly, WPA 170
Lordship,
10395 of 2023 is disposed of by directing respondent number 2, the district magistrate Birbhum, to dispose of the pending application under section 14 of the SABYASACHI Act 2002 at the behest of the petitioner against the private respondents as expeditiously as possible, positively within 3 weeks from the date of communication of this order to the said respondent. No address to cause urgency.
I'm grateful, Lordship.
Item number 26.
No.
It's,
Origin side now.
kindly indulgence, my lord, for the last 1 month, 2 months, my lord, is pending, my lord. If,
Next day, yes. Call on the origin side.
Any mentioning in the original side? Case list for hearing item number 1, Dalmia Securities Private Limited.
My petition,
yes,
and there's also a GA filed by me. Kindly permit me to give your lordship a very brief background before I take you to the matter. My lord, my client, the petitioner, is a stockbroker who's registered with my lord Calcutta Stock Exchange and National Stock Exchange, and also Bombay Stock Exchange. Now, my lord, in the course of its dealings, my lord, transactions are undertaken on behalf of clients for buying and selling of securities. My lord, in 2002, my lord, we received a letter from the Calcutta Stock Exchange saying we want to inspect some transactions. We said, very well, we don't stand in the way. Whatever you want, I'm giving. My lord, this correspondence went on till about 2004. My lord, they asked for ABC, we provided them according to us ABC. My lordship will hear, my lord, we may not have given one document, but according to us, we gave everything. Now, my lord, in 2004, that was the end of the communications. Nothing happened thereafter. CSE did not write, let alone, my lord, file anything against me. Now, my lord, in the meantime, I had also filed writ petitions and a suit, essentially seeking to stop the investigation because according to us, it was a roving fishing inquiry. My lord, those proceedings were pending and my lord, they remained pending. In or around 2011, we wanted to give up our membership of the stock exchange because your lordship is aware CSE has also become defunct for all purposes. Then, surprisingly, we were met with a chain of correspondence from the Calcutta Stock Exchange saying, sorry, Mr. Dalmia, you cannot surrender your membership and we cannot give you back your security deposit because that's the necessary result. We have to keep a certain margin for trading as security. We also wanted it back. There are a lot of letters on record, which your lordship will be surprised to see a body like CSE saying, first you withdraw the proceeding. First you withdraw that writ petition, you withdraw that suit against me, then I will process your surrender of membership.
The suit was for what? The same relief?
Suit was formulated in relation to the inspection, but may not be totally relevant for this purpose. The writ petition principally to us. So, CSE also took a stand before you withdraw these proceedings against me. I'm not. It's not expected of a body like CSE to hold out a threat like that. Be that as it may, that position also continued 15, 16, 17. After 2004, for the first time, we received another letter from CSE saying, please let me come to your office to inspect. We naturally wrote back, what were you doing?
They said, please.
Not really please, in slightly harsher language. Kindly permit me to omit the please because that will give a more accurate picture. So we wrote back saying, no, we object because there is no investigation. It was an inspection exercise at best. But anyway, they came. And there's a letter from us also recording that whatever remained also was taken. Now, my lord, ultimately in 2022, we filed the writ petition. And the writ petition was very restricted. My lord, the writ petition was to get back our security deposit, which they had held on to for so many years. My lord, when the writ petition came up for hearing before the learned single judge, that's when we first came to know that there was apparently some letter issued by SEBI in 2002, basis which CSE initiated this action in 2002. We did not know what that letter was. And my lord, in the course of hearing, CSE said there's an investigation which is pending against you. So we also told the learned judge that, look, it was an inspection. And the correspondence will also say it's an inspection, no investigation. Anyway, my lord, the learned single judge at that point, my lord, some papers were handed up without giving a copy to us. That's our complaint, my lord, also. Papers were handed up, including that so-called SEBI letter. The learned single judge considers that and says that, look, SEBI has done this. You have started this so-called exercise. Your return will be subject to that. Let that exercise be completed. Though, my lord, that was not subject matter of the rate. It was our rate.
Return of security deposit will be subject to that.
That's right. So, my lord, we took it up in appeal. We challenged that. We were successful in the appeal. The order was set aside, remanded back. And the division bench also passed, my lord, a direction that in the meantime, if any order had been passed pursuant to the single judge's directions, we would be at liberty to challenge that before the learned single judge.
This application is.
That's why, my lord, GA1.
What are the orders passed?
The order is on 15th of March 2022, backdated to that date, which we shall, my lord, demonstrate. Division bench's order is 31st March. On 1st April, we receive, under cover of 1st April, an order of 15th March, my lord, by CSE, my lord, saying that the transactions we have undertaken are irregular, and my lord, imposing penalty, interest, and my lord, referring the matter to SEBI. My lord, this is the conspectus of the matter, but I shall show, my lord, the whole exercise not only is totally illegal because the starting point itself is wrong, because there was no investigation.
But then probably your security, the final relief in the writ petition becomes dependent on the application.
Yes, in a way. But that is only pursuant to, my lord, the division bench's order.
Yes, in any event, you have
Lordship
to
is
overcome
right.
that hurdle first.
Now, my lord, it's GA1 really which has primacy, not the writ petition.
Yes.
It's slightly peculiar in that sense. And the whole proceeding, and that's what will show, no show cause notice, no power. And I'll show that to your lordship, no show cause notice issued, abandoned after 2004, threats held out, and no power to do anything. Even if CSE had come to a conclusion, at best it could have referred it to SEBI.
Have affidavits been directed?
Affidavits are complete. Yes,
Achha. Have they disclosed anything regarding the documents which are handed up to Justice?
Yes. What they handed up, we came to know later during the course of the appeal. We wrote an advocate's letter. They said this is the SEBI letter of 2002. So, my lord, this is the short background. Kindly now permit Mr.
The long background will be given by Mr. Dane, who is not at all prepared.
No, he is more prepared. He is.
He's more prepared in some other matter.
There's a specially constituted bench which will be there at 3:30. That's my only hesitation. Otherwise,
by 3:30 you'll be finishing, sir. At your speed. Not at my speed though. I mean,
no.
But at your speed, definitely you'll be finishing.
There are. We have to really show the what Mr. Mitra has already made his submission. We have also prepared a list of dates. Perhaps from 2002, sees the correspondence which was exchanged, including the SEBI also stopped. There's a 27.
If an investigation was started, you have to satisfy me that the SEBIs must have been a party here also.
Yes.
There's no investigation.
No investigation. 27 November 2003, they also stopped. They also went on for a while, the Calcutta Stock Exchange, then they also stopped. When we filed this writ petition, then only all of a sudden, everything started.
Even if they stopped, Mr. Banerjee, you have to satisfy me that this action was bad.
Yes.
I mean, the previous orders
Yes.
without jurisdiction.
There's no show cause notice. The whole action fails only on one single ground only.
SEBI Act is necessary here.
No, it will not be.
Investigation is under what?
They were notice under the Security Contract Regulation Act. They are only they have the referral part. They don't even have investigation part.
So should I hear the SEBI first for justifying their stand?
No, SEBI has nothing. SEBI has not done nothing.
These orders
Calcutta Stock Exchange.
Okay, all correct.
SEBI is not taking any action.
Very
well. No, 27 number 2003.
So let us hear them.
Kindly permit me to place it. my lord, there's
Only reason, my lord, because if I no, definitely break, my lord, at 3:30, my lord, I don't want. And we also, my lord, have another, my lord, we are also, my lord,
So can you come prepared with a short notes of arguments? I'll hear you definitely.
ultimately led, my lord, by Mr. Mukherjee as well. So, my lord, I don't know why.
So therefore, all of you can be present for 5 minutes and give the written notes. Should I keep it Friday? I can keep it.
List of dates.
List of dates.
List of dates already ready.
You are for CAC.
I am for
You will be
list
able
of
to
dates
come
hand
on, come back on Friday with the written notes.
No,
Written notes in so far.
We have, my lord, we have already prepared a list of dates which will give you a
basically-
lordship, my
Yes,
lord.
my lord, this
It's
is
a comprehensive, my lord, list of dates.
Give a copy to them also.
We'll give
Mr.
a copy.
Yes.
In
It's a
fact, my lord,
comprehensive-
we'll also be relying on a separate list of dates.
Written notes may come later, but that will give you a
No,
lordship.
this
the
is
entire
all.
picture.
I mean, you can file your list of dates also. So
Because
yes, exactly. All the pages have been.
And my lord, it has some comments, my lord, from our end.
So this is virtually an argument. Okay? I mean,
My lord,
it's
I'll be
argumentative.
placing a similar list of dates, my lord,
Do that.
which will be encompassing my arguments.
Come back
Insofar
on
as-
Friday. I'll hear out.
My lord, Friday, my lord,
Since
But
they are
I'm-
prepared, you can come back tomorrow also.
my lord, I'm being led by Mr. Rai in this matter, my lord, Mr. Anirban Rai.
Mr. Anirban Rai.
Yes, my lord.
He'll never be ready on any day.
My
He
lord,
has other important tasks. He's the
he
chief
has
and all.
some personal difficulty, my lord. I was just informed, my lord, if it could be any day apart from 8th, my lord. If it could be on Monday, Tuesday.
Tomorrow? Day after tomorrow?
After tomorrow.
They are prepared. They have prepared the list of
Day
dates.
after tomorrow আমি আটকে যাব না আমি আটকে যাব আমার ইন ক্যাব হিয়ারিং আছে ওটা পুরোটা চলবে ডে আফটার 8 তারিখ আছে ফ্রাইডে নেই ও হ্যাঁ আফটার 12 বলছে গোপাল
Tomorrow difficult for you, Mr. Banerjee?
No, I'm.
গোপাল বলছে আফটার 12 tomorrow
So I'll keep it tomorrow. Let us hear both of them tomorrow, both of you tomorrow, and written notes I may postpone in some other day.
Very well.
তাহলে কি আজকেই করে নেব
The list of dates filed by the petitioners be kept on record. Full stop. Let the matter stand on the prayer of learned counsel for the parties, comma. Let the matter stand adjourned till tomorrow. Come back on tomorrow. SEBI, does it have a major role to play? I don't think so, as Mr. Banerjee.
No, my lord, they don't have, my lord. Because SEBI, my lord, key.
list of dates
CAC will be paid your fees.
My lord, now CSC is practically, my lord, defunct.
Yes.
No, my lord, there are issues, my lord, which perhaps better, my lord, if I can, whenever I come before your
we are
lordship to
earning
address your lordship, my lord, perhaps I'll be able to satisfy your lordship on that. But my lord, only one difficulty, I might not be able to be ready with the list of dates by tomorrow. So in that, let my learned senior
Let us
friends
hear the arguments of Mr.
comments
Banerjee.
the arguments. Very well. I'll come back tomorrow. Grateful.
Grateful.
Yes.
I am for the petition, my lord.
Right. I appear for the state. Yes.
Just a second.
I'm for the my lord.
You're for the?
I'm for the private respondent,
Private.
contesting a respondent.
Right. Yes, Mr. Agrawal.
Yes, my lord. My lord, since my lord main, I have got a GA also, but since main writ petition is ready for hearing, I can proceed with the same.
Yes, yes,
also.
absolutely.
Yes. My lord, this relates to property which is situated Razorhat. The property, my lord, in Newtown, my lord, was given to us, is actually by the National Cooperative, National Confederation, Federation. National Cooperative Consumer Federation of India.
Right.
This land was allotted to National Cooperative Consumer Federation of India exclusively for the purpose of constructing building for residential housing complex with and to be used as a cooperative society only. And a particular clause was there that a portion of the said plot will be used for constructing LIG flats.
Who gave to whom? You gave to them?
No, NCCF was allotted a plot of land by the West Bengal Housing Infrastructure Development Private Limited, my lord.
Right.
Corporation.
Then what happened?
This was with the condition that it will be a cooperative society and it will be used for a residential housing complex and a part of it will be used for the purpose of constructing LIC housing complex. NCCF in turn, your lordship, had entered into an agreement with my client, my lord.
Right.
Development agreement with the Sunny Rock States and Developers Private Limited for development of the said property. My lord, in fact, for the purpose of acquiring the said plot of land, my lord, my client had paid the entire consideration money on behalf of the NCCF to the West Bengal Housing Infrastructure Development.
NCC represented today.
My lord, my client is holding the power of attorney. In fact, the entire stake of NCCF has been taken over by my client upon
Very
payment of consideration
Very well.
amount.
Then what happened? Yes.
Now, my lord, in terms of that arrangement, my lord, or the agreement, my lord, it was always understood, my lord, that there will be a cooperative housing society built up there. In accordance with the sanctioned building plan, my lord, we had constructed the complexes over there of separate building.
You are assigned the rights of NCC. You are the developer or what?
I am the developer, and the entire original consideration money on behalf of NCCF was paid by me. Then, my lord, the stake of the NCCF was also subsequently transferred in favor of the Sunny Rock Estate and Developers Private Limited. So now my client has got the entire right of NCCF over the said property. However, it has a condition, my lord, that this exclusive right to construct the space will be for the purpose of construction of the residential housing complex with all other basic amenities which are always there in the complex, like
Common
small,
facilities,
common facilities, small
including
market,
LIC, including LIC.
including LIC. And LIC was built up by my client at a nominal cost. Not we have charged only 500 rupees per square feet and gave it as a subsidiary for the lower income group people. Now, my lord, when in turn, when we developed this portion of the property, we entered into a standard terms and conditions which was originally approved by the NCCF. That STC, my lord, I shall show to your lordship. This contains a specific clause that all the members or the purchasers who will purchase the property over there will become the member of the cooperative society, or a cooperative society of all the members will be formed, who will run and manage the affairs of the said premises.
This included the LIC also.
No, LIG is separate.
Very well.
LIG is
Right. Then
my lord, this is the basic structure, my lord. But all the intending purchasers, my lord, who had acquired the property, my lord, now, my lord, had entered into that standard terms and conditions, my lord. They are fully aware of the terms and conditions that a cooperative society needs to be formed. Now, my lord, what has happened, my lord, that in between there was some difficulty in getting the electricity supply from NKDA. So when the NKDA has, because the completion certificate was issued later, so the NKDA has given us the completion certificate little later. So some of the flat owners, my lord, they took advantage of the situation, my lord. They had gone to the consumer court, my lord, and then they wanted, because we could not, without the completion certificate, you cannot have the electricity and to hand over the flats also. But that is a different part of the chapter. Now, these group of people, only few of the flat owners, my lord, including the one, my lord, who has applied before the competent authority, West Bengal Apartment Owners Association, my lord, they wanted to take control of the entire society. They refused to pay the maintenance charges. They were and are still using and enjoying all the facilities at the property, my lord, including the common passage, car parking space, electricity, lift. Everything is maintained by my client at his cost and expense last several years. We had written them letter galore, my lord, that please come forward and form a cooperative society. They have refused to do so. And neither they are making payment of the maintenance charges, more than a sum of rupees 5 crores, my lord, on account of maintenance charges have accrued, my lord, which are due and payable by these flat owners. Now, my lord, what they have done, my lord, they wanted to form a owners welfare association. Instead of becoming member of the cooperative society, my lord, they said that you form an owner welfare association and hand over as the charge of the property. We will run the same. We will not become part of the cooperative society, because cooperative society, there is some cumbersome procedure in case of transfer, because you have to seek consent and permission, and these are written. So in order to overcome these, my lord, they wanted the owners welfare association to be formed. Now, my lord, what they have done, this I can place before lordship the clauses of STC.
Mr. Agarwal, can you compel them to become part of that? Is there any?
Yes.
Was it implicit in your
It is
clauses or-
implicit. It is implicit. That is why, my lord, I was
So, my lord, it is not, my lord.
Obvious.
very well. You will so
You are
definitely.
there to do that.
Yeah, definitely. My lord, in paragraph 26, my lord, some of the important clauses I have set out of my application.
Yes.
It is like, my lord, when a plot is allotted to a cooperative society, my lord, there will be a cooperative society, not other than that. So, my lord, these clauses are, my lord, the document is also annexed, my lord, which is, but our clauses are set out, my lord, paragraph 26, my lord. Or if your lordship takes annexure P3, the main document also. Just keep the page number. Just a second, it is that. It is at page 90, my lord, it starts. 91, volume 2.
Yes.
My lord, the most,
The owners were signatories here.
yes, separately, individually, they have signed it.
Very well. This is the format.
This is the
Naturally, this is a
format.
standard.
Standard format.
Right,
my lord.
right. Yes.
Kindly come to 8.2. Page 100, my lord, 1008.
Yes.
Scheme of management and maintenance.
Right.
The developer at its discretion may management and maintenance of the housing project and common parts and portions and utilities itself or through the facility management company unto such time the management and maintenance of the common parts and portions and utilities of the housing project is taken over by the cooperative society, my lord, of the unit owner of the housing project. Such cooperative society shall be at the instance of the developer, shall be formed by the unit owners. All unit owners shall compulsorily become members of the said cooperative society. The developer shall be deemed to be member of the cooperative society in respect of the units held by it or remaining unsold by it. So, your lordship, kindly see in the standard terms and conditions, my lord, it is clearly written that to become form a cooperative society is mandatory, compulsory. Then, my lord, 8.1.5, my lord, I'm not reading the entire thing, my lord.
What is the dispute now? What have we
Dispute
challenged
now,
here? Let's go back there.
I'll go back there.
Yeah.
My lord, my challenge is this, my lord, one of the flat owner. My lord, I told your lordship, some of the flat owners, they formed a coterie, my lord. They wanted to take over control and management of the society without becoming, forming the cooperative society. And they were not paying the maintenance charges also. They were also inducing others to not to make payment of the maintenance so that it becomes difficult for my client to maintain the property. In such a situation, what they have done, my lord, they surreptitiously, my lord, one of them, my lord, is the private respondent, my lord, made an application before the competent authority under the West Bengal Apartment Ownership Association. And my lord submitted the form 1, my lord, A, and got it approved. This is the subject matter of challenge. Respondent number 3 is the private respondent, my lord. An order was passed, my lord, by the private, by the competent authority, my lord, on 18th May 2022 on such application, my lord. Immediately upon coming to know of the same, my lord, we have challenged the same, my lord. That is also annexed, my lord. Show that order.
Page 162.
Yes. Page 162. With reference to the declaration in Form A submitted by Mr. Ranjan Kumar Mohanty with respect to property situated Sunny Fort VTC Action Area 2, North 24 Parganas, pin code 161 is she is hereby informed that in pursuance of subsection 2 of section 10A of the West Bengal Apartment Ownership Act 1972, read with Rule 3 of the West Bengal Apartment Ownership Rules 1974, the undersigned has examined the declaration submitted in Form A under this Act and found the property concerned comes within the purview of this Act and the declaration is in order. In view of the reasons stated herein above, it is ordered that the declaration submitted in Form A, my lord, I have filed a supplementary affidavit annexing the legible copy because it is not so legible.
Yes,
Form A submitted by him, her.
right.
The accepted Form A is returned herewith along with all enclosures for registration, and he is requested to collect the same from the office of the undersigned. The accepted Form A is required for registration under the Registration Act 1908 within 120 days of the date of return of form. Accepted Form A is an instrument compulsorily registrable within the meaning of Clause B of subsection 1, Section 17 of the Registration Act 1900 Act. Then, my lord, Section 12 has been quoted. Then he is further requested to take steps so that Form 1 is submitted before the undersigned accordance with Clause 2 of Bylaw 3 of the West Bengal Apartment Ownership Bylaws 2022 for issuance of certificate of registration under the Act in favor of the proposed association of apartment owners. Now, my lord, this order was.
If this association is registered, then you are precluded from registering your association.
Yes, then I cannot because members cannot become the two parallel society cannot run, my lord, at one place. And my lord, I can show you the base origin, all the deeds where from the NCCF has got the property from West Bengal Housing Development Infrastructure Limited. The first condition was that it should be a cooperative society. As an owner, my lord, as a developer, it makes no much difference to me whether it is a cooperative society or it is an owners association. However, my lord, it will amount to violation of the terms and conditions by which the property was granted to the NCCF. And then in turn, NCCF has given to me. And then secondly, my lord, this association, if this is being allowed to be formed today without clearing the past dues, my lord, the area dues, my lord, they will take over the management and then, my lord, they will not pay any of the dues, my lord. They knew this would be the basic hurdle, my lord. That is why they had gone to form the corporate apartment owners association, my lord. Now, my lord, I shall show. Kindly come to first the writ petition, first volume, my lord. Page 23, my lord, is the next P1, page 23 of the writ petition.
Yes.
So kindly see the first recital part, in fact, Lordship will find if I read. This is an agreement between National Cooperative Consumer Federation of India Limited with my client, my lord. Whereas National Cooperative Consumer Federation of India Limited is the apex federation of consumer cooperatives in India and has been registered on the Multi-State Cooperative Societies Act 2002 and functions under the administrative control of the Union Ministry of Consumer Affairs, Food and Public Distribution. In pursuance of an application made by the Federation to the West Bengal Housing Infrastructure Development Corporation Limited, the Federation has been allotted with all that the various pieces and parcels of land containing by estimation an area of 5 acres in Newtown, Kolkata, on the terms and conditions contained and recorded in an announcement letter dated 27 February 2006. Now, means this letter of allotment, my lord, clearly says it should be a cooperative society.
Where is that stated?
Yes. Just a minute.
In 3.1, it's mentioned that exclusively for the construction of residential housing complex for cooperating group housing societies.
Yes, cooperative
So
group
that's
housing.
also-
That is also the
one of
same
the
thing, my lord,
purposes.
group housing society.
Right.
And then I'm just showing, my lord, the after maintenance part also, the agreement has the provision. That I was. I just give you lordship, there is a specific clause also. This- But I shall give you lordship. In due course. Then, my lord, page 44 is the power of attorney, which has been given in favor of the director of the petitioner. NCCF. Then, my lord, this is the main document, page 49, whereby NCCF has got the property in its name by West Bengal Housing Infrastructure Development Corporation Limited. Kindly come to page 50, my lord. Part of the deed, my lord, whereby West Bengal Housing Development Corporation has given. And whereas the purchaser applied to the vendor for purchase of a piece and parcel of land in the New Town, Kolkata, so as to enable the purchaser to erect a building therein for residential housing complex for its cooperative societies after completing all formalities for allotment of such land by the vendor. That is the basic condition, my lord, that it was always for the cooperative society. Then the main body, your lordship will see, page 51. The purchaser hereby covenants with the vendor as follows. Paragraph 2, my lord, the purchaser shall use the said demised land exclusively for the purpose of constructing building for residential housing complex for its cooperative societies at the cost of the purchaser in conformity with the planning rules 2006 and planning area building operation regulation 2006. So, my lord, it has to be a cooperative society.
Page 71 also probably.
My lord, place 62, lord 64, lord will also find.
This is something else.
Therefore, this is something else, my lord, where we have purchased the right, it is for that. Now, my lord, kindly come to page 74.
Yes, 74, it's clearly mentioned.
It is meant to form a new cooperative housing society as per the norms of cooperation of the Department of Cooperative Societies, Government of West Bengal. And then, lordship, the main document with the purchasers, my lord. In tune with this, my lord, the standard terms and condition was approved by the NCCF. And these were the STC, my lord, which has been signed by all the parties, including the respondent number 3, my lord.
Which one?
The STC which I placed before Lordship, page 90.
Yes, STC.
STC,
STC, where is the provision regarding
clause 8,
8, right? Right. You
clause
said.
8, page 100, my lord.
Yes, yes.
Lordship, this clause 8 deals with the maintenance, and it clearly says, my lord, 8.2 also 8,
Yes,
8.1.5, 8.2, my lord. The developer and after formation of cooperative society may aid, alter, modify the same from time to time in the common interest. So everywhere, my lord, it was well within their knowledge, my lord, since the time of acquisition of the property, my lord, that it has to be a cooperative society, none other than that. With regard to the factual aspect, this is the thing, my lord. They have submitted so, and my lord, West Bengal Owners Apartment Ownership Act, my lord, they had applied. Immediately thereafter, when we came to know of this order, my lord, we have challenged the same by way of filing of the writ petition.
The question is how this affects you.
The question is, my lord, if if the cooperative society is not formed, my lord, it will be in violation of all the basic document, my lord, whereby the plot was allotted. Very purpose. And my lord, how their rights are being infringed, my lord, firstly, they have undertook, my lord, the parties, that they will form a cooperative society. They are duty bound to pay the maintenance charges and all other charges. In
Mr.
order,
Advocate, can you please show me from the act that only one association can be formed?
yes.
Just show me that also.
My lord, if we take the West Bengal Cooperative Housing
West Bengal
Society,
Apartment Ownership
okay,
Act.
yes,
In Apartment Ownership Act, there is no such bar.
No such bar.
In Cooperative Society Act, I am not aware of, I could not find, subject to my lord correction, I could not find any such provision that it divars another society. But
Yes.
subject to
my lord,
correction.
my lord, it requires no specific bar for the reason, simple thing, my lord.
Yes.
My lord, if I presume, but there cannot be, my lord, such a situation that for maintaining one property, my lord, there will be two bodies. It cannot be. Two parallel association cannot run and maintain a particular complex, my lord. It has to be one body. Either it is apartment ownership association, my lord, or it is a cooperative society or a welfare association, which is normally done.
You have agitated certain rights on the basis of all the documents.
All the documents.
By which you derive title, they
Yes.
derive title also,
Somehow
all these
I
documents.
find my book
Now,
is missing.
why isn't this, Ms. Agarwal, a cause of action for a civil suit? I
No,
mean,
my lord, I'm
can
not
you
sure.
debar the authority, competent authority from
Yes.
giving this registration?
Yes, my lord.
Could the
sorry.
competent authority even go into this?
Yes, my lord. My lord, may I just? I'm very sorry, my lord. My books were there. It is, I found it is missing apartment. Cooperative society to है, owners apartment. कोर्ट को देना होगा ना. My book is missing. And cooperative का ही है लेकिन.
ये है ना,
एक मिनट.
যেগুলো তো পাওয়া যায় সেগুলো হাতে নিয়ে আসছি। হ্যাঁ, এতে by list আছে, right, mark করে দেওয়া আছে।
My lord, I've got a guideline under the West Bengal Apartment Ownership Act 1972
Guidelines framed by whom?
by the competent authority under the West Bengal Apartment Ownership Act 1972, my lord.
Please give a copy to them also, Ms.
Yes, my lord, I'll give. I have it. I just read it and then give it to him, my lord.
Right.
Both of them. My lord, if Form A, it is felt necessary to frame a guideline regarding practice and procedure for filling up Form A and Form 1 for formation and registration of Association of Apartment Owners under the West Bengal Apartment Ownership Act 1972, so that anyone intends to form an association of apartment owners under the said act may find it helpful. First
Guidelines,
page,
my
now
lord,
it's,
has no statutory force perhaps.
I shall show the form because this is the basic thing. Documents and papers which are required to be submitted with Form A. My lord, how come my learned friend has got all these details? Page 3, kindly see, my lord. Page 3. Yes. So, page 3. Document containing all the owner's details, description of the limited common areas and facilities, if any, stating to which apartments there use reserved car parking, percentage of individual interest in the common areas and facilities of each apartment owners.
Mr. Honorable, please show me from the act. What
Yes.
is the provision regarding this formation of the association?
Yes, I'll show.
My lord, section 2, 10 and 10A. These three my lord, sections, my lord, the most important. Section 2, 10 and 10A.
And 10A has also been quoted here.
Yes, my
It
lord.
has been quoted. May I just read?
Well, I'll show from those sections.
Right.
Kindly come to section 2, my lord.
Please.
This act shall apply to every property having residential units or both residential and commercial units, and the sole owner or all the owners or majority of the owners of every such property shall submit the same within such period as may be prescribed to the provisions of this act by duly executing and registering a declaration setting out the particulars referred to in section 10. Then my lord, section 10 kindly come. The declaration referred to in section 2 shall be submitted in such form, accompanied by such fees and in such manner as may be prescribed. Name of the owner, nature of interest of the owner or owners in the property, existing encumbrance, if any, affecting the property, description of each apartment containing its location, actual built-up area, number of rooms, immediate common area to which it has access, and any other data necessary for its proper identification.
Question is whether they're the majority owners or not.
Yes, my lord, it is there.
Sole,
Yes, it
all
cannot.
owners or majority of?
Yes, it cannot be. I shall show my lord the form if it is called upon to be submitted. The property has 285 ownership flats. 285. And my learned friend, I do not know how many signatures he has put in or has obtained. In his affidavit in opposition, he has contended even one signature is sufficient. This is what has been stated in his affidavit in opposition. And my lord, kindly see 10A. A declaration or an instrument to be submitted before the competent authority and to be dealt with by him. Any declaration referred to in subsection 2 or any amendment thereto or any instrument referred to in subsection 3 of section 4 shall in the first instance be submitted by the sole owner or all the owners or the majority of the owners of the apartment in duplicate within 30 days from the date of its execution to the competent authority along with copies of site plans, building plans, and the notice of intention to submit the property to the provisions of this act by the majority of owners specified in section 2 to the remaining owners of the property in such form as may be prescribed when such declaration is made by majority of owners. The remaining owners shall be allowed to submit declaration subsequently either individually or collectively in such form as may be prescribed. On receipt of a declaration or an amendment thereto, or instrument referred to in subsection 1, the competent authority shall, after issuing notice to the parties concerned and after holding such inquiry, if any, as it may consider necessary for the purpose examine the declaration, the amendment or the instrument as the case may be to ascertain whether the property concerned comes within the purview of this act and the declaration, the amendment or the instrument is in order by an order in writing giving reasons therefore accept or reject the declaration, the amendment or the instrument, and in case of acceptance immediately return the declaration, amendment or instrument along with all the enclosures to the owner as the case may be for registration. Now, my lord, I pause here, my lord. Even if I assume that everything was given, though it could not have been, my lord, building plans, site plans, all access, they could not have of all the owners. My lord, it was incumbent upon the competent authority why the writ is maintainable. We have not been given any notice. Even the my lord, my client is in possession of several of the flats.
Ms. Agarwal, how far they are required to give you notice? One. Secondly, what is the scope of adjudication of this competent authority? Can they go into these questions even?
It is there, my lord. Kindly see subsection 2.
2 years.
2A.
Acha, after issuing notice this. Yes.
After issuing notices to the parties concerned and after holding such inquiry. So an inquiry is required to be done. Notice is required to be given. This order dated 18th May 2022 has been passed, my lord, behind the back of my client. No notice has been given. No inquiry has been conducted whether the property will come within the purview of the West Bengal Apartment Ownership Act or it will be a cooperative society. I could have argued this point before the competent authority, provided, my lord, a notice would have been given to me, my lord. Kindly see I2AI, the property concerned comes within the purview of this act. It does not, my lord, that automatically all the properties of the West Bengal, my lord, will come within the purview of this act.
Ms. Agarwal, the limited scope of inquiry after issuing that notice, inquiry is on these two scopes. Scores only.
These two,
Two.
10A2.
One is the property concerned, whether the property concerned comes within the purview of this act, that has nothing to do with your cooperative point.
Yes.
2 is the declaration, the amendment or the instrument is in order. Order means in terms of this act or the rules.
Act or
So
the
none of these gives you scope for agitating your point on cooperative society being a necessity. So
No, my
this
lord.
inquiry does not have anything
No, my
to
lord,
do
the
with your-
property concerned comes within the purview of this act. I come here, my lord.
Even if it is not a cooperative society, it comes within the purview of the act.
No, my lord.
Property comes within the purview of the act. Why do you say cooperative society is the requirement as per your documents, which you very well have a right to agitate that. There is no doubt on that. You have a civil right. But that you can you enforce under the garb of this? This inquiry does not contemplate
No,
such
my lord, my lord, the only thing is, my lord, I shall come back, my lord, if your lordship gives me. Because if, my lord, what is the role of this owners association will be? And what will be the role of the cooperative society? But kindly presuppose a situation, if the two bodies, my lord, a cooperative society is formed of all the owners and an owners association is registered under the West Bengal Apartment Owners Act 1972, my lord. Then, my lord, how they will function? Whether the two bodies will be allowed to function parallelly. My lord,
Suppose
both
they
are,
do not operate parallelly. There is only one association, their association. Why should the competent authority go into this question?
no, because the reason is the competent authority gives approval.
Yes.
A competent authority gives approval of an owners association.
File a civil suit that will be subject to the outcome of the
No, my lord, competent authority, my lord, is sanctioning now this Form A has been approved. They is giving the document that you get it registered under the Registration Act.
That is the illegality competent by the competent authority. Apart from you are saying that notice was not
Notice
given.
has
I'll
not
go
been
into that.
given. Yes.
But even if a notice is given, this inquiry this does not take it within its fold your the adjudication of your point. You are saying that it had to be a cooperative society. Yes, they are not
My
forming.
lord, I had
That is a
missed my
different-
brief. One of the brief, I'll come back tomorrow, my lord. I shall show that wherever there is a cooperative society, cooperative society, it is, my lord, then this act will not apply.
Well, in the meanwhile,
shall.
may I, my lord, counter her argument? Only
So,
to-
1 minute. So you say as per the Cooperative Societies Act, if there is a cooperative society, this act will not apply.
This act
Therefore,
will
the
not apply.
registration cannot be given at all.
It cannot be, my lord, because everything is to be governed by the cooperative society. There is a registrar. There is a total forum is separate, my lord.
Yes, register, obviously.
Registrar is there separately who will govern this. Registration will be done by the registrar of cooperative society. Membership, induction, transfer, everything is being done under the West Bengal Cooperative Societies Act 2006, my lord. So, my lord, one associate complex, my lord, cannot be governed by the two acts. One by the West Bengal, there cannot be a violation of one act, apartment ownership or cooperative society. It has to be one. When the parties have selected a forum of cooperative society, which is the main intent, at the time of entering into the agreement, my lord, they could not have applied to the competent authority for the purpose of forming an apartment owners association, my lord.
So that brings it within the fold of 10A to AI.
That he has to decide. But I shall give it, kindly keep it tomorrow only, my lord.
Tomorrow in reply, you cite the section.
Yes,
But I'll take that argument of yours. So 2 or 3 arguments. One is that As per all the documents, they have to do it. Cooperative society has to be found, one. Secondly, they are trying to bypass these, the dues and all, the payments.
Yes, and they have suppressed before the competent authority. I am not aware what application has been submitted by them. No copy of such application has been given to me to deal with the same.
And no notice is
No
itself a
notice
point
has
also.
been given. So
Very good.
moment without any notice, my lord, I am not in a position to deal with as to how many owners have put the signature. But so far as my knowledge is concerned, my lord, majority of the owners have not given so.
Good. Yes.
Yes, my lord. I am for the respondent number 3, my lord, and I am opposing his application. My lord, perhaps the answer to her query or query raised by my learned friend, why there was an provision for Cooperative Societies Act, then why this particular act is coming into picture so far as the actions of the private respondent is concerned. My lord, perhaps my lord, my answer lies in the dates, my lord. My lord, kindly appreciate when my lord, the deed that was executed between my lord NCCF and the my lord writ petitioner was executed. That was in the year 2006. Admittedly, the clauses my learned friend has just submitted, it is there. In fact, I was also going to refer to those
Between
clauses.
NCC and them.
And the writ petitioner. That was in the year, my lord, 2006.
Yes.
And my lord, when this dispute arises,
When?
soon after the my lord, the impugned action of the competent authority.
Yes.
2006 to 2022. So I'm asking myself, what action they have taken to my lord, to implement that no, this organization, this particular association belongs to cooperative society, and these are the steps that you have to carry out. And the reason being, my lord, they themselves did not rely upon that clause, and also from their own documents. They themselves did not rely upon that document. Not only that, they have later on, only to facilitate, my lord, the selling of the, my lord, the large number of flats, they have carried out a rectification deed. And by way of executing the rectification deed, that is the part of the writ petition, my lord, they have specifically included a clause by which, my lord, the sale was, my lord, the writ petition was empowered to cause sale in respect of, my lord, all the prospective buyers who comes from all walks of life.
So what is the difficulty in that?
All walks of life, this is very, my lord, material thing, because my lord, the Cooperative Society Act, my lord, knows that Cooperative Societies Act applies in a very limited manner. Only the eligible persons who are found to be, my lord, the member who are found to be eligible to become a member of the cooperative society, they alone can be, my lord, made a part of the cooperative society. And that is why, my lord, the Cooperative Societies Act 87 is paramount in this case. Kindly see, my lord, one, the section 87 of Cooperative Societies Act. What are the eligibility for membership of housing cooperative society? Because if they rely upon this clause, they could have no way sold the flats.
The rules.
All the flats, my lord, admittedly more than almost 300 flats are there.
Act, section 87.
In the building, my learned friend has just said there are total 285 flats, and all has been, my lord, sold out, either by way of execution of deed of conveyance or by way of sale agreement. And kindly see, my lord, what are the eligibility of cooperative societies? 87. Eligibility of membership of housing cooperative society. In addition to the requirements under section 63, an individual shall be eligible for membership of a housing cooperative society if he is a citizen of India, he is not a member of any other housing cooperative society of West Bengal, he or any member of his family does not own any plot or vastu land, house or flat within the local limits of any municipal corporation or municipality or town or any gram panchayat or any notified area authority where the housing cooperative society is situated other than the one in relation to which the membership of a housing cooperative society is applied for by him under this section. He is a permanent resident of West Bengal or intends to reside in West Bengal permanently within the period of 1 year from the date
You
of
say many of the purchases do not fall
no, nothing, no kind of, my lord, that fact finding, my lord, the exercise was carried out. From the very beginning, keeping in mind of the fact that is why, my lord, the rectification deed was incorporated for the purpose of selling the property in mass to any of the, my lord, the buyers who come forward, is ready with the money and they can buy the property. So they themselves, my lord, waive their right for the purpose of cooperative society. If at all that issue is, my lord, germane in this particular discussion. Admitting for the sake of argument, yes, that cooperative society would have, my lord, or rather should have
the
been.
page number of the rectification deed?
My lord, that is the page number, my lord. Yes, my lord. Kindly comes to read petition, volume 165, page number. It starts from my lord, page number 62. Nomenclature is deed of rectification. If my lord kindly comes to page number 65.
65.
Yes. Page 65 is that rectification.
Yes, my lord. Paragraph
Various
number
walks
3.
of life.
Yes. If, my lord, the all works, people from all works of life is incorporated, then in no way, my lord,
Yes.
in my lord, no way this the sections 87 could be applied. Because there is certain restriction by which my lord, only certain person is eligible to become a member of cooperative society.
But there was also that terms and conditions, special terms and
There also, my lord, there was special
but
terms
this has
and
to be read
conditions.
in that perspective. You can
Yes.
come from any walk of life, but you cannot own.
In the deed also, my lord, in the deed also, they have nowhere mentioned the.
So per se, there is no conflict between people from all walks of life and section 87.
Yes, ma'am.
You
There is
can come from any walk of life, and you may fall within the contemplation of
Then,
this.
then
also.
who carried out, my lord, who will vouch for that?
No,
This
but
thing,
in
my
your
lord?
STC, the document, the STC document,
STC, my lord, that was a special terms and conditions. That is
special
my-
terms and conditions is a part of the of your agreement also.
of your agreement. Thereafter, my lord, deed of conveyance was executed, and I have attached deed of conveyance also, my lord.
No, everything is subject to that. That was a STC binds you also.
Yeah,
So
but-
there it was specific that you have to form a cooperative society.
But kindly comes to my lord, say, my lord, deed of conveyance, my lord knows once the deed of conveyance is executed, the my lord, earlier document goes, my lord.
Deed of conveyance does not say anything about that.
Absolutely not, my lord. I have attached with my affidavit in opposition. I'll show from it, my lord, as well.
কোর্টে থাকো একটু এটা কি গো আচ্ছা which page of your opposition give me
Yes,
the page
yes, my lord. Opposition, my lord. Deed of conveyance, my lord. My lord, volume 1, my lord. It starts from page number 55 and relevant portion is page number 60.
60
Page number 60, 60, my lord, of volume 1 of my affidavit in opposition.
Lord, kindly see page 60, clause G.
Yes, I'll refer that only to
F
show,
and G.
that is for the purpose of mere, my lord, writing, and nowhere it has been mentioned further.
F and G.
That
Show me
is
that.
why
Show me-
I'll relying upon this only, my lord.
rely then clause
My lord, F.
F and G.
The cooperative housing society to be formed as envisaged herein. I will rely upon that part only, as envisaged herein. And thereafter, my lord, nowhere in any other, my lord, pages, lines, paragraphs, I could find what was the, my lord, the cooperative society meant for. That is the only bare, my lord,
other paragraphs
reference,
also.
my lord.
this was in terms of the special terms and conditions.
There also, my lord, only cooperative society, and that apart, my lord, special terms and
It was
conditions.
made clear that you have to form a cooperative society.
Society, and why I'm saying so, my lord, thereafter they also sent a, my lord, written letter when my lord, there was a mismanagement. Admittedly, there was a total mismanagement in the property, in the whole complex. So they
No, but
started.
you see E also page 60. Please come to the previous clause only. There's a clear mention that shall remain deposited such and such till the formation of cooperative housing society of which the purchaser shall become a member. On formation of the cooperative society, the developer shall make over to the everywhere. There's a mention of cooperative
F,
society.
G, S.
Yes, my lord.
Everywhere.
Yes, everywhere it is mentioned, my lord, but they have not.
Apart from F, in fact, everywhere else.
Yes, my lord. Apart from F, my lord, as far as envisage what terms is called, what I was highlighting, my lord, they have not mentioned how it is to be formed. And so far, my lord, they have not taken any steps. That is why, my lord, the flat owner decided to form an association by relying upon this West Bengal Apartment Ownership Act. And your lordship has just seen that only the majority, my lord, flat owners can apply for. So apart
How
from
can you do it without notice? How can the competent authority do
But
it?
as part of that, the competent authority can reply. Well, that access I do not have. They will serve the notice to them.
They can reply definitely, but the law says that they cannot. If no notice has been served to them, then
My lord, if the state shows, my lord, notice was given to them, they decided
then
not
it's a
to
different
appear.
aspect
Yes, my
altogether.
lord. But
Otherwise,
that-
it's
But
vitiated.
I am not privy to that information, my lord, because I applied and
Kindly, my lord,
perhaps the
and
company.
cross,
Please, Agarwal, you cannot disturb the
yes,
court.
sorry.
Yes.
We applied for the my lord registration, and the my lord competent authority expected to send the notice. I do not know, my lord, what occurred in that particular scenario, my lord. And that apart, my lord, why my lord, there is a my lord, the changing stand between the cooperative society and my lord, apartment ownership act. The developer also sent several letters, my lord, to all the flat owners. My lord, at the same time, my lord, I may, my lord, my lord, submit that the respondent, she is not the one, my lord, the alone representing all this case. Since I was one of the power of attorney holder, that is why, my lord, the writ petition has made me the party. The act says majority, so I was representing the majority, my lord, flat owners. So total 185 flat owners, and I represented 145 my lord, flat owners. So therefore, my lord, total 145 flat owners applied for this my lord, this registration under the West Bengal Apartment Ownership Act, and that form I have, my lord, has made a part of this my affidavit in opposition to show that 145.
What
my
is
lord,
your capacity? You,
I acted on behalf of all of them, my lord, because 145, my lord, the
if you acted in representative capacity in the impugned act, then why couldn't you be imputed in representative capacity here?
yes, my lord.
Because you
Yes,
submitted the
but
form in
yes,
representative.
that is why, my lord, I've just
So you
submitted.
cannot change.
No, that is what I'm saying.
capacities.
I am representing all of them, my lord. My learned fan may say the one person he was submitting. So in that respect, keeping that submission in mind, I
No, the
just
question is whether you are majority or not.
I have in majority. I have, my lord, the whole application I have attached with my affidavit in opposition to show I was in majority.
So one aspect you say this cooperative part was not an integral part of the sale deed.
Sale deed.
But that probably there are some doubts anyway.
My lord,
Apart from that also you say that no, they cannot. I mean, if you are the majority, you can always go and apply.
yes, my lord. And now, my lord, to remove, my lord, the doubts, my lord, arising in the mind of this honorable court, kindly comes to page number 152 and 155 of my affidavit in opposition. Because they took a standing, my lord, shifting stand. So far as formation is concerned, and that is why, my lord, till this date they did not
Yes,
take.
that is the other question you pose, that what were they doing for so long?
Well, they did not take any action.
And
Only
that's-
to, my lord, it is our allegation.
They will say that is due to your dilly-dally.
My lord, they could not show.
Obviously,
perhaps.
they will allegations and counter.
Yes,
Yes, page 152 what?
152 and 155, I have attached only two letters, my lord, addressed by the writ petitioner to few of the, my lord, the flat owners. If, my lord, kindly comes to page number 153, paragraph number 7. You will be required to become a member of the Apartment Owner Association or such other organization to be formed at our side, at our sole discretion of Sunnyport project. For this purpose, you would need to fulfill the formalities as and when advised by us.
Yes.
You are required to become a member of the Apartment Owners Association. So they did not have a very firm stand from the very beginning whether the Cooperative Societies Act, keeping in mind of the fact that all the flat owners are not eligible to become members of the society. So even if, suppose we all give our consent to form a society, then also, the act comes in the way. Then, an exercise is to be carried out whether they would be eligible to become a member or not. And in my most respectful submission, what I have the instruction, most of the members are not. They may have multiple flats. They may not, come originally from West Bengal. They may not be, the citizens of India. They may be, foreign passport holder. There are many ifs and buts are there. So in any practical situation, forming a cooperative society under West Bengal Cooperative Societies Act no more possible, even under the eye of law. And secondly, under the facts also, they were not serious, and that is why, we are constrained to apply for the forming the association under West Bengal Apartment Ownership, because that was the most easiest, way to form an association, because we are the flat owners, and perhaps we have got the right after purchasing the property to manage our own property at our own cost. They are not going to get deprived, except, some, the emotional, submission, I should say. There would be breach
What
of
emotional? Money.
that
Emotional here.
yes, my lord.
Nothing
And all the
Both sides.
yeah, I have given the series of, letters showing the complaints addressed to the developer, how the property is not being is not managed properly. There has been some areas, but then also, he has got the reserve account, a sinking fund, lots of crores of rupees are lying therein. The developer never bothered to utilize this, only to extract money from us
Yes.
But kindly have a look.
Oh, a big rodent.
That's a resident here.
Even that.
When
what
I
is
get
that?
bored with the arguments, I look at his or her movements. Yes.
Yes. So, my series of my complaints were
But
there.
that is very sensitive to bad arguments. Beware of that.
My lord, perhaps he is not yet.
No, he has not yet come.
My
So it's
lord.
all right.
Well, I'm so grateful. So, my lord, the series of my lord complaints are there, which my lord shows that the developer was miserably failed to manage the property, and now only it is a financial, my lord, the part wherein my lord they are trying to extract from the flat owners for the purpose of on the garb of my lord managing the property.
Right.
And thirdly, my lord, the impugned action is the actions of the competent authority. And if my lord it is indeed found, I would be must be candid in this submission. If they indeed it is found that no notice was served, then perhaps it requires another hearing.
Only that.
Only that.
But
Apart
on
from that,
jurisdiction,
no,
jurisdiction.
absolutely not. My lord has seen under section 2. Any property, I am a property owner, and as far as the owner definition is concerned, even the person holding a sale agreement, because I was searching for it, because many of the my lord the applicants were not holding a sale deed as well. After the sale deed, there is a bit deadlock. That is why, my lord, the cases as submitted by my learned friend, the cases has been pending before the Consumer Forum, thereafter State Commission, thereafter National Commission. So few of the my lord, applicants were sale agreement holder as well, but that is also not that will not also stand in the way, because the owner includes the person having the sale agreement. So if any person,
Let us come to the definition of owner once.
Yes, my lord. একটা দিলেন না আমাকে? Yes. In the proviso, it is mentioned, my lord, provided.
Right.
Provided that any person who has executed an agreement for purchase.
Or lease even.
Or lease, yeah. So, my lord, it is wide ambit.
And a lessee is also.
Lessee is also in
for 30 years.
whenever a person shows, if it is a sole owner or sole leaseholder, or my lord, the sole, I should say, coming within the definition
Owner
of
or deemed owner.
Yes, deemed owner can apply, or if there are multiple, then all or majority. So it is nobody's case, my lord, that we are not the main majority. We are in the majority.
No, it's their case, you are not majority, but that's
I have attached, my lord, the form A,
Different
my lord.
aspect.
145. If my lord kindly sees once, then I have attached that form A itself.
You are 145.
145. But
Total is?
Total is 280, 285 perhaps. And thereafter, my lord, if the provision is there, I can take into my class several other flat owners. I am told another 100 flat owners are ready to get involved in this association. But anyway, that is not the part of this writ petition. But as far as the majority part is concerned, my lord, there is absolutely no semblance of doubt.
Good.
My lord, I have attached my form A to show the my lord, list of applicants, my lord.
Give me the page number.
My lord. $229, my lord.
229.
229.
Of?
229 of my affidavit in opposition, volume 2. Two 229 to 230. Total 144, my lord. Names, details, everything is there, my lord. So as far as the question of majority is concerned, there is absolutely no doubt. And keeping that thing in mind only, I have attached this form A application.
Right.
So, my lord, I have only twofold argument, my lord. First,
144 here.
Is 144, subject
Right,
to correction. Perhaps maybe keeping in mind of respondent.
Anyway, that is also majority. If it's
Yeah,
285
yes,
total, right?
Way ahead, my lord.
Not way ahead. 288 is your double.
But in subsequent, my lord, development.
Barely.
At that point of time, barely, but I am told now another 100 of my lord, the flat owners are with us. So, my lord, a twofold argument that the impugned action, my lord, the writ petition has failed to, my lord, challenge under which provision this action is banned under eye of law. And secondly, even if we give consent to this thing, formation of cooperative society is no more possible under the eye of law.
Right. Yes. State. Sir, you are for the competent authority also, I suppose. Yes. Right.
Before I start, I must be candid before your lordship, my lord. I tried to get instructions, but I could not. My junior tried, my lord. I have been after him to get instructions, but he couldn't get any instructions. So I will make submissions on whatever is there on record. I don't want to drag the matter. My lord, first, your lordship will, my lord, first two parts of the matter. One is the factual part, one is the legal part. I'll come to the factual part first. But what I found from the documents on record, what has actually been done, Malad, is that the property was handed over for a particular purpose. This has been diluted and it has been converted into a commercial project. So both parties are guilty insofar as this is concerned. If your lordship kindly have a look at the original deed, which of course my learned senior friend has already placed. But if your lordship sees page 24 once again, the purpose for giving this 5 acres of land at a reduced price was for members of the corporation to have a housing society. Now, Malad, it is mentioned here that the allotment letter dated 27 February 2006 is a part and parcel of that deed. But Malad, unfortunately, I have not been able to find this letter of allotment. Subject to correction by my learned senior friend, Malad, if it is on record, she will show it before your lordship. Because the intention that I find from here was that it is to be given to only the members of the cooperative. Now, Malad, subsequently, there is a rectification. And by that rectification, Malad, apart from the
All walks of life.
all walks of
As
life,
he pointed out.
apart from the members of the confederation, that has been brought into it. Now, Malad, the third aspect of the matter is that again I find, Malad, from the agreement which has been entered into by the purchaser with the petitioner, but it is possibly unregistered. Subject to correction from this document, I do not find
That
it's a-
STC.
No, STC is
Agreement.
a part of the contract,
Contract, yes.
which they have created. It doesn't appear to have any statutory force
No.
or any other legal force. All I'm saying is that this property, Malad, was given to the National Cooperative Consumers Federation of India for building a housing society for their members. Subsequently rectified to the effect that apart from the members, other people from all walks of life can also come in. Very well. But the third aspect of the matter is that now the purchaser, after becoming the owner, this National Cooperative Consumers Federation of India Limited has practically sold this project to the petitioner under an agreement which is unregistered. And the power of attorney is also unregistered. Kindly see at page 44. It's a notarized power of attorney and agreement. No. Malad, kindly take the agreement at page 71. First volume. Now, in this supplementary agreement, your lordship will find, Malad, it's between the National Cooperative Consumers Federation and the Sunny Rock Estates. I do not find that this is a registered document. Now, here, Malad, if your lordship takes page 73, paragraph 11.1.
Yes.
It has been agreed by and between the parties hereto that in consideration of the developer having agreed to incur all costs, charges, levies, outgoings and expenses for promoting the said housing project, the federation through the developer shall and transfer the sellable area in the said project to any intending buyer upon his agreeing the price on account of sale of the flat and or unit at the declared rate. And further that the developer shall be eligible to receive, realize, collect all rents, profits, everything. So effectively, by way of an unregistered agreement, the entire project has been sold off.
Sorry to interrupt, an incorrect fact will go to your lordship. It is a registered agreement. My friend is looking at the notarial certificate.
Yes.
That was kindly see page 87. Page 87, it is registered with the DSR 2 Note 24 Paragana.
Very well, may have been registered.
It is a registered
But what has
document.
been done is, Malad, from the original purpose, even I do not know whether the power of attorney is registered. Page 44 also, I'll draw your lordship's attention.
It is not relevant now because
No, it is relevant because you have sold all the flats based on that, on that power of attorney. No, then you produce. But kindly see, this is a fit case which should be relegated to the civil court to decide the rights of the parties. But a plot of land was given for a particular purpose for a housing society to make a project for its members.
then it is diluted, sold off to a private party, and now the private party says that I will control everything by forming a perp. This is the factual aspect of the matter. Whether at all in such scenario of factual disputes, your lordship will enter into this dispute at this stage. That's why, my lord, first submission. Now, my lord, so far as the order of the competent authority is concerned, my lord, your lordship has seen the order at page 162. I am not troubling your lordship with the order. It is very simple. It says that the law has been complied with, and therefore it is to go for registration. If your lordship kindly takes, my lord, the act, my lord, what is he to see? Kindly see. My lord, at the cost of repetition, kindly, my lord, permit me to place section 2 once more of the West Bengal Apartment Ownership Act 1972. Your lordship has found it, my lord?
Yes, please.
Yes. Application of this act, section 2.
Right.
This act shall apply to every property having residential units or both residential and commercial units, and the sole owner or all the owners or majority of the owners for every such property shall submit the same within such period as may be prescribed to the provisions of this act by duly executing and registering a declaration setting out in particulars referred to in section 10. So, Malad, every property having residential unit or both residential and commercial units will come within the purview of the act. Then, Malad, your lordship will kindly take 10. 10 is what is the contents of the declaration. 10A, your lordship has already seen. But I will only clarify. Kindly, Malad, read 10A subsection 2 with me once, Malad.
Yes.
On a receipt of a declaration or an amendment thereto or an instrument referred to in subsection 1, the competent authority shall, after issuing a notice to the parties concerned and after holding such inquiry, Malad, kindly mark this, if any, as it may consider necessary for the purpose. So it's not as a matter of course that notice has to be given. Secondly, Malad, the notice is to whom? The persons concerned. The persons concerned are the persons who have applied. It doesn't envisage that anybody and everybody connected with that project has to be given notice. Malad, your lordship remembers, Malad, there was an amendment to this act. Originally, it was the sole owner or all the owners.
You argued that matter.
Yes. And why this amendment came in? Because it was found that somebody or the other is blocking this system and associations cannot be formed. That's the reason why the amendment came, that majority of the owners. So that they could submit to the jurisdiction despite other owners not wanting to do so. And that is why, Malad, these amendments have come into the act as also the rules. So, Malad, today there is no scope in this section that all owners of the flat have to be given notice. Malad, then that entire amendment goes. The very purpose is frustrated. So therefore, Malad, while considering the order of the competent authority, your lordship will consider whether he has followed the mandate of the law or not. That's all. And Malad, in my respectful submission, once section 10 and section 10A ingredients are complied with, he in fact has no option but to allow. He has no right saying that, no, I will not allow. If he does not allow, he has to give reasons why he does not allow. And Malad, kindly see the one answer, Malad, nobody has addressed this because your lordship, it fell from your lordship whether, Malad, there can be one association or many associations. Yes. What is the law, Malad? Kindly take the bylaws. There, Malad, it has been clearly mentioned. The West Bengal Apartment Ownership Bylaws 1974. Malad, kindly have a look at 3. Formation of the association.
Yes.
Malad, there shall be in respect of each property an association, and each apartment owner of such property shall be a member of such.
This was also placed by you on the last one.
Yes. And Malad, if your lordship sees 4 also, what are the powers and functions? Everything is there. The mechanism by which, Malad, this is to continue.
Thank you very much.
So, Malad, this is my submission so far as the action of the competent authority is concerned.
I would quote another section for the bar of cooperative society.
You have finished your arguments.
Only the rule, the rule, cooperative society rules, one.
All right, yes.
131, subrule 3, clause 8. There also, the eligibility criteria of members are mentioned.
This is
West Bengal Cooperative Society rules.
Cooperative.
Yes, cooperative society. I have just referred to section 87 of the Cooperative Society Act. And reading which cooperative,
Which rule?
West Bengal Cooperative
Which
Society,
rule? Which particular?
131, madam. Membership, dealing with membership. Membership of cooperative society.
Yes.
131, sub-rule 3, clause A. For the transfer of land or house or apartment, a member shall obtain a written consent of the society, and before giving such consent, the society shall satisfy itself. Thereafter, the eligibility criteria has been.
Is why are you placing this?
West Bengal Cooperative,
Why are you placing this?
because my lord, the
Shall obtain a written consent of the society, and before giving such consent, society shall satisfy such and such.
this eligibility criteria has to be there. Even if my lord, the
But
cooperative society is formed, my lord, then also my lord, it cannot be fulfilled. The requirements of law under cooperative society act and rules, that cannot be met anymore. At the time of selling, this eligibility criteria was not, my lord, given reliance at the time of selling.
Yes, you want to give a reply tomorrow?
Tomorrow I'll give.
Hard in part for further hearing tomorrow. এটা একটুখানি এর মধ্যে স্টেপলার আছে ওখানে? ঠিক আছে, আমি এটা অর্ডার হইলে এটা পরের দিন একটু খেয়াল করি। বইগুলো ফেরত হবে বোধ হয়, ওরা বই দিয়েছে আমাদের একটা বাদ দিয়ে, এটা ওদের রুলসটা বোধ শুধু আমাদের। আরেকটা বই ওদের আছে, এটা ওদের না বইটা।
I am further petitioner, my. Affidavits are complete, my lord, copies served upon them. Well, it's very short case actually, basically, my lord.
Right.
My lord, in the year 2021, my lord, I came before this Honorable High Court on the ground that the authority exceeding their jurisdiction and the authorities acting beyond the law, which they are not actually authorized, even specifically actually restrained from acting in doing so, my lord. So, my lord, so at that time, His Lordship, Honorable Justice Manta, my lord, passed this order, my lord, which is annexed in affidavit of reply, my lord. My lord, affidavit in reply, I have particularly concised everything, my lord. This is at page 11 of that, my lord, as a petition. It was heard continuously, heard, and ultimately His Lordship passed this order at page 11, my lord. So in that order, my lord, particularly His Lordship, actually there were many grounds raised in the writ petition at that time. Even doctrine of the double jeopardy and XYZ, all things were raised. But were certain things which His Lordship specifically quoted in this order. So at least that thing should be, my lord, abided by them. Though His Lordship has given me a liberty in this order that the allegations raised in the writ petition should be considered by the department. But His Lordship had particularly recorded that thing. That is, my lord, that the authorities cannot directly jump to the section 206 subsection 4 of the Companies Act without, my lord, following the 206 subsection 3 and 4. That actually, that your lordship, I will read it again for your lordship, my lord.
Right.
So secondly, His Lordship, my lord, also held that as per section 128 subsection 5, which is recorded in the order, that the authorities are not authorized to ask for any documents beyond 8 years, my lord. So that is also specifically stated, my lord. And third thing, His Lordship also specifically quoted that they must respond to my representation dated this, which is recorded in the order. And in addition to that, His Lordship also recorded that this writ petition to be treated as my representation and they should respond it within 2 months, my lord. So this time was also there in that order to adjudicate the issue within 2 months. So this time, actually, His Lordship has relegated the matter back to that.
No, His Lordship had recorded your submissions.
This is my submission.
There also, he submits that the proceedings under such and such.
Yes,
but those were not made a part of the directions.
No, it was not made at last.
You are saying Justice Mantha.
No, it was made a part of that election at the last paragraph of page number 12, your lordship.
Yes.
Page number 12. This court is of the view that the respondent must take a suitable decision on either of the representation dated this, my lord, which is also annexed with the affidavit of reply, and the petitioner argument as contained in the writ application in course of the adjudication passing of the final order, my lord. So they were directed to pass the final order within 2 months, my lord. So these submissions out of my entire writ petition, this particular 2-3 submissions were recorded by his lordship, which they should not forget, my lord, which they should not forget.
So they can also forget. Under the law, there is nothing to compel them to remember.
No, but as per
Your submissions were recorded, but Justice Mantha ultimately directed that they will have to decide the representation.
Yes, my
And not only that, his lordship had not entered into the merits of the notice.
Yes, that is his lordship.
So therefore, these are new arguments. You can make those arguments before me.
Yes, your lordship.
But that was not the direction of Justice Mantha.
No, it was not direction, but I have actually, it's my humble view that they should consider this. When it was recorded in the argument, they should have considered this.
If they should have, then they'll suffer now.
My lord.
If I accept your grounds.
So, my lord, what happened, your lordship? Thereafter, my lord, they remained silent for 6 months, my lord. They have not passed any order on adjudication. They have not communicated anything, even in their this opposition. They have not annexed with that. Even so, thereafter, my lord, this matter was heard by your lordship on 30 June.
No, they did not pass a decision on the representation.
No, nothing was passed. Even they made a mischievous submission before your lordship on 30 June 2023.
Yes.
It is my lord's order, which is specifically recorded. Their submission is specifically recorded in my lord's order. This is the my lord's order dated 30 June 2023. So without passing any order, after 6 months, they directly issued me a notice of winded up under section 272, subsection 3. So when this matter, so I filed a writ petition. Writ petition came up before your lordship. After filing of the writ petition, 6 months after filing of the writ petition, they moved to the NCLT. So unfortunately, this petition has not came up for hearing for 6 months, my lord. But before your lordship, they have particularly submitted that this order of the Honorable High Court has been specifically complied with. This is recorded in your lordship's order. And secondly, they have stated that this writ petition has been filed to stall the proceeding before the NCLT. This petition was filed 6 months before. So after going into that, I issued them the email, my lord. This is the last page of my lord affidavit in reply. So I have issued them the email, my lord, page 20 of my affidavit in reply, that the why an application for perjury shall not be filed before your lordship for making this false submission. So on that day, I myself was shocked that my client might have not told me the truth thing. Actually, before the authorities are expected to make the very true submissions, my lord.
Please show me those findings in my order, 30th June.
My lord, this is the page 2 of your lordship's order.
Yes, yes.
Well, at paragraph number 2, my lord. So it is a learned counsel appearing for the respondent authorities controverts such submissions and submits that the order of the coordinate bench was complied with duly by taking a decisions in terms of the same. Where is that decision? Even they have not annexed with the opposition also. So thereafter, I wrote them the mail. I'm going to initiate perjury. But in spite of that, they have not annexed that. So secondly, they said that for such purpose, a show cause notice was initially issued under the section 272(3) of the said act, and after getting to say, it is further argued that the said winding up petition is at present subjudiced before the National Complaint Act. It is should to be argued that the petitioner is not trying to stall such proceedings. So I'm not trying. He admitting that he has filed the petition after 6 months. It is admitted in their opposition. It is not a disputed fact.
No, their application, their motion before the NCLT was subsequent to your writ petition.
It is admitted in their affidavit of this opposition at page 5 of their affidavit in opposition. It is almost 6 months after filing of this writ petition, my lord. Not that I have not filed anything to stall anything, my lord. So in spite of that, your lordship, now, my lord, the kindly come to the section 206. This of the Companies Act, my lord. Now I'm placing before your lordship.
Give me half a minute.
My lord.
Which page?
My lord, section 206.
Oh, section 206.
Section 206 of the completion, my page 260, my lord. Subsection 3 and subsection 4, my lord, I will read section 20.
Yes.
Subsection 3, my lord. If no information or explanation is furnished to the registrar within a time specified under subsection 1, or if the registrar on an examination of the.
We'll proceed tomorrow. We'll proceed tomorrow.
Well, kindly keep it on Friday, your lordship. I'm going outstation for 2 days, my lord. My lord.
At the commencement of the comments, although the hearing was commenced, the same could not be proceeded with substantially since due to paucity of time, full stop. Let the matter be placed in the list for hearing on September 8, 2023.
Well, I'm grateful. I'm grateful.
Grateful. Affidavit in reply filed today be kept on record.
My lord, grateful.
Thanks.
Yes.